Good morning. It's 9 a.m. On October 23rd, and this is the business agenda of the Colorado Energy and Carbon Management Commission. We will start with the roll call.
Thank you, Commissioner Ackerman,
Here.
Commissioner Kraus,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Ogletree, Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
Very good. That's quorum. Good to see everybody. We start with commissioner comments. If any commissioner has comments for the rest of us or for our stakeholders, love to hear from you. Seeing none, move to consent agenda. Does anyone have questions on consent? Seeing none, do we have a motion to approve consent?
So moved.
Second. Motion and a second. Any further discussion? Seeing none, all those in favor signify by saying aye. Aye. All right. We've got a couple of 1, 2, 3, 4 OGDPs on the agenda. Those are oil and gas development plans. The first is docket 2405-00111. Oil and gas applicant Fundair Resources Operating Company. And I believe we start with, and it's called the Wild Horse 4-7 OGDP. And I believe we're going to start by hearing from someone from Weld County.
Good morning, commissioners. Thank you, Chair Robbins. How are you all today?
Good morning.
Morning. As you all know, my name is Jason Maxey. I'm the director for the Weld County Oil and Gas Energy Department, and we always appreciate the quick opportunity to speak to you for a few minutes regarding our WOGLA process and the OGDP in front of you, which for this first one on your docket, as you mentioned, Chair, is the Fundair Resources Wild Horse 4-7 OGDP. On May 10th of 2023, we held our usual pre-application meeting for both the Wild Horse 4 and the Wild Horse 7 locations, which make up this OGDP in front of you today. So 2 locations that we held a pre-app for that we ran together. Attendees at that pre-app meeting in May of 2023 included Fundair staff, one of their consultants, actually a couple of their consultants, one Miracle Energy Consulting, and then also Jost Energy Law representation. They had RPG Resources on the line as well. We had our usual group of Weld County staff to help assist with any questions and running the meeting. You all had ECMC representation on the line. CPW was on the line, and actually U.S. Forest Service was on the line also. The 2 1041 WOGLA applications that we received were received on March 1st of 2023. And through that application process, you all know that we send out letters of notification of our pending hearing. We send out referral responses. We did not receive any public comments. We did not receive any intervention requests to participate in our hearing. And we did not receive any negative referral responses back on these applications. We held our hearing on June 20th of 2024, so just a few months back, and our oil and gas hearing officer considered testimony at the hearing and subsequently approved both of the applications. Throughout that process, I also want to mention that no referral parties participated in our hearing as well, which we fully allow anybody who is a referral entity to participate, and we had no participation. The final orders that the hearing officer issued were recorded with our Weld County Clerk and Recorder, and as per our process, they were officially and legally noticed in the Greeley Tribune on July 19th of 2024. We submitted our standard 2A comments for each location that is in Weld County. We always do our best to submit comments to you all, and we did the same for these 2 locations. They are included in the director's recommendation that you all have. We have received the director's recommendation and we've read it, and we agree with and support approval of this permit, or of these permits. So with that being said, I appreciate your time. And if you have any questions about the Weld County process, I'm always happy to answer those.
Questions for Mr. Maxey? All right. I'm not seeing questions at this point in time. We'll keep you on target and know how to get back to you if we need to.
Thank you, sir.
right, Ms. Wazelinski,
Good morning.
do you have witnesses to be sworn in?
We do. Thank you. If everyone could please turn their cameras on. We've got our whole panel here ready to be sworn in.
Attorney General Davenport.
Thank you, Mr. Chair. I'd ask each of the witnesses, I'll call your names in turn, to raise your hands, state your name, and say that you swear to tell the truth. I will start with Ms. Smith.
My name is Sydney Smith, and I swear to tell the truth.
Thank you, Mr. Gleaton.
My name is Craig Gleaton, and I swear to tell the truth.
Thank you, Mr. Schultz. Mr. Schultz.
My name is Joe Schultz, and I swear to tell the truth.
Thank you, Mr. Stone.
My name is Teal Slade, and I swear to tell the truth.
Thank you, Ms. Pfister.
My name is Miracle Pfister, and I swear to tell the truth.
Thank you, Mr. Melvin.
Grant Melvin, I swear to tell the truth.
And Mr. Brown.
I'm Brown, I swear to tell the truth.
Thank you. Did I miss anyone, Ms. Waslinki?
No, thank you.
Thank you.
Very good. The panel is yours.
Wonderful. Thank you, Chair. We have a PowerPoint. We'll get that pulled up and then I will get started. Give us just a minute to get this up. Here we go. Looks like we'll just need that in slideshow mode, and there's some Miracle. It looks like we're seeing the second slide. This is always tricky to get this into the right mode, so thanks for your patience. Miracle,
Sure why.
Yes, do slideshow from that.
Yeah, and that's what I did, and it keeps going to this. Sorry about this.
Share your screen when it's all ready.
Is it shared?
Yeah, we still see the two slides in a gray box.
One second, sorry. Let me see if moving it to my other. Can you still see it?
The gray box is gone. There we go. Perfect. Okay. Wonderful. Well, good morning, commissioners. My name is Kelsey Wazelinski with Jost Energy Law, and with Jamie Jost, we represent Fundair Resources Operating Company, LLC, in the Wild Horse 47 OGDP before you today in docket 2405-00111. We would like to thank Weld County for its support and participation in the WOGLA process for the Wild Horse 47 OGDP, and also ECMC staff and the director for their efforts on this OGDP. Next slide. This OGDP requests that the Commission establish an approximate 3,252.27 acre OGDP for the development of 26 new horizontal wells in the Niobrara, Fort Hays, Codell, and Carlisle formations. The OGDP requests that the Commission approve two new Form 2As, one for the amended expanded Wild Horse 4 pad for the development of 12 new horizontal wells, and one for the new Wild Horse 7 pad for the development of 14 new horizontal wells. The OGDP also contains 4 spacing requests: to amend two 640-acre DSUs for sections 4 and 5, to establish a new 1280-acre DSU for sections 6 and 7, and to establish a new 640-acre DSU for section 18. As stated by Mr. Maxey, the proposed locations are in Weld County, and the 1041 WOGLA permits were approved in June of 2024. Both locations are more than 1 mile from all RBUs, high occupancy building units, schools, childcare centers, and DIC boundaries. There are no Rule 304(b)(2) ALA criteria associated with the new Wild Horse 7 location, and 1 ALA criteria for the amended expanded Wild Horse 4 pad, which is in the Mule Deer Severe Winter Range and Mule Deer Winter Concentration Area HPH. Fundair will discuss its alternative location analysis and CPW consultation in the presentation today. As part of the Wild Horse 4.7 OGDP, Fundair has committed to several BMPs to avoid, minimize, and mitigate potential adverse impacts, which Fundair will also describe today. And finally, Fundair has complied with all notice requirements for the Wild Horse 4.7 OGDP. No formal petitions were filed and no public comments were received on the Form 2As. So I'll go ahead and turn it over to Sydney Smith with Fundair to continue the presentation.
Thank you, Kelsey. My name is Sydney Smith, and I'm the Director of VHS&R for Fundair. We're excited to present the Wild Horse 4-7 OGDP to you today. This slide shows the topics that I will address in the presentation today. Next slide. Fundair appreciates your time in allowing us the opportunity to present this application. Since this is the first OGDP that Fundair has presented to this commission, I'd like to take a moment to introduce our company and our team. Fundair Resources Company is an exploration and production company headquartered in Denver, Colorado, focused on developing oil and gas reserves across the Rocky Mountain region. Fundair was founded by the experienced management team behind the successful Fifth Creek Energy Company and the 4 Bonanza Creek companies. Our management team has operated oil and gas assets for nearly 2 decades. Our president, Mr. Truitt, was the vice president of engineering at Fifth Creek Energy and oversaw the successful delineation of the Hereford field. And after the Fifth Creek merger with Bill Barrett, Mr. Truitt went to Curitin Midstream as the chief commercial officer and led the commercial activities for the company. Our VP of operations, who is also on the line today, previously was with Bonanza Creek, where he oversaw the DJ Basin asset, and then went on to be the drilling manager for Fifth Creek Energy, preceding its merger with Bill Barrett Corp. Scott Landreth is our CFO, who was also previously with Bonanza Creek as our Senior Director of Finance. Daniel Seaver is our VP of Midstream and Marketing. Prior to his role at Fundair, he worked for Curitin Midstream and Bill Barrett here in Denver. Craig Gleaton is also on the line today, and he's our General Counsel and Vice President of Land. Previously, Mr. Gleaton was a partner at Davis, Graham & Stubbs, a Denver-based law firm. And as I mentioned earlier, I'm Sydney Smith, and I'm the Director of VHS&R for Fundair Resources. I've worked in various regulatory and environmental roles for over 10 years across the DJ Basin. I was also previously at Fifth Creek Energy, where I was a regulatory manager prior to the merger, and then went on to Clear Creek Resource Partners. Our team has worked together in many fashions over the last 15 years, and our commitment to environmental, social, and governance is a core value. And we are committed to the responsible development of oil and natural gas resources in every aspect of our daily operations. We strive to be valued members and have a positive impact in the communities in which we live and work, and we are doing our part to minimize the impact of our operations. We value the health, safety, and well-being of our employees and contractors in the area in which we operate. Our current assets include 319 operated wells in Northeast Wattenberg of the DJ Basin, which was acquired from Whiting Petroleum in September of 2021. Also acquired from Whiting Petroleum in September of 2021 was the midstream gathering system, which consists of gas gathering and crude gathering system that gathers and processes approximately 10 BCF of gas a year and 1.5 MM barrels of crude a year. In addition, we acquired the Green River Basin asset in July 2022, which consists of 191 operated wells, primarily on BOM surface. We have a team of subject matter experts on the panel today, and we welcome any questions you have following our presentation. Next slide. So this slide provides an overview of the amended expanded Wild Horse 04 location, which has been constructed and currently has 1 producing well on the location. Fundair is requesting to amend and expand this location to accommodate 12 new horizontal wells. We have an executed SUA with the landowner, and the 1041 WOGA permit was approved in June. This location does trigger 1 ALA criteria for mule deer habitat. Later on in the presentation, I will describe the extensive BMPs in consultation with CPW to protect this habitat. This location is more than 1 mile from all sensitive receptors, including RBUs, and is over 1 mile from the nearest DIC boundary. Next slide. This slide provides an overview of the new Wild Horse 07 location. We cited this proposed location to avoid the Pawnee National Grasslands to the south and to avoid all ALA criteria. We also have an executed SUA with the landowner, and the 1041 WOGA permit was approved in June. This location is more than 1 mile from all sensitive receptors, including RBUs, and is over 1 mile from the nearest DIC boundary. Next slide. This slide shows a timeline of this OGDP. So notably, we began the pre-application consultation process with Weld County 1 year prior to filing, and we had an on-site consultation with CPW and Weld County in August of 2023. No public comments were submitted on the Form 2As and no petitions were filed. Next slide. This OGDP contains 2 spacing applications, which are summarized on this slide and supported by land regulatory, geology, and engineering testimony. Fundair proposes to develop the Wild Horse 4 pad in 2 amended 640-acre DSUs established for sections 4 and 5, and to develop the Wild Horse 07 pad in a new 1,319-acre DSU for sections 6 and 7, and a new 653-acre DSU in section 18. There are federal minerals in sections 4 and 18, and Fundair has an approved communitization agreement with the BLM for its development of section 4, and the minerals in section 18 are 100% federal and leased to Fundair. We have submitted 9 federal permits to the BLM, which have passed the public comment period and are nearing approval, which we expect in Q4 of 2024. Next slide. So as I mentioned, the amended expanded Wild Horse 04 location is within mule deer high priority habitat. We began consultation with CPW 1 year before filing the OGDP and have developed a protective wildlife mitigation plan in accordance with that consultation. The use of the existing Wild Horse 04 location avoids habitat fragmentation by utilizing existing disturbance adjacent to County Road 110 and 113. We also agreed to complete most of the operations outside of the winter season. We anticipate the operations of the first 4 wells in this pad to start outside of the winter season and anticipate having some operations briefly within the winter season. We agreed to both direct and indirect mitigation fees with CPW. Both the drilling and completions of the 8 remaining wells on this location will be outside of the big game winter season. We also agreed to full wrap sound walls for drilling and completion operations that occur at the location during the winter season. And finally, we agreed to conduct nesting surveys prior to operations at this location. Next slide. As part of our siting analysis for the Wild Horse 04 location, Fundair evaluated 2 alternatives, which are shown on this map. Both of these alternatives fall within the mule deer high priority habitat. Both alternatives would create new pad disturbance in unfavorable surface locations, while the proposed location utilizes existing disturbance to avoid habitat fragmentation while accommodating topography in the area. Fundair worked closely with CPW, Pawnee National Grasslands, BLM, and Weld County to reduce the number of pads in this area from 5 originally planned pads that were all in high priority habitat down to 3 with only 1 in high priority habitat. Next slide. I will highlight a few wildlife related BMPs before turning to the remaining BMPs. Because we cannot avoid the high priority habitat, Fundair is committing to a robust set of BMPs to minimize and mitigate potential impacts. These include conducting most of the drilling and completion operations outside of the winter season, freshwater delivery via lay flat lines, takeaway for oil, gas, and produced water, locating all chemical storage more than 500 feet from any water feature, and installing full wrap sound walls for pre-production operations that occur during the winter season. In addition, we did agree to pay direct and indirect mitigation fees as outlined in the wildlife mitigation plan. Next slide. Moving on to drilling and completion commitments, we plan to utilize Tier 2 dual fuel engines for drilling, and we will comply with the new CDPHE NOx intensity requirements. Fundair will utilize EPA certified Tier 4 engines during the hydraulic fracturing process, Group 3 drilling mud, and a quiet frac fleet. All freshwater delivery will be via lay flat line to reduce truck traffic, and we will conduct air monitoring at both well pads for at least 10 days prior to the start of drilling, during drilling and pre-production operations, and for at least 6 months after the proposed wells are completed and producing. Next slide. For production, all oil, gas, and produced water will be connected to pipe infrastructure, allowing for the facility to be tankless. In addition, the new facility will be tankless, and once the new wells are on production, the existing tanks will be removed. We will utilize line power to operate the production facility equipment, which will allow the location to be electrified and consist of electric compression. Hydrocarbon liquids will remain in a closed loop system, reducing emissions and odor. And finally, all lighting will be on timers and motion sensors to minimize light usage only during scheduled activities on site. Next slide. This slide shows the phases of operations for both locations. We plan to drill the Wild Horse 4 pad in 2 phases to keep majority of the operations outside of the winter season for mule deer. 8 of the 12 wells on the Wild Horse 4 location will be drilled and completed outside of the winter season. I will now turn the presentation back over to Kelsey to conclude.
Thank you, Sydney. Next slide. The Wild Horse 47 OGDP will protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and will protect against adverse environmental impacts on any air, water, soil, and biological resources. The OGDP utilizes the amended, expanded Wild Horse 4 location to minimize impacts and cites the new Wild Horse 7 location outside of all sensitive receptors. In addition, Fundair is committed to the use of oil, gas, and produced water takeaway and will conduct the majority of drilling and completions outside of the winter season for HPH. The 1041 WOGLA permits have been approved by Weld County, creating vested property rights. No comments were submitted on the Form 2As. No formal petitions were filed, and the director recommends approval of the OGDP. And finally, after conducting ALA, Fundair has determined that the siting of the proposed Wild Horse 4 and 7 locations best avoid, minimize, and mitigate potential adverse impacts compared to alternative locations. Next slide. This slide shows the relief requested for the Wild Horse 47 OGDP. This does conclude our presentation. We respectfully request approval, and we have a team of subject matter experts here on the panel. So I think we can take the PowerPoint down, and if all witnesses could please be on camera, we are open for your questions.
All right, it looks like the PowerPoint is down and the panel is up for questions, commissioners. Commissioner Messner.
Thank you. I've got a few questions so that I better understand the timing of the proposed operations. So first question, understanding that the BLM permits are anticipated to be approved in Q4 of 2024. Is there any contingency plans associated with the timing stipulations should those BLM permits be delayed? Understanding that Q4 2024 does start to, the end of that starts to bump up into the proposed timing stipulations.
Yes, we've been in very close contact with the BLM, and we've expressed kind of our expedited time frame and our starting date that we are trying to get going on these. We do think we're going to reach that, and they do think they will as well. In the event that they do not, we have worked very closely with CPW, and between our higher mitigation fees, they have also agreed that if timing were to get pushed back a little bit further into the high priority habitat season, that they would approve the operations. They are on board with the operations going in further into the timing window.
Okay, that goes into my second question. I mean, as I read the consultation that we received from CPW, their understanding is that the completions on the 4 wells that are being anticipated in the timing stipulations would only go 2 weeks into the timing stipulation, so approximately December 15th. And I think that minimal amount of encroachment into the timing stipulations was a pretty important decision point in that consultation as to, evaluating the overall potential impacts.
So I believe you're referring to the director's recommendation where it has that statement of the 2 weeks. Is that correct?
No, it's actually in CPW's consultation.
Okay, so and our understanding was, and I think we can pull up to our wildlife mitigation plan. So we proposed an anticipated schedule with CPW, and we are going off of what we anticipate that schedule being. That 2 weeks was newer information to us when we received that director's recommendation. And our conversations with Brandon at CPW was if operations were to go further into the high priority habitat season, that we had, as long as we have already paid our higher mitigation fee, we were approved to be in that season at that time.
Okay, well, I'm going to read to you then from CPW's summary then of their consultation that is included in the Form 2A. I'm pulling it up here. So CPW's understanding is that the first 4 wells will be drilled this fall, and completions currently slated to begin around 12/1/2024 and extend for about 2 weeks into the mule deer winter high priority habitat season. The remaining 8 wells will be drilled and completed in the second quarter and third quarter of 2025 outside of the mule deer high priority habitat winter season. And then if you go to the conclusion of that, it seems to indicate that they feel like because of that minimal intrusion into the 2 weeks of the high priority habitat season and combined with the additional BMPs that are being proposed, that they're comfortable with it. But my conclusion from reading the CPW's consultation is that the expectation is that there would be minimal 2-week intrusion into that high priority habitat timing limitation. So I think I'm going to need a little clarity on that, because my understanding is that that's an important element in that determination, and that they are comfortable with the application. So I don't know if Brandon Moret is available to bring up to provide some clarity on that, but that does seem to be different than at least what I read in the application, what you're indicating here today.
And I think we would be, I am not really sure the process when it comes to bringing Brandon in. I know that our meetings with him and our consultation with him, given the commitment to the sound walls that are fully wrapping during drilling completions and any activity that are happening in that high priority habitat timing. And then, like I mentioned too, with the compromise that we had. So originally, to kind of back up a little bit, originally there were 5 pads in this development plan. And we went ahead with Brandon's consultation in CPW Weld County. We were able to reduce the number of pads in this area and reduce our disturbance acreage drastically by bringing it down from 5 pads to 3 locations, with only 1 of them in high priority habitat. So with those couple compromises, our understanding in our higher mitigation fee payment, our understanding was that if operations got pushed into that winter season, that we would be approved to do that. And our anticipated schedule, he approved our mitigation plan, and our anticipated schedule in that mitigation plan does have a start date of 12/2024 for completions, given we do have the BLM permits approved.
And Commissioner Mesner, if I may, first of all, would like to clarify, well, it's sort of 2 subparts, and I'll let Fundair clarify how many of those 4 wells actually do require federal permits, because I don't believe all of them do. And then secondly, it's my understanding that there was no stipulation with CPW that completions end at a certain period within that winter timing stip per Ms. Smith's remarks.
I appreciate your responses. I'm reading the CPW consultation. I'm reading the application that's in front of me. There seems to be some misunderstanding as the way that I'm interpreting it, because the 2 weeks is pretty clear in a number of places in the CPW consultation as what makes it more palatable, I think, for CPW in combination with everything else. And so at this stage, I don't have enough information, because there seems to be a conflict here between what the applicant is saying and what CPW is saying. And so that's what I'm trying to clarify here.
And thank you, Commissioner Mesner. Perhaps could Sydney, would you be able to clarify how many federal wells are included within those first 4?
Yeah, 2 of them on the full 4 pad are in BLM permits.
Thank you. And I would just reiterate, Commissioner Mesner, that it's certainly not, we're certainly not putting words in CPW's mouth, but there was certainly no agreement or stipulation in the wildlife mitigation plan, which CPW reviewed. It's in the Form 2A, that completions be limited to a 2-week time period.
Further questions from commissioners? And I took a look. I did not see Mr. Moret in the panel. Commissioner Ackerman?
Thank you. And I had questions along the same point. And just to make sure that I understand, drilling is, and I saw it in a couple different places that I thought I read differently when drilling was anticipated to begin. And so can you just clarify once again for me the schedule of when you intend to begin drilling specifically and intend to begin completion specifically?
Yeah, we anticipate being able to begin pad construction following, of course, the approval of this OGDP by the end of the month. And then we could have, assuming we get the BLM permits and the rest of the Form 2s approved, we will have drilling commenced by November. And then that can have completions by December. And our flowback and initial production would be anticipated to begin by January of 2025.
Thank you. And I didn't find information about the production and flowback as far as discussion with CPW. I'm operating under the assumption that because of your best management practices of pipeline takeaway and minimal intrusion during that time, that CPW was okay with that, but I didn't find anything specific there. So can you clarify, did you have those discussions about beginning flowback during the timing stipulation period as well?
We did. Yes, we absolutely did. And in our part 3 of our development activity, part of our wildlife mitigation plan, does outline that anticipated schedule that I just highlighted, and it does show flowback and initial production anticipated to begin in January of 2025.
Thank you. And I reiterate that I had the same questions that Commissioner Messner did about again, the CPW consultation also, to me, makes the assumption that they are okay with the drilling extending into about 2 weeks into the mule deer winter HPH season, but I don't see anything else that states that they anticipated that it would go further and that their consultation was based on drilling going further in the season. So I do have that same question as well. Switching gears, I also wanted to ask a question about the Tier 2 dual fuel engines. I know that you mentioned Tier 2. Can you be a little more specific about the type of engine there, as dual fuel kind of runs a spectrum? So for example, are you talking about natural gas primary with Tier 2 diesel supplement? Or are you just talking about standard biofuel? Kind of what type of engines are we talking about?
I'll probably let Brian Brown give you the details on the drilling engine.
Yeah, it'll be CNG engines with diesel backup.
I couldn't quite hear that, Mr. Brown. I'm sorry.
It'll be natural gas primary with diesel backup, basically. So it'll be a Tier 2 dual fuel, but with natural gas primary.
So I think what I heard was a natural gas primary with Tier 2 diesel supplement, but I couldn't hear if there was battery backup there or not.
There is battery backup.
There is, you say? Thank you for that clarification. I don't have further questions at this point, Mr. Chair.
Other questions for the panel? All right, I'm not seeing further questions, which means we are done with questions for the panel. If the panelists could visualize themselves away, it'll be a little easier for the chair to be able to see the other commissioners. Thank you. All right, commissioners, we turn to deliberation. What are folks' thoughts? Commissioner Messner.
Thank you, Mr. Chair. While I see a lot of good things about this application, I don't know as I have adequate information to make a determination on this application at this point until there's some clarity around what CPW actually understands to be the operations and whether or not they're comfortable with it either bumping 2 weeks into high priority habitat season or whether they're comfortable with completions activities occurring at any time through the high priority habitat timing stipulations. I'm not sure which one it is. I mean, to me, the CPW consultation was pretty straightforward, I think, with what they perceive to be the proposal. That seems to be in conflict with what the operator is proposing here. And so I think where I'm at is needing additional information from CPW before I can make a decision on this application.
What are other folks' ideas? Commissioner Ackerman?
Yeah, I'm in a similar situation, Mr. Chair. I would add to that that the wildlife mitigation plan does set forth some of those timing components, although it's more generic than we discussed here today. And then it specifically states that those dates are subject to change based on permit approval timing, project adjustments, or operational delays, weather conditions, and or other unforeseen factors. And so the point that I think that Commissioner Messner made is also a bit complicated in that CPW by rule takes a look at these, has an opportunity to take a look at and improve the mitigation plan as well. I didn't remember them talking in their consultation about having approved the mitigation plan, but you know, I might have missed that. But they did approve the wildlife task associated with this OGDP. And so absent CPW's presence here and with their consultation that they approved the wildlife task, that implies to me that they approved the mitigation plan that potentially allows for some extension that's not specified to a date. But then again, in their consultation, as Commissioner Messner has pointed out, they specify that their understanding was that that date lay somewhere in the 2-week range into December. So that's what leads to the need for additional clarification for me as well.
Ms. Wozlinski?
Thank you, Chair. And I know our panel is off questions and you're in deliberations, but I think it would be helpful just to clarify the record. We do have evidence of CPW approving that wildlife mitigation plan via email, and we're happy to provide that if helpful on this question.
Commissioners Ackerman and Messner, would that be helpful? Commissioner Ackerman?
Yes, for sure it would. And again, my assumption was that was the case. And so I gave the benefit of the doubt there, but appreciate the additional documentation as.
Do you want to bring that document up, Ms. Wozlinski?
Yes, if someone on the panel, either Ms. Pfister or Ms. Smith, could bring that email up via share screen, that would be wonderful.
Yes, I will absolutely bring that up. 1 second. Can everybody see that?
Commissioners Messner and or Ackerman, you're the ones who had the questions on this. Do you have any questions for the applicant relevant to the email that's on the screen at this point? And I can't see both of you, so just pipe out.
So, Mr. Chair, my question is just to get clarity. And so this certainly speaks to the wildlife mitigation plan and the compensatory mitigation that's being contemplated. I think that there's a different question here as far as the timing of operations and whether there's a comfort level there just based on the consultation that I read as part of this application. And so I'm not saying one way or another on this one. I'm saying I don't know because these things are conflicting with one another. And so what I would request in this particular situation is a stay of the application until we can get clarification from CPW. I think generally speaking, it appears that this application is an approvable application. There's lots of good elements with this application, but in order for me to fully review the application and understand the operations that are being proposed, and then tying those into the required consultations and the information provided by our wildlife experts, it's unclear to me enough to be able to make a decision today.
And Mr. Chair, I would add to that if the applicant is willing to state that they would extend for about 2 weeks into the mule deer winter HPH season and would commit to that, then I don't have any issue with this moving forward. Now, the about, I'm even okay with leaving the about language in there. But absent that, I would also need additional clarification.
Ms. Wozlinki, it appears we've got a couple of options before us. One, and I'm going to call an audible here. I'm pretty sure Mr. Moret is going to be with us by the end of the day because he's going to be testifying on a different matter entirely. So what I could do is just put this on hold and bring it up at such time in the agenda that Mr. Moret is available to testify. Alternatively, if you wanted to entertain the about language from Commissioner Ackerman, we could do that, and we could probably move forward with the application at the moment. What is your client's preference?
Thank you, Chair. I think our group here is just a little confused on the 2-week time period that is referenced in the consultation summary. I think based on maybe more recent conversations with Mr. Moret on this OGDP and this Form 2A, there certainly was not a concern with a mandate, I'll say, on a 2-week window within the timing stipulation. And that's evidenced by the approved wildlife mitigation plan, which sets forth sort of these broad timeframes. So I'm not sure the team right now is comfortable with a COA limiting completions for, about 2 weeks, just because that could be subject to change. And of course, I'll confer with my client. But at this point, we think this is approvable, and we think it's CPW's intent is clear as memorialized in the wildlife mitigation plan. So I suppose I'll leave it there. And we're happy to confer with Mr. Moret, and perhaps we can bring him on sooner than the afternoon if it's available.
I think what we do, let's just stay this matter for the moment, noting that we have the opportunity to take it back up a little bit later in the day. Mr. Moret was going to show up, I think, for the last OGDP, which seeks a variance with regard to some issues. So if you're comfortable with that, I'd rather not try to figure out what the vote might be otherwise. So I'm seeing you're nodding your head up and down, so I'm going to say that's an affirmative on the audible. We will stay consideration of 240500111 for an indefinite period of time, with the idea that we'll probably take it up a little bit later today. Fair?
Yes, thank you, Chair.
All right. Let's take a few minutes and bring up docket that ends in 324, and we'll take that up next. Let's return at 9:50. That's about 7 minutes out. All right, commissioners, we're back. Taking up docket 231-000-324, an oil and gas development plan for TEP Rocky Mountain LLC, entitled the NR41-3 OGDP. I believe we're going to first hear from Ms. Donahue on behalf of Garfield County.
Morning, Commissioners. My name is Jessica Donahue with Ardor Environmental. I'm here today on behalf of Garfield County. Garfield County just wanted to provide a comment that it has received TEP's NR 41-3 application. The application is currently undergoing completeness review. Garfield County does anticipate that the application may be presented to the Board of County Commissioners either late Q4 of this year or early Q1 of 2025.
Okay, thank you very much. Questions, Commissioners? All right, seeing none, I believe we'll move to the applicant and would ask AG Davenport to swear in the witnesses that are on the panel.
Thank you, Chair. Mr. Jewell, I see what appears to be 3 witnesses, Mr. Kirtland, Mr. Gillum, and Mr. Tankersley. Is that everyone?
Yes, sir. That is correct. Thank you.
Okay, thank you. For each of the witnesses, I'll ask you to raise your hand, state your name, and say that you swear to tell the truth. Mr. Kirtland, we'll start with you, please.
I swear to tell the truth. Jeff Kirtland.
Thank you, Mr. Gillum.
I swear to Tyler Gillum. I swear to tell the truth.
Thank you. And Mr. Tankersley.
My name is Adam Tankersley. I swear to tell the truth.
Thank you.
All right, Mr. Jewell, you're recognized.
Thank you, Mr. Chair. Thank you, Mr. Davenport, and Ms. Donahue. As always, thank you for your time for joining us this morning. Good morning, Commissioners. Michael Jewell with Jewell Jimerson Natural Resources Law on behalf of TEP Rocky Mountain LLC. Proud again to be the largest and most innovative operator in the Piceance Basin, up to date on its blanket financial assurances. Grateful for your time and consideration as always on this lovely autumn morning. Today, I propose a slightly different format for your consideration. As you may have noted on your agenda, we have 40 minutes allocated for your time. This time is relevant to docket number 231-000-324, but it's also a kickoff of sorts to operations moving forward for TEP in general. You may recall I signaled this operational pivot to you during the cumulative impacts rulemaking. Today, I could not be happier to introduce TEP's rollout of its EFRAC enhanced system and process, which will be part of this NR 41-3 OGDP should you decide to approve after our presentation in your deliberations. So to that end, a quick roadmap. We will present in typical TEP fashion with my providing an overlay of the key features of the OGDP. Jeff Kirtland, the regulatory manager for TEP, will go into the finer points of the application in the forms and technical standpoint. It will be available to address any questions that you may have concerning the application after the initial summary. We have, as we have before, Mr. Adam Tankersley, TEP's planning manager. He will contribute significant color to our planning processes, particularly as it relates to wildlife interfacing. And of course, he'll be available for questions and conversation after the initial thoughtful presentation. However, once Mr. Tankersley concludes, I will invite Mr. Tyler Gillum. He's our Director of Drilling and Completions to give you a presentation, of the PowerPoint variety that details TEP's innovative and first of its kind for Colorado EFRAC fleet. I think you'll be pleased to hear of his details, not only of the significant investment that TEP has made in the environment, but also in the paradigm and long-term goals for Colorado, wherein TEP positions itself to be a partner and lead investor for clean energy development. But before that, we thank your staff, specifically Ginger Malachowskis and the rest of the ECMC technical staff, for his insights and feedback for this OGDP process. None of this gets this far without their insight and detailed analysis. In this case, there was some interaction with the BLM that folded into timing here, but it went off without any significant delay or reconfiguration. To that end, there was one amendment to the application, but it was related to the collaboration with BLM with syncing with our mineral interests, communitization, and timing, but that's another testament to solid collaboration with permitting. So we appreciate that. So our technical details, for the record, this is docket number 231-000-324. We are in Garfield County, proposing one new oil and gas location in Section 3 of Township 6 South, Range 94 west of the 6th Principal Meridian. TEP formally requests the ECMC approve an order pursuant to Rule 303 and Rule 503G1 for an approximate 564.195 acre oil and gas development plan for the development of 39 new directional wells. This will include 12.705 acres of initial disturbance, 0.171 are existing, 12.55 are new. 1.95 acres will be initially reclaimed, so that's a 15% footprint, so it's 85% will be rolled back. 31 of 39 of these wells will be federal, so that'll be federal APD related. A lot of existing pads will be used, so we're going to be recycling a good bit here. The existing federal Rulison 8 pad will be used as remote frac support. The existing NR 334-1 pad will be used for condensate production. It utilizes the existing, the original disturbed footprint and partial reconstruction. The existing RWF 34-12 produced water storage will not require expansion. Existing roads of 2.42 miles will be utilized. New final roads of 2.25 miles will be built. That's 25.76 acres of new disturbance, but that'll be reduced down to 6.9 acres after interim reclamation. So about 75% will be rolled back. Pipelines will represent 7.9 acres of new disturbance and reduced to 0.325 acres after interim reclamation. So about 98% rolled back and covered up. So the public health, safety, welfare, and environment impacts, no residential building units, high occupancy building units, schools, or childcare facilities within a mile. A rarity for the Piats, this is not located within a DIC at any definition. TEP has committed to several BMPs to minimize and mitigate impacts from emissions, primarily by having pipeline takeaway for gas and flow lines for oil and produced water, which reduces emissions from fewer on-site production equipment and reduced truck traffic. TEP committed to various BMPs to address water impacts, including transporting hydrocarbon liquids and produced water by flow line to existing production facilities. There will be no permanent produced liquid storage on location. The largest tank on location will be a single 200-barrel tank. BMPs for groundwater and surface water production include, but not limited to, secondary containment on temporary flowback tanks and piping produced fluids to existing production locations. Real quickly on wildlife, Mr. Dankersley will go into the details here. But the proposed location is located in HPH for mule deer winter concentration area, mule deer severe winter range, and aquatic sportfish management waters. During the pre-application consultations, CPW discussed impacts to wildlife and control measures with TEP. And CP noted direct mitigation fees of $76,000, indirect mitigation fees of $45,592. CPW reviewed and accepted our wildlife BMPs. CPW noted in their comments in the Form 2A they are satisfied with wildlife impact avoidance, minimization, and compensatory mitigation measures, and have addressed pursuant to the requirements of ECMC's 300 and 1200 series regulations. Wildlife BMPs agreed for this OGDP include vegetation removal outside migratory bird season. If vegetation removal occurs during the bird season, then exclusionary measures will be used. Daily inspection for the first 6 months production, weekly for the remaining life of the wells, and the use of a remote monitoring system. So all that said, I'll leave it to the subject matter experts with the firsthand direct experience to elaborate. But granted, we would not bring an OGDP with you that we did not believe was 100% rule compliant. And our details are spelled out in our plan of development that runs alongside our forms 2A, B, and C for this application. And importantly for all, we note this application comes to you without protest or petition at all, formal or informal, no phone calls our surface development folks at all, or matters of significant concern from ECMC staff or other stakeholders. The director's recommendation included a clear and thorough assessment and recommendation of approval that addresses specifics for application, technical forms, and internal analysis. So with that, I'll pass over to Mr. Kirtland, who will walk you through the finer points of our signature plan of development before Mr. Tankersley provides more planning and wildlife details. And we'll conclude with Mr. Gillum's EFRAC presentation. Jeff?
Good morning, commissioners, and thank you for your time this morning. A couple points here, just really quick before I turn it over to Mr. Tankersley. As outlined, the planning of this OGDP follows our customary and collaborative approach of early and often consultation with CPW, BLM, and our partners at Garfield County. This critical consultation is really necessary for our developmental approaches in the peons. It really supports our commitments to wildlife protection, ensures that it's really the forefront of our operation. To that end, the planning process that this pad went through involved real dynamic consultation with the agencies that I mentioned, primarily around the identification and selection of this oil and gas location through the alternative location analysis process. While the application notes that official consultation with CPW occurred in 2024, discussions really began earlier than that. In 2023 with CPW and BLM. So again, this is a very iterative process in our planning, which Mr. Tankersley will go into a little more detail about. And then with Garfield County, we have been in discussion with them for over a year as we're working up to the submittal of that application. As noted in the director's recommendation, the alternative location analysis was completed, and we did identify there were 4 different locations. Again, the primary concern of siting in this location is high priority habitat, which you'll hear more about. But during that collaborative pre-application consultation between CPW and BLM, we confirmed in that real collaboration that there are at least two locations that were outside of HPH, but were within BLM's no surface occupancy zone. And really just wanted to explain that in those on sites and in those meetings that we have with these agencies, it's a pretty collaborative decision-making process. And through that, it was really contemplated that this would be the preferred location to best avoid, minimize, and mitigate impacts to wildlife and habitat. And part of the reason for that is that there's good access, and given that planned access, the minimization of the disturbance with the use of existing nearby pads for support facilities, and then it sort of further enhances the timing of our operations, given that we're looking at two separate visits, which will really help us avoid and minimize operations during seasonal wildlife periods. But more details on that. But before I turn it over to Mr. Tanksley, again, I want to emphasize that we're working closely with Garfield County. Again, that they're a critical partner in this development. And thank you to Ms. Donahue for her comments. And we're continuing to work closely with them on this pending oil and gas application. But now I'll just quickly turn it over to Mr. Tankersley, who'll provide some additional details before he turns it back to me for introductions of Mr. Gillum.
Thank you, Mr. Kirtland, and thank you to the commission for your time today. As is standard practice for TEP's planning operations, we engage with CPW early and often in the planning process. It's critical for us to get their input up front so that we can develop a plan that is protective of wildlife resources. And CPW has, for this application, has reviewed the full plan of development as well as the wildlife mitigation plan, and has approved that plan for development. This location specifically is located within aquatic sport fish management waters. It's located within 300 to 500 feet of that drainage. It's Yellow Slide Gulch. We did meet with CPW up front and request a waiver for activities within the 500-foot buffer, and they did approve that waiver request. The pad location is also located within mule deer winter concentration, and we have addressed that in the wildlife mitigation plan as well. The pad, the access road and pipeline corridors are located within aquatic sport fish and mule deer winter concentration. We do have activities within mule deer severe winter range for the access road, the pipeline corridor, and a few of the support facilities. So during the consultation process, we met with CPW out on location to review the full extent of the development plan. They had the opportunity to walk around the site and review all the project components for this development plan. That occurred back in 2023. We also had a pre-application consultation meeting with them where we went over the finalized plan of development, including the development schedule, which has changed slightly from what was submitted in the original application. Originally, we were planning on constructing the location in August of 2024. Obviously, that's not going to occur. That has been pushed back to August of 2025, and the development schedule is basically offset by 1 year. So all the associated mitigation for developments from a timing perspective is consistent with what was proposed underneath the original plan. So the oil and gas location itself is 12.705 acres, all of which is located within high priority habitat. The full disturbance acreage for the entire project is 52.15 acres. Of that, 36.466 acres is new surface disturbance. So we're capitalizing on utilization of existing facilities as much as possible. The primary discussion topics were timing of the activities, for drilling and completions operations, habitat loss associated with surface disturbance, noise, light, and traffic associated with the proposed operations. We also reviewed the alternative location analysis, which covered 4 alternative locations. As mentioned, 3 of the alternatives were located within the BLM NSO wildlife security boundary. And due to that reason, and through discussions with BLM, those 3 locations were effectively thrown out of consideration due to the NSO boundary, as well as additional service disturbance that would be caused through development of those locations within wildlife habitat. There was one alternative location that was downhill the NR 41-3 pad, which has topographic challenges, creates more surface disturbance within aquatic sport fish management waters, and it is a little bit more problematic overall for development. All 4 alternatives would have a reduced well count from the proposed 39 total wells. For a compensatory mitigation, as agreed to with CPW, direct impact fee would be $76,000. Indirect impact fees would be around $45,000. And in addition to the direct and indirect impact fee, TEP has agreed to pay a seasonal wildlife TL fee, which is broken up into the 2 separate drilling visits. For visit 1, we're proposing to pay $5,698 for activities that would occur in April of 2026. And then for visit 2, we've agreed to pay $28,493 for drilling over the winter season. These seasonal winter TL fees will be paid in advance of winter operations and following future consultation with CPW to ensure that they align with the proposed impact at the time of operations. In addition to that, we reviewed noise and lighting impacts. CPW was comfortable with the ECMC noise standards and lighting standards as it pertains to mule deer. We've included those as BMPs in the application. And then I just wanted to highlight a few operational items that really help to minimize overall impacts to wildlife resources. First, the avoidance of the BLM NSO wildlife security area is critical for wildlife, minimizing wildlife impacts further uphill from this location. We're also going to be installing gas, water, and condensate pipelines from this location to minimize overall truck traffic to location. And then utilization of existing infrastructure and existing facilities for condensate storage, water storage, and remote frac operations is also a key component of this project for wildlife resources. In summary, we believe that the NR 41-3 has been prepared in a way that avoids, minimizes, or mitigates impacts to wildlife resources. And we appreciate CPW's efforts and time in reviewing the application and developing something here that is protective of wildlife resources. So with that, I'll send it back to Mr. Kirtland.
Thank you, Mr. Tankersley, and appreciate the summary on that. The remote frac aspect of this is critical. We've brought to you a lot of information with respect to how we approach the topography challenges related to these remote locations, and we're excited to present Tyler Gillum, who's our drilling and completions director. And again, a little outside of what we typically do, but would like to share with you a PowerPoint presentation that we'll ask Tyler to share his screen. And I'll turn it over to him to talk about our new process related to this EFRAC technology, and allow him to walk through that process. And then after he's done, we can open it up for some questions and comments. Tyler.
Thank you, Jeff. Is everybody able to see my screen okay today?
Yes.
Figure out how they maximized it here. Huh. Sorry for the struggle. Are you guys okay to move forward like this?
Yeah, that's fine.
Okay. Um, Appreciate the intro, Jeff, and excited to be here today with you guys to share with you a project that we have a lot of pride in, and we've spent a lot of man hours putting this together over the last really 2.5 years to take a concept from reality over that time period. And really just kind of revolutionize how we approach fracking our wells to be more conservative ultimately and use the resources that we have in the Piance to do a cleaner job overall. So, in our continuous journey to find a cleaner and more sustainable solution, we've reached this new milestone with our enhanced electric frac system. This frac system creates basically a microgrid within our production field to reduce our carbon footprint compared to conventional diesel frac pumps, as well as eliminating and reducing other environmental impacts associated with current and future development. The microgrid ensures we're burning the cleanest methane molecule possible directly at the source to generate power for all new well stimulations, and also minimize right-of-way disturbance to all of our remote sites. Large right-of-ways that would only provide temporary access to a grid that's largely 35% coal-based and more carbon intensive. So with that, I'll get into it. Like I said, late last year, we formed a wholly owned subsidiary of Terra to kick this project off, which we called Piance Electric Pumping Company LLC. We refer to it as PEPCO. Proud to announce that as we sit here today, we've already completed 4.5 wells. We went fully operational on some retroactive permits on September 26th, releasing the previous diesel frac provider we had used before. And I think what's unique to the Piance is a lot of you know that we have an abundance of produced water that we're able to recycle and use 100% of that water when we do a well completion. Well, now this setup allows us to take it to the next level because not only can we use recycled water, but we can fuel the frac fleet and power it up and do everything we need to do with 100% natural gas that we source directly from our field on site. We like to coin it closed loop completions, and it's a handsome system comprised of 100% recycled water and 100% electricity generated with field gas on location. We vertically integrated and purchased the electric pumps and the blue box ourselves, as you can see up there. And then we also partnered on the power gen side with a company called Accelerated Mobile Power, who provides ultra lean burning generator packages that are driven by a 3,000 horsepower MTU Rolls-Royce German-made engine that drives a reciprocating generator. Each generator, as you can see individually down at the bottom, is about a 2.5 megawatt gen set with a D rate. And those generators all run off our field gas, can commingle up to 17.5 megawatts of power on a power distribution system, which we then feed into our electric pumps, which have no carbon emissions. All the carbon emissions obviously are generated on the amp side of things where the power gen side is. Within the last year, when we kicked off this project, we needed a facility both for AMP and us to house and maintain this equipment as we continue to operate. So we actually purchased out off the Rulison exit between Rifle and Parachute off I-70, an old trucking facility that we then converted into electric pump shop and leased some space to AMP, hoping that they can grow their operations in the future with these ultra lean burning generators in the field. Next, I'll show you guys a picture of it in action today. We just took these pictures earlier this month. This is up in our Ryan Gulch field in Rio Blanco County. As you can see here, pretty clean location overall. We utilize the MLVTs, those big blue harpoon tanks on the left that are covered to store our processed produced water that we're recycling for frac. And then on the left is a little bit more zoomed in picture of the setup. You could see on the right side of that left picture is the bank of the 2.5 megawatt amp generators. Behind there, that ties into our gas manifold system off of our field gas separators to pull line gas straight off the pad and power the generators. From there, the generators generate medium voltage, 13.8 kilovolt voltage that is then distributed or commingled, I should say, apologies, on the power distribution unit, and furthermore distributed to what our variable frequency drives here, which are basically control the current to the electric motors or the speed of the pump, if you will. And what's comprised in those VFDs is we're taking the 13.8 kilovolt medium voltage, we're dropping it down to 4160 voltage, and then we literally plug it in with a pretty big extension cord to these dual drive electric pumps. And we like to call them Tesla pumps. What you have here on the far left is a 5,000 horsepower single trailer with actually 2 quintuplex frac pumps on it on either side of that green electric motor you see with the blowers on top. And that's a 5,000 horsepower electric motor that has dual drive lines on either side, a lot like you would see like a dual drive Tesla, where it has one motor with dual drive lines to each tire. This is essentially the same concept. We power up the 5,000 horsepower electric motor, and then that drives 2,500 horsepower quintuplex frac pumps on either side of the electric motor, eliminating the transmission and even more kind of oils and fuels you would use to maintain a diesel pump. You simply just have to lubricate the electric motor a little bit to maintain it. So big question is why we did this. Well, I would just say overall, it's the right thing to do. When we look at all the factors today with carbon increasing and how we can use natural gas as a bridge fuel for the future to mitigate that by swapping from diesel with tier 2, tier 4 pumps, whether it's dual fuel or not, to 100% natural gas, we can reduce the oxides and nitrogens or our NOx emissions, which is one of the biggest proponents of ozone pollution, by over 61% relative to what we would have submitted to you guys in this application had we just done it our same old conventional way. Another big driver for doing this is reducing the overall CO2. We do reduce CO2 emissions. We are burning more methane since we're displacing a lot of diesel fuel usage. So when you think of the CO2 equation and methane having a 25 to 28 times intensity factor of that of CO2, we are significantly reducing our CO2, but given that we are burning more methane, the CO2E reduction isn't as significant as the reduction on the nitrous oxides. Another highlight with this fleet is that it eliminates all diesel particulate matter. We estimate up to 8 tons per year, which isn't tracked currently through the Form 2B process, but is sort of a component of that smog you see coming out of diesel exhaust pipes. Another big selling point in a driver for us to not only mitigate road traffic, but also mitigate impacts to wildlife is reducing the miles. Every well we have now on average in this field takes about 37,000 gallons of diesel to frack it with a conventional fleet. Now we can just use a mere 5 million cubic feet of gas to get to the same finish line, and we no longer need to bring diesel transportation trucks down our lease roads to fuel a fleet on a daily basis since we're tied into our gathering line right on site. So we've seen a pretty significant reduction in miles driven associated with this project. And then, like I said, where we're at, it's a remote site. We're always trying to minimize our right-of-way disturbance, especially given the nature of our operation and that it's temporary. So there's not typically transmission lines available at our sites, especially not ones that have more than 200 to 300 kW. A lot of them are single-phase power lines around the Rio Blanco County area. So, when you think about how do we tap into electricity to get more carbon-free, we believe that when you sum up everything and then you think of all the natural gas power generation on the western slope where we produce it, we process it at a plant, it goes to turbine power generation, and then is backfed down the line. When you take account that full cycle energy process to get that same power back to location by running these ultra lean burning engines directly at the source to generate a microgrid on site, we believe, based on our research calculations and a lot of Department of Energy data that the carbon intensity of this operation with this microgrid can be anywhere from 5 to 26 less carbon intensive than the carbon intensity of the regional power infrastructure that we have or don't have available in our field. And I'll get more into that theory here shortly. I thought this was a good reference point that I wanted to share. Is we've studied this for a long time to come up with what we thought was a kind of grabbing the lowest hanging fruit to cut our carbon footprint. But about 2 years ago, GTI Energy did an assessment for Black Hills, just looking at the use of natural gas and how we could utilize it as a tool in Colorado to help us decarbonize and reach our goals faster. And what's interesting when you look at Colorado and just the elevation, the intense heating demand, is there's still a lot of coal-fired generation in Colorado relative to the rest of the United States. 40% of the U.S. is powered by natural gas, about 20% coal. But when you look at Colorado, and I have some updated 2023 EIA numbers, it kind of flips, and you have a lot of coal generation, which I feel Colorado's done a great job displacing that with wind generation on the renewable front, where wind generation is conducive in the plains and the eastern side of the state. But still, even with all the intermittent wind generation coming onto the grid, when you go west of the Continental Divide, the power mix significantly changes. So while the wind is definitely helping us catch up and decarbonize the state at a rapid pace to keep pace with where we're heading on this journey, we still got a lot of work to do. And we think we can put a dent in that with the project we're presenting to you today. So what is on the Colorado grid? These are Department of Energy EIA power gen numbers from 2022 that have been published, and later on I'll share with you some preliminary data from 2023. But there's definitely a delta when you differentiate the eastern side of the state from the western side of the state. If you look at the snapshot on the bottom left here, this is a snapshot of the power mix in January 2023 at Public Service Company of Colorado, which we actually sell gas directly to them in the wintertime for their turbine plant. And you can see that just given the nature of the resources on the western slope and how the grid's evolved over time, that still to this day, about 90% of the grid west of the Continental Divide is all carbon-based power. You can see here that we have about 56% natural gas generation on this particular day, 32% coal, with a mix of some hydro and renewables, making just a little over 10%. Now you compare the western slope, where we're 2 miles, a mile up in the air, compared to the eastern plains, and the eastern plains is a lot less carbon intensive because it's conducive for all the wind generation to help stymie the use of carbon-based energy to power the grid. But when you look at the western slope, there's definitely a different dynamic that raises the carbon intensity out there, mostly due to just regional constraints, topography, intense heating demand in the wintertime. There's a multitude of reasons there. And the fact that wind turbines don't work very good at 8,500 feet elevation as they do on the plains. This is just a snapshot. I also have a reference to the Colorado Pathway Project, which is a huge investment in clean energy infrastructure to connect all the wind turbine farms on the eastern slope between 13 counties. Pretty necessary project to helping us decarbonize and take advantage of the resources that the state has on the plains, where it's conducive for wind generation and a better climate for solar generation at all. But just to kind of prove my theory where we're at, I've kind of highlighted where the location of the 41.3 OGDP would be relative to the closest wind farm, which is a small 7.5 megawatt wind farm just south of Boulder, Colorado. There is one on the other side of the border in Utah, but this is just a snapshot from the U.S. wind turbine database, which I've referenced there in the slide below, if anybody's curious there. But I think it just shows the dynamics, and you can clearly see where the Continental Divide there at Denver, there's just a different dynamic as you go up in altitude. So what does all this mean, and why do we think it's less carbon intensive than the grid as it stands today? So we did a lot of research on this, including pulling a lot of Department of Energy data. The Department of Energy, a while back, as part of the IRA plan, actually developed a tool called the GREET model for hydrogen subsidies. And what the GREET tools is used for is to basically designate if you're going to go make hydrogen, whether it's green or blue hydrogen. Green hydrogen being made from renewable power sources versus blue hydrogen would be made from fossil fuels. And obviously they're after green hydrogen because that's less carbon intensive. But within this GREET model, there's a lot of good data in there to prove your power source, and they have a pretty good handle on emissions factors from different types of power plants, which I've listed in table 1 for you. And as you can see there, according to the Department of Energy, a coal-fired plant at the terminal is going to generate about 968 grams of CO2 per kilowatt hour versus a natural gas-fired plant only generates 428 grams of CO2 per kilowatt hour. There's thankfully not much oil-fired generation in Colorado. It's mostly gas and coal, but I did stick that in there for reference. I also referenced biomass. Burning stuff is very carbon intensive, whether it's organic material or not, and those emissions factors aren't counted in here because it's such a small source of power, but that is a very carbon intensive process based on the DOE factors. And then as you go further on the table to the right, I took those factors all the way to the wall outlets. So when you generate power at a plant, you got to send it down the high line. There are typically parasitic losses to transfer those BTUs to a user site, which can be up to 5% or more, depending on the distance that you have to transfer power. And on the far right, I can't say the ultra lean burning field gas generators are cut carbon quite as much as a fixed stationary gas turbine plant, but we're almost there. The factors for these AMP lean burning generators is about 463 grams of CO2 emitted per kilowatt hour generated. So taking these factors, what we did was go pull the energy mix data and weight these against the different types of power generators there are on the Colorado grid, given a 0 for nuclear, a 0 for hydrogen, a 0 for wind, and a 0 for solar, because those are carbon-free forms of energy once they're implemented. But you weight these carbon factors that I showed you in table 1 against the power mix. And as you can see in the red box, last January at the Public Services Company daily generation mix on January 2nd, 2023, the carbon intensity of the grid came out to be about 585 grams of CO2 per kilowatt hour. Now compare that and take away that 32% coal and replace that with 100% natural gas, and you could see about a 26% reduction in carbon intensity by creating a microgrid directly at the source and not having to transfer any line power, not having any carbon-based energy in the mix. Now that's the western side of the state in a winter month at peak elevations. I highlighted in blue what the 2022 annual Colorado average was, where we still had 36% coal on the grid and 26% natural gas. Given all the wind generation out there, approximately 28%, as you can see here, you can see how much lower the carbon intensity is out there compared to the red box, which is the western slope. And then fast forward to 2023 EIA data, which is still preliminary and unpublished, but there seems to be not many changes there. You can see that Colorado's gotten even better, but how we've gotten less carbon intensive year over year is because natural gas picked up from 26% in 2022 to 30% in 2023 and displaced some of that more carbon intensive coal-fired generation, with wind holding steady. And hopefully wind will be expanding as a result of the Xcel Energy pathway project that's actively being installed on the Front Range. But when you add up all these factors and you truly look at the carbon intensity using these emissions factors from the DOE, we deduce that, even on our best day, we could be somewhat 4 to 5% less carbon intensive than the grid on the plains. And in the middle of the winter time, when intense heating demand picks up, we believe the data shows that we're much better than that on the margin when you talk about carbon intensity. And finally, just kind of summarize what I said. I've spoke to a lot of these points already, so try not to waste more of your time. But 90% of the power generation in January on the western slope is carbon-based energy. So by creating this microgrid, we really feel like we're putting ourselves ahead of the curve when you look at holistically, just look at the overall carbon footprint of our operation by using fuel directly at the source to generate a microgrid and using water that's already produced in the field. We think it's one of the most sustainable ways to frack wells moving forward into the future and conserve resources out there that we have. And again, by referencing the CO2 emissions factors from the feds, you can see that when you account for parasitic power transmission losses and the energy mix on the grid, and reference, you look at our overall CO2, this is a very sustainable solution relative to tying in the medium voltage power that could have up to 32 to 35% coal-based generation tied to that. Again, we're striving to be one of the top operators in the state, and we're committed to helping the state reach its goals because it's the right thing to do to reduce CO2 and make our operation more sustainable as we move into the future for everyone. And I just want to thank you for your time today. And we're always open for tours now that we're up and running. If anybody's interested, and with that, I'll open it up to you guys if you have any questions for me or any of the other witnesses from Terra.
Mr. Jewell, does that conclude the presentation?
It does, Mr. Chair. TEP University, one of the many services we offer. So thank you very much for your time and consideration. We welcome your questions and guidance as always. Thank you.
All right, if we want to pull down the screen share, be a little easier to see everybody. And then commissioners, the panel is open for questions. Commissioner Ackerman?
Thanks, Mr. Chair. I still see the screen on my side. I'm not sure if folks are pulling it down or not, but just wanted to let you know. Mike, thank you. It's down now. I appreciate the presentation, appreciate the good work that TEP always does, and do appreciate the additional information that's larger than this OGDP today. Thank you for sharing that with us. My primary question here, once again, is on the timing. You've got two occupations here. It's really kind of one long continuous occupation of one type or another, with construction beginning in August 2025 and then completed prior to timing limitations, coming back after the timing season, and then pushing all the way through visit two, all the way through the winter timing stipulations on the second season. And I certainly understand that this is a complex issue on these larger pads on the west slope where HPH avoidance really is not possible. And certainly understand that there might be site-by-site considerations, there are BLM lease issues, the ongoing conundrum of whether it's better to pause and then start again or just push all the way through. And I know that you've discussed those things in detail with regard to this application. But I have a few questions as the schedule seemed to be a bit different than what we're used to. And specifically, my first question would be on the first occupation. Did you discuss pushing back completions on visit one? Right now, they're scheduled to begin on April 25th. If you push them back for a week, then you'd be outside the winter timing stipulations entirely on visit one, as opposed to starting up during the end of those timing limitations. So that's my first question. And I'll pause there for an answer, and then I'll ask the other two.
Thank you, Commissioner Ackerman. Indeed, we're always consulting with CPW and BLM on these timing issues. And normally I would ask Jeff to look into this, but I think with Adam with us, he is our planning maestro. I think he might be the best person to start here to answer this. So Adam, if you would, sir.
Yeah, thank you for the question, Commissioner Ackerman. Really, the schedule is based off of our active drilling operations. So this is where it currently slots in behind the location that's prior to it from a drilling operation standpoint. There is the potential for that to be adjusted depending on drilling efficiencies or drilling delays associated with those activities. So while we think it's going to occur in April of 2026, at this point, there's no guarantee that it's going to occur. So it could ultimately get pushed back outside the TL, but it could also get pushed forward. And that's why in the wildlife mitigation plan, we committed to consulting with CPW prior to those activities occurring, and just to make sure that the mitigation fee is paid in proportion to the activities that would occur during the TL.
Thank you. So a follow-up on that question is that you're doing your best to avoid the winter timing stipulations, but that was based on simply your rig availability and as opposed to trying to avoid the back end of the timing stipulation. Did I hear that correctly?
Yeah, we operate a continuous drilling program. So to delay, drilling operations, that could be problematic for us, especially further into the winter we go. That could ultimately be problematic for a continuous drilling program and potentially having to lay a rig down and pick it back up at a later date if that makes sense. So.
Yes, thank you. And that kind of leads to my second related question that's a little more complex, and you can maybe educate me here a little bit as well. Um, you've got those completions picking back up at the end of April, like we just discussed, and then going all the way through till October, and then beginning drilling on the second set of wells on this pad subsequent to that in October, and then pushing through the winter. Is it possible for you to bring the rig in and drill concurrent on the pad to the completions of the first 20 wells? And did you discuss that? And can you talk a little bit more about why you opted away from that? That would largely keep you out of winter timing on the second occupation, is why I'm asking.
Yeah, thank you for the question, Commissioner Ackerman. We did consider a continuous drilling program. This area. There's a little bit of uncertainty about well performance in this area, and that is the key driver to the two visits. We need approximately 1 year between completions operations completing on the first visit and beginning of drilling operations on the second visit to analyze results to verify that we will be going back to drill the remaining wells.
Yeah, thank you. I made this mistake before when I was reading and didn't catch the 2027. So it's not that you're operating continuously, it's that you're taking that actual pause for a year and coming back. So thanks for that clarification. It was clarified to me before, and I still made the mistake in the hearing. So thank you for clarifying. So that's essentially to take a look at well performance. I guess that would lead to my third question then, which would be if you're able to identify and evaluate that and you're taking a break anyway, what's the detriment to reworking that schedule so that you begin again on occupation 2 subsequent to the winter timing limitations?
Yeah, I think again that kind of comes back to the continuous drilling operations that we currently have and where that slots in from a timing standpoint underneath the current schedule. And again, that could be accelerated potentially depending on efficiencies or potentially delayed depending on issues with drilling operations going forward.
You're on mute.
Thank you. I appreciate that, Commissioner Cross. Thank you. And I didn't see any, discussion about the BLM lease timing period, and wondered if you were pushing up against the back end of the potential of the lease and therefore needed to move forward. But it sounds like that may not be the case.
Yeah. So Jeff, do you want to discuss the lease and the associated expiration date?
Sure. Yeah. And I might ask Mr. Jewell to help us out because, we effectively approached BLM with a request to suspend that lease and, worked really hard with them to understand a way to preserve that option. That was driven a lot by, the complexity of this project, the access associated with this project, to ensure that it was, it was safe in terms of accessibility, et cetera. But, effectively, we are in a situation now where the lease is essentially suspended, and we would be awaiting our approval of APDs to then start that clock. So again, really good working relationship with BLM on ensuring we could preserve that option for us. And I don't know, Mr. Jewell, I know you were involved in some of those discussions. I don't know if I missed any additional details that might be important.
Thank you, Jeff. That's correct. I would just add the BLM noted this was the first of its kind for an SOP or a suspension of operations under that CFR for these purposes. So the collaborative effort that went into getting this SOP was the first of its kind in Colorado, they noted. So we're proud of that effort and that collaboration with BLM. So I think it worked out quite nicely.
Thank you, and I appreciate you having this discussion with me. I would note for those listening that these discussions certainly I understand have been had at length with CPW and BLM during the planning process, and there is no conflict in the CPW consultation summary as we saw in the last OGDP, and CPW did concur that the operators effectively consulted with them and implemented the mitigation hierarchy. Nonetheless, I appreciate you having this conversation with me as we strive to ensure, protection of wildlife habitat, certainly on the western slope and throughout the state, and particularly in those winter timing stipulation periods. Appreciate it.
Yes, sir. Appreciate it as well.
Other questions to the panel? Commissioner Messner?
I have just a curiosity question about the kind of the electric frac pump setup and the proposal that was shared, and appreciate all the information about that. I think it's a really unique solution to challenging situations up there, but I didn't hear any discussion around noise. Is there any noise benefits associated with the natural gas generators utilizing or providing electricity for an electric frac fleet, or is it relatively the same?
That's a great question, Commissioner Mesner. And I don't want to put the cart before the horse because I got Adam Tankersley lining up a sound study as we speak to provide actual data to you guys, which we plan on publishing in the next application. But to answer your question with the best information I know today, you don't actually have to wear hearing protection next to electric pumps. It's a quiet hum. That side of the location is really quiet. There is some noise off the cooling package of the generators, but overall, we feel that's going to be significantly more quiet than the historical conventional diesel fleets we've used in the past.
Great.
But we do plan on following up with that sound study once we have all the data in hand.
Yeah, I'd be curious about that. So appreciate that you are doing the study. And then I wonder if you just talk a little bit more about the VFDs and how they I'm assuming that the VFDs are being utilized in this whole process in order to maximize the efficiency of the engines that are generating the electricity and so on and so forth. But it seems to be an important part and parcel to the whole operation. And I wonder if you just provide a little more information on why it's important to maximize the efficiency of the engines from a emissions standpoint.
Yeah, no, great question again. It's just like driving your car at 60 versus 90. You're gonna burn more gas, and what we're striving to do is not get the max 2.5 megawatts out of these generators, but rather when we're fracking, just drive them at 60 miles an hour, or 70 to 80% load, to where our emissions profile looks really good, and we're ensuring the right oxygen to fuel mix on the intake to make sure that we're burning the cleanest molecule possible in those combustion chambers. But then once we do generate that 13.8 kilovolt off the front of the recip packages there, it does go to those variable frequency drives. And those basically are what controls the current. Once we drop down that 13.8 kilovolt voltage to 4160, there's actually a transformer in there with cooling fans. So we transform that to lower medium voltage power, which is suited for those 5,000 horsepower electric motors I showed you. And really the VFDs control the current. So once we aggregate that power on the distribution unit, we have controllers and comms tied back to our data van, which is the controller for the VFDs. And just in layman's terms, it's literally a dial there. And as everything's tuned together, the generators and the pumps alike. And as we turn that dial to send more current to the motors to increase our pump rate, the generators come up and they load share, and we get to a good spot where everything's level loaded. So I'd say the main two things of the VFDs are, one, they control the current going to the motors, and within inside those trailers, there's also transformers that drop our 13.8 kilovolt medium voltage down to 4160 for the electric motors.
Great. Thanks for the additional information.
Yes, sir.
Thanks for the questions and the answers. Additional questions for the panel? Well, we do appreciate the extended information on this new work that you're doing out there. We now will turn to deliberations. Does any commissioner desire to initiate deliberations? Commissioner Messner, then Commissioner Ackerman.
Thanks. So really appreciate, like I indicated earlier, TEP coming to the table with unique solutions to challenging situations. And I think, as I look at the technology that's being proposed here, and I know a lot of work that's being done here, I would acknowledge, particularly on the Western Slope and in some of these areas, that extension of transmission lines in order to electrify drill rigs can potentially have more negative impacts than positive impacts in a lot of these environments. And so being able to contemplate, a remote generated electric frac fleet, makes a lot of sense to me, and really appreciate that this is that's being proposed here. I note that this is 39 new wells on one location utilizing remote frac and remote production facilities. That there's a reduction in NOx emissions, as indicated by the operator, of potentially 61%, reduction of CO2 emissions at 22.3%. The elimination of diesel particulate matters associated with stimulation operations. Also really important to me is the elimination of truck traffic associated with the hauling of diesel fuel. As always with this operator, I really appreciate the submission of the plan of development. I think that it really clarifies what is being proposed, how it's being proposed, and eliminates a lot of questions and conflicts in the review between the local governments, the federal governments, the state governments, and the different consultations that we have. And so I continue to encourage other operators to utilize the plan of development concept that TEP continues to utilize. And so, I really also appreciate the continued significant produced water recycling that this operator does, and that they are also utilizing on-site natural gas for a lot of these operations as well. And so I appreciate Commissioner Ackerman's questions. I do think that the timing stipulations on the Western Slope end up being a really important aspect of this. I know that there's been continual conversations with CPW, and I don't see, as Commissioner Ackerman indicated, any conflicts between what the operator is proposing in this presentation and what is being presented in the CPW consultation. And the CPW consultation indicates that they're comfortable with this application, and so I'm comfortable with the application and would be supportive.
Commissioner Ackerman.
Thank you, Mr. Chair, and thank you, Commissioner Messner, for kicking us off there. I just wanted to make a couple of deliberative comments with regard to HPH in general, and remind us that all HPH is not in the same bucket. These HPH habitats are listed in Rule 1202D. And from the Mission Change Statement of Basis and Purpose on page 202, the subset of habitats listed in Rule 1202D, while sensitive, are frequently managed by land managers and state wildlife agencies using impact minimization strategies like co-locating facilities and limiting the density of surface facilities, or eliminating or implementing surface disturbance caps. Evidence in the administrative record demonstrates that when properly regulated, development can occur within these areas in a manner protective of wildlife populations and their habitat. And then compensatory mitigation is often utilized to offset unavoidable adverse impacts that occur in these habitats when impact minimization strategies are not successful. I believe the operators' consultation with CPW and BLM in the process that they've gone through are consistent with the intent of this regulation under the statement of basis and purpose clarifications as well. That said, I did hear a couple of comments today about a rig schedule, and I know that that's a complex operation to manage. I would continue to challenge all West Slope operators to manage their schedules in such a way that prioritizes or continues to prioritize, in the instance of this operator, operations outside of winter timing periods, the great preponderance of the time. That said, I'm also echo Commissioner Messner's comments about the many virtues of the conduct of this operator and the innovation that they're undertaking, and I'm in support of this application.
Agreed. Other commissioners with thoughts? Does any commissioner desire to make a motion? Commissioner Cross?
I'd move for approval of the application.
Motion and a second. Is there further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Thank you to TEP as well as to our staff for bringing this matter forward.
Thank you, commissioners and staff. Appreciate your time. Great day.
All right, let's return at 10, or let's return at 11. That's about 6 minutes out, and we're going to take up the PDC matter next. And then we likely are going to get back to Fund Air at some point, but we're going to go PDC next. So if we could get PDC set up, we will see everybody in about 5 minutes. All right, welcome back. The Colorado Energy and Carbon Management Commission. It's Wednesday, October 23rd. It is 11 a.m., and we are continuing with our docket. We now will take up docket 240300069, an oil and gas development plan proposed by PDC Energy, entitled the Mountain View 4N67W3 1-24 OGDP. And I believe we're going to start this presentation by hearing from Amanda Petzold, an ECMC location assessment specialist. Ms. Petzold.
Good morning, commissioners. Can you hear me?
Yes.
Thank you. For the record, my name is Amanda Petzold, Lead Location Assessment Specialist for the PDC Mountain View OGDP. Thank you for the opportunity to clarify a statement in the published director's recommendation under the Public Health, Safety, and Welfare Considerations section. Staff indicated that PDC has committed to an electric drill rig. However, the OGDP does communicate that if the utility is unable to provide the necessary line power, natural gas generators will be used to power the drilling rig. Please note, the clarifying language is included in the Form 2A BMPs and was discussed at the CDPHE consultation. Staff's recommendation for approval does not change. Thank you for the time to clarify this for the record, and I'm happy to answer any questions if needed.
Great. Any questions, folks? We appreciate you being with us. Thank you very much. Mr. Maxey is now recognized from Weld County.
Thank you, Chair Robbins, and again, thank you to the Commission for allowing us a few minutes to speak to Weld County's process regarding this OGDP, which is in front of you right now, being the PDC Energy Mountain View OGDP. Just to hit it right off the bat here, we can say that thank you to Ms. Petzold for her clarifying comments as well, seeing as how we received the director's recommendation. I have no concern with what I just heard Ms. Petzold clarify. It does not change our view of this or what we permitted at all. On February 1st of 2023, Weld County held our pre-application meeting for this location. Attendees did include at the time PDC staff, Weld County staff, ECMC staff, and CPW staff. I want to make note for the record that CDPHE, the BLM, the town of Johnstown, and the town of Milliken were all invited, but chose not to attend our pre-application meeting. The 1041 WOGLA application was received on June 12th of 2023. We did not receive any public comments from the submittal that we received, but we did receive requests from both the town of Milliken and the town of Johnstown to be granted permission to attend and participate in our hearing. This request was due to concerns regarding the proposed traffic haul route. The town of Johnstown ultimately withdrew their request as the final agreed upon haul route did not end up impacting their jurisdiction. There was initially a postponement at the request of Weld County staff from the original advertised hearing date. And then there was an additional postponement, which was at the request of PDC to postpone again. So therefore, the 1041 Wogley hearing was actually held on January 25th of 2024. At that hearing, the hearing officer considered testimony at that meeting and also heard not only from staff, but also from the town of Milliken, who again requested to participate, and we allow their participation. We encourage that. And the hearing officer took those comments from staff and from the town of Milliken. And again, the town of Milliken had concerns regarding the haul route. And at that time, the hearing officer elected to continue the hearing to February 29th of 2024. And he further ordered that all parties continue discussions regarding the proposed haul route and the town's safety concerns that were brought up at that hearing. Before the continuance hearing that I just mentioned on February 29th, the towns of Milliken and Johnstown, PDC staff and Weld County staff and CDOT staff met on location on February 15th to coordinate haul route discussions. After that meeting and coming back to the hearing on the 29th, the application was ultimately approved, and the operator was ordered to comply with the installation of any safety suggestions as recommended by CDOT, who holds jurisdiction over State Highway 257. The final order was recorded with the Weld County Clerk and Recorder and noticed in the Greeley Tribune on March 22nd of 2024. And as you all know, approval of our permits does create a vested property right pursuant to Colorado revised statutes. As usual, we submitted 2A comments for this location, and they are included in the director's recommendation. Again, we did receive the director's recommendation, and even including Ms. Petzold comments, we support that recommendation, and we have no concerns with this OGDP being approved by the commission today, if that is your decision. I know that I brought in and introduced some comments that are usually out of the ordinary and might be additional to what you normally hear from Weld County, but we feel that those comments are very relevant and pertinent to this case. Be happy to answer anything you all might have. And once again, thank you as always for the time we are allowed to participate in your process.
Thank you, Mr. Maxey. Questions? All right, I don't see questions, so thank you very much.
Thank you again.
Ghost.
Good morning, Chair. Is it appropriate to bring all of our witnesses on screen to be sworn in?
Yep.
Wonderful, thank you. If everyone could please come on video.
AG Davenport.
Thank you, Chair. I think everyone's pretty familiar with the process at this point, so I'm just going to go ahead and start. Mr. Sheehan, would you please raise your hand, state your name, and say that you swear to tell the truth?
Corey Sheehan, I swear to tell the truth.
Thank you, Mr. Manning.
Marcus Manning, and I swear to tell the truth.
Thank you, Mr. Blessing.
Tyler Blessing, I swear to tell the truth.
Thank you, Mr. Rouse.
Jim Rouse, I swear to tell the truth.
Thank you, Ms. Waters.
Tammy Waters, I swear to tell the truth.
Thank you, Mr. DeRose.
Brian DeRose, I swear to tell the truth.
Thank you. I'm not sure everyone's appearing on my screen. Mr. Holbert.
Taylor Holbert, I swear to tell the truth.
Thank you. Miss Joseph, am I missing anybody? I apologize.
No worries. We have one more, Miss Meinrich.
Oh, okay. Please go ahead, Ms. Meinrich.
Patricia Meinrich, I swear to tell the truth.
Thank you.
All right, Ms. Jost, the video panel is yours.
Wonderful. Thank you, Chair. Let me go ahead and share my screen. Chair, are you seeing that okay?
Looks fine.
Wonderful. Thank you so much. Well, good morning, Commissioners, staff, council, and members of the public. My name is Jamie Jost of Jost Energy Law, and I, along with my partner, Kelsey Wozolinki, represent PDC Energy, Inc. in this Mountain View OGDP application that was filed on June 3rd, 2024, and is before you today in docket number 2403-00069. PDC would like to thank Weld County for its participation through the local permitting process and its approval of the Mountain View oil and gas location subject to this OGDP. And we'd also like to thank ECMC staff for the clarifications this morning, as well as the staff and director for their hard work and efforts on this OGDP. We'll have two main presenters today for the Mountain View OGDP, Mr. Corey Sheehan and Ms. Tammy Waters. They'll touch base on topics 3 through 7 shown on this slide. The Mountain View OGDP seeks approval of an approximate 3,520 acre OGDP and Form 2A for the development and production of up to 24 new horizontal wells to be developed from one new well pad. This is the Mountain View 4N67W3 1-24 oil and gas location located on 18.51 acres in the northwest quarter, southwest quarter of Section 3, Township 4 North, Range 67 West in Weld County, Colorado. PDC is also seeking approval of one 3,520 acre drilling and spacing unit for the production of oil, gas, and associated hydrocarbons from the Niobrara, Fort Hays, Codell, and Carlisle formations within the OGDP. PDC has been preparing the Mountain View oil and gas location for almost 2 years. PDC initiated the Weld County WOGLA process for the current Mountain View location in June 2023, obtained WOGLA approval in February 2024, and submitted the current OGDP to the Commission in June of 2024. In terms of the OGDP submittal, PDC complied with all notice requirements for the OGDP, no formal petitions were filed, and no public comments were submitted on the OGDP application. The director's recommendation for approval was issued on September 5th, 2024. Rule 604B governs the siting requirements for proposed oil and gas locations near residential building units and high occupancy building units, and provides that no working pad surface will be located more than 500 feet and less than 2,000 feet from one or more residential building units or high occupancy building units, unless one or more of the following conditions are satisfied. The applicable condition for the Mountain View OGDP is Rule 604B1 that states the residential building unit owners and tenants and high occupancy building unit owners and tenants within 2,000 feet of the working pad surface explicitly agree with informed consent to the proposed oil and gas location. For the Mountain View location, each of the 4 residential building unit owners and tenants have explicitly agreed to the siting of the location. The Mountain View OGDPs falls under Rule 604B1 standard of review because there are 4 residential building unit owners within 2,000 feet of the working pad surface of the location, and PDC has obtained informed consent from each of the owners and the tenant. More specifically, PDC utilized the ECMC template Weld County Informed Consent Form and obtained informed consent on such form from the RBU Tenant 1 and the RBU Owners 3 and 4. Under the terms of a joint development agreement executed between PDC and the RBU Owners 1 and 2, which is in the ECMC record in support of the Mountain View OGDP, PDC also obtained informed consent to the Mountain View location under Section 1.8 of the Joint Development Agreement, where Owners 1 and 2 expressly waived any siting requirements of Rule 604, and that waiver serves as the necessary informed consent pursuant to the Commission's rule, the Statement of Basis and Purpose, and the Rule 604 operator guidance published by the ECMC. So PDC has obtained explicit written consent and explicit written agreement to the proposed Mountain View location from RBU owners 1 through 4, and as well as the tenant. I'd like to now turn the presentation over to Mr. Corey Shaheen and Ms. Tammy Waters to address topics 3 through 7. Thank you.
Thanks, Jamie, and good morning, commissioners. My name is Corey Sheehan, Surface Lane Representative at Chevron. In Section 3 of today's presentation, we outline the application specifics of the Mountain View OGDP. The Mountain View location is planned for 24 new horizontal wells, developing approximately 3,520 mineral acres from one location. PDC has obtained 100% of the informed consents applicable to the location. The location is outside of high priority habitat, outside of public water supplies, and outside of disproportionately impacted communities. PDC plans to have oil, gas, and produced water takeaway from this location via pipeline. The location will utilize tankless hydrocarbon storage as well as Group 3 drilling fluids. Here we outline our currently planned phases of development for the Mountain View OGDP, with construction scheduled to start in Q4 of 2025, drilling planned to commence in Q1 of 2026, completions planned for Q3 of 2026, production beginning in Q4 of 2026, and interim reclamation commencing in Q1 of 2027. Section 4 of the presentation outlines the siting and alternate location analysis that was conducted through PDC's efforts of selecting a location that best protects public health, safety, welfare, environment, and wildlife resources. As you'll see on this slide, PDC's preliminary assessment of the overall development area provided 6 alternate locations which could potentially accommodate oil and gas operations, with 2 of those alternates, locations 5 and 6, being ruled out early on in the process as being unfeasible due to a substantial amount of immediate receptors identified. This left 4 alternate locations to be fully evaluated by PDC. Our primary area of focus was towards the center of the map, as the eastern and western portions of the proposed mineral development area are dense with both residential and commercial development within the town of Johnstown and Milliken. As with all of PDC's surface locations, considerations when conducting our site selection or ALA process include but are not limited to proximity to building units, operational feasibility, does the location meet the standards of our site-by-site risk assessment for development, impact to future land use, will this site have negative impacts on future development or are there pending development plans in the area? If this site is being planned on lands that are intended for long-term farming operations, will the surface owner and or tenant farmer be negatively impacted by the site for these future operations? Proximity to cultural features, environmental concerns such as wildlife corridors, raptor or eagle's nests, prairie dogs, burrowing owls, wetlands, floodplains, designated surface water, and much more. Access to location. Does PDC believe we can construct or utilize an existing access that is safe with minimal impacts not only to the surface owner, but the surrounding community as well? Surface owner negotiations. PDC wants to be a partner with our landowners or stakeholders, and these proposed locations have to be locations that not only work for PDC, but work for the surface owner as well. Geology. Does the subsurface structure formations complement the surface location in which to safely and adequately develop hydrocarbons? And last but not least, consolidation, a consideration that is evidenced quite clearly through the evolution of the Mountain View location and or unit as we see it today. This is a unit that at one time in its early development stages was planned as 2 separate units with 2 individual oil and gas locations planned to develop them. Through the extensive ALA process, coordination with stakeholders, and PDC's continued efforts of consolidating our overall footprint within our development areas, we are looking at a plan today in which we are able to develop the entire mineral development area from a single oil and gas location. We'll now walk through each of the 4 alternate locations that were fully evaluated as part of the alternate location analysis associated with the Mountain View OGDP, beginning with alternate location 1. The advantages associated with this location included it being located outside of high priority habitat, wetlands, and floodplain designated areas, not being located within a disproportionately impacted community, and not being located near a school or child care facility. The disadvantages or potential impacts that we identified with this location included having 2 residential building units within 2,000 feet of the location, neither of which that would be subject to a surface use agreement on the property. At one point in time, PDC did inherit a surface use agreement on the subject property through a company acquisition. However, this SUA has since expired and is no longer valid nor effective. Additionally, we identified concerns with the existing overhead power lines creating setback concerns, a disruption to irrigated farm ground, and feasibility and safety concerns related to the planned access for this alternate coming off of Highway 60 and crossing existing railroad tracks. The biggest concern that was identified with this alternate was its overall location as it related to the current and future development plans of the town of Johnstown and Milliken, as well as it being located along the main thoroughfare or corridor between these two municipalities. Through our community outreach efforts in this area and our extensive communication with local municipalities, this area was identified as an area for future growth and development for both commercial and residential, with near-term plans for development of the lands located just west of the alternate. It is important through the alternate location analysis process that we not only evaluate the present receptors that we see today, but also consider the receptors that may be present in the later life stages of these oil and gas locations. As we will see later in this presentation, when we looked at the proposed location, PDC was successful in selecting a location further set back from Highway 60 with far less potential future impacts to the growing development in this area. We'll now look at the second location that PDC fully evaluated through the ALA process for the Mountain View location. The location is not located within a disproportionately impacted community. The natural topography of this location provided a sort of natural screening from existing development in the area, and we initially saw this location as a good potential candidate for oil and gas development due to the existing industrial use nature of the subject property. However, once we fully evaluated this location, several receptors or concerns were identified that deemed this location to be far more potentially impactful than the proposed. This location currently has 105 RBUs within 2,000 feet, with more residential development planned in the future. It was also discovered that this location is within 2,000 feet of a school and/or childcare facility property line, located directly west of the alternate location. It is located within HPH, being Aquatic Native Species Conservation Waters, located adjacent to the town of Johnstown's pedestrian walking trail, and would likely have required an additional oil and gas location to fully develop the proposed mineral development area as we see it today. Alternate location 3 was a location PDC identified as lands that could potentially accommodate an oil and gas location and provide the ability to develop the entire Mountain View unit from a single location. However, many concerns were identified as we fully evaluated the subject alternate. One of the immediate concerns that PDC identified was the difficult access to this alternate, located off of Highway 60 and County Road 19. Additionally, through our preliminary consultations with local government and discussions with this alternate, there were concerns raised with the planned future bridge construction on County Road 19 and the additional impacts that could be created by an oil and gas location in the same proximity. Through our consultations with the surface owner of the subject property, the owner conveyed that they would not execute a surface use agreement at this location due to the impacts it would have on both their current farming operations as well as future development opportunities on the lands. We also identified similar concerns to alternate 1, being that this location would be in close proximity or just off of the main thoroughfare between town of Johnstown and town of Milliken, and recognize the visual impacts this location could potentially create. While the map for alternate location 4 speaks volumes as to why this location was deemed far more potentially impactful than the proposed location, it was important that we included this alternate in our assessment, as it is a part of the evolution of the Mountain View development plan and a contributing factor to our efforts of consolidating this plan to one single oil and gas location. Alternate 4 was a location that was identified through preliminary discussions with local jurisdictions at a time when PDC was planning 2 separate locations in which to develop the mineral unit we see today. This location presented an opportunity to consolidate new wells to an already existing oil and gas location. However, it would have still required an additional oil and gas location to fully develop. After fully evaluating, PDC confirmed this alternate would be within high priority habitat, floodplain, and within 2,000 feet of encroaching development from the town of Johnstown. Now that we have looked at the first 4 alternates that PDC fully evaluated as part of the ALA process for the Mountain View development, we'll now look at the proposed Mountain View location and discuss the reasons why PDC deemed this location to be the preferred and least potentially impactful to public health, safety, welfare, environment, and wildlife resources. The proposed location is located outside of high priority habitat, no surface occupancy, wetlands, and/or floodplain designated areas. PDC has executed a JDA, or Joint Development Agreement, with the owner of the subject property and a solar company who also has plans for solar development on the subject property as well. This location is not located within a disproportionately impacted community and not located near a school or childcare facility. One of the biggest benefits that PDC recognized with the proposed location was the opportunity for a consolidated energy footprint in an area that, as previously mentioned, is destined for future residential and commercial growth. Through the ALA process and our consultations with surface owners in the area, we identified that this surface owner had already planned to designate these lands to energy development, and we were able to open up communication with both the surface owner and the solar company in which the owner had already been working with on a development plan to do so. Through these discussions, we realized the benefits of working together to avoid creating a separate footprint elsewhere in the community, and through a joint development agreement, successfully created a plan to consolidate both solar and oil and gas development to the subject property. While the proposed location does have 4 RBUs within 2,000 feet of the working pad surface, the 2 closest RBUs are owned by the surface owner of the subject property and subject to the JDA. PDC has conducted several consultations with the owners and tenants of all 4 RBUs within 2,000 feet, and again has obtained 100% informed consents from the owners and tenants of these RBUs as well. With that, we'd now like to take a bit of a deeper dive into the community outreach efforts that were conducted in association with PDC's proposed Mountain View development. As with all of our development plans, we find it crucial to conduct our community outreach efforts both early and often, and continue these efforts throughout the cycle of the project. As it pertains to the proposed location for the Mountain View development and the RBUs within 2,000 feet, PDC has conducted multiple individual meetings with the owners and or tenants of each of the 4 RBUs, beginning at the early stages of our planning process, and most recently as just this past week, to inform these owners of the site's progress through the permitting process, as well as remind them where to find the information in their informational booklets regarding the ECMC permitting process and hearing. Additionally, in these informational booklets, these owners were provided specific details regarding the proposed Mountain View location and the proposed operations associated with it. We always ensure that these owners have a personal point of contact within PDC that they can reach out to at any time should any questions arise. PDC also sent pre-application notices to not only all residents within 2,000 feet of the proposed location, but also parcels as well, in accordance with Weld County's notice requirements. In regards to these 4 RBUs, PDC did not receive any major concerns regarding the siting of the proposed location or the operations specifically. Some of these owners did cite minor concerns with the maintenance of the county road in which PDC has proposed utilizing as part of our haul route to this location. However, these concerns were addressed by PDC providing information of our planned maintenance for this road as part of our siting requirements with the local jurisdictions. In addition to our consultations with the residents within 2,000 feet of the proposed location, PDC also conducted in-person consultations with the 1 residential building unit just outside 2,000 feet to the northwest of the location, as well as all RBUs along the proposed haul route to and from the location. The feedback that we received from the owner just outside 2,000 feet from the proposed location was that they were in support of oil and gas development and had no concerns with our proposed plans. They also mentioned they recognize Colorado has some of the highest standards for oil and gas operations in the country, and that this would ease any of their concerns if they did have any. Feedback we received from residents along the haul route was similar to the feedback we received from the residents within 2,000 feet of the location. That being no concerns as it pertains to our planned operations or the proposed location of the site, only that we have plans to properly maintain the haul route and that our vehicles operate in the safest manner possible. Again, these residents all received a personal point of contact within PDC and or Chevron that they can continue to communicate with throughout the life of the project. Section 6 of the presentation outlines the current status of PDC's local government approval for the Mountain View location. Weld County is the relevant local government to the Mountain View location. PDC obtained Weld County approval for the Mountain View location on February 29th, 2024, recorded in the records of Weld County on March 20th, 2024. There are 2 proximate local governments to the Mountain View location, the town of Johnstown and the town of Milliken, both of which were invited and or participated in the Weld County pre-application process, as well as the WOGLA hearings pertaining to the Mountain View location. PDC recognized that this location was essentially at the intersection of 3 local governments, and it took extensive communication and coordination with each to arrive at a plan that all were comfortable with. This included an on-site meeting with all 3 local governments to discuss the least potentially impactful haul route to this location, as well as best management practices to utilize for this haul route. I will now turn it over to Tammy Waters to provide additional details on the proposed location for Mountain View OGDP.
Thank you, Corey, and thank you, Commissioners. My name is Tammy Waters, and I'm a permitting coordinator with Chevron. I will be reviewing our consultation with CDPHE and our best management practices for the Mountain View location. PDC consulted with the CDPHE on the Mountain View location on July 26, 2024, and agreed to the BMPs as summarized in the consultation letter included with the Director's recommendation. These BMPs include our commitment to oil, gas, and produced water takeaway, a hydraulic fracturing fleet that utilizes Tier 4 or equivalent engines, and several ozone mitigation BMPs. The Mountain View location will have an electrified production facility, and we commit to continue working with the utility provider to provide highline power for our drilling operations. PDC has been diligently working to obtain electrical services for our Mountain View OGDP for several years. We started conversations with Xcel Energy in mid-2022 and submitted an application to Xcel in March of 2023. In December of that same year, Xcel Energy advised us that they did not have the capacity or the infrastructure to support the Mountain View project at this time. To continue our efforts for electrification, PDC then started discussions with Poudre Valley REA. Over the course of several months, PDC and Poudre Valley REA were able to negotiate an electrification plan for the projects, and in June of 2024, an agreement was signed to procure electric service. The project is currently in the design phase with the utility provider. Our locations and BMPs are designed to protect public health, safety, welfare, and environment and wildlife resources in accordance with state law and ECMC regulations. PDC recognizes and applies protection hierarchy as required by this commission. PDC's locations avoid receptors when at all possible, and if not possible, minimizes impacts to the surrounding residents and communities and mitigates such impacts through extensive best management practices. As you heard from Corey, our land department worked extensively with the surface owner to design a location that avoids all high occupancy building units, schools, and childcare centers. We are outside of high priority habitat and disproportionately impacted communities. And we have obtained the requisite informed consent from each surrounding residential building unit owner. We avoid spills by utilizing tankless hydrocarbon storage and avoid unnecessary truck traffic by utilizing a pipeline for oil, gas, and produced water takeaway. PDC will minimize light and sound impacts by installing temporary sound walls during drilling and completions and utilizing a quiet frac fleet. While the primary purpose of the sound walls is to reduce drilling and completions noise, they also serve to contain artificial lighting within the walls. Light fixtures will be installed on the inside of walls and pointed downward during pre-production activities. As outlined in our noise mitigation plan, PDC will conduct continuous noise monitoring during pre-production operations. The Mountain View location will include continuous air monitoring that is in accordance with the approved air quality monitoring plan from CDPHE. PDC will construct an automation tower that provides site security, remote shut-in capability, and 24/7 remote monitoring. The map you see on this slide depicts the Mountain View OGDP with the proposed location in the center of your screen. The OGDP is outlined by an orange dotted line, the existing locations are represented by green dots, and the producing wells are yellow dots. The map also shows shut-in and temporarily abandoned wells. The blue lines outline various water bodies within the area. And it's difficult to see on your screen, but we also show high priority habitat areas shaded in orange, pink, and blue. You can see several subdivisions and the Big and Little Thompson rivers running right through the development area. This map also shows just a small portion of the town of Johnstown on the west, and on the east side of the map is the town of Milliken. While you may not be too familiar with these two towns, you have probably heard of or been to a Buc-ee's. I mentioned Buc-ee's because it's been a very big deal for northern Colorado, and it's just on the outskirts of the town of Johnstown. And you could say the heartbeat to Johnstown. the heartbeat to Johnstown, paving the way for commercial and residential development in this area. This is just one of the reasons why PDC consulted early on in the planning phase with staff from both of these communities, and their feedback was vital in our site selection process. The Mountain View development is beneficial to these two small towns because many of the existing wells on this map are nearby neighboring houses, schools, and recreational areas. The Mountain View OGDP develops approximately 3,520 acres from 24 wells, with a permanent footprint of 7.4 acres. We plan to plug and reclaim 42 existing wells and 21 facilities within the development area and return approximately 50 acres of land back to surface owners. When you take into account the 7.4 acres for the Mountain View OGDP, this is a net return of approximately 43 acres of land to landowners. Drilling down even further on this map, you can see one example of the beneficial impact that the Mountain View development will have on the town of Johnstown. There are a handful of existing wells shown in the center of your screen. Two of the wells are within approximately 1,600 feet of a high occupancy building unit, which is the YMCA of Johnstown. To the north of those same wells is a baseball field that is within a few hundred feet of just one of the production facilities that will be removed. South of the wells at the bottom of the map is the river and a walking trail for the town of Johnstown. Several of the wells that we commit to plug and reclaim are nearby this walking path, are within the floodplain and inside of high priority habitat. In summary, 43 wells will be plugged and reclaimed. This removes 28 wells within high priority habitat, 20 wells within the floodplain, 28 wells within 2,000 feet of residential building units, 2 wells within 2,000 feet of a school. We anticipate that this is a reduction of up to 8 tons per year in reduced VOC emissions just from the PDC owned wells. PDC recognizes the ECMC's desire for companies to focus on these types of high priority legacy wells in their P&A programs, and through the development of the Mountain View OGDP, PDC is fully invested in ensuring that the P&A of these high priority legacy wells results in the return of lands to the landowners and meaningful beneficial impacts to these two communities. I'll now turn the presentation back to Jamie Jost for our conclusion.
Wonderful. Thank you, Ms. Waters. So to conclude our presentation, PDC respectfully requests that this commission approve an approximate 3,520 acre OGDP for the production and development of up to 24 new horizontal wells from 1 new well pad, approve the associated Form 2A, and establish a 3,520 acre drilling and spacing unit for the production of oil, gas, and associated hydrocarbons from the Niobrara, Fort Hays, Codell, and Carlisle formations. Commissioners, thank you for your consideration of this application today. I'd like to now ask all of our subject matter experts to join us on video for any potential commissioner questions that you may have.
Thanks for dropping the screen share, and thanks for the panel being with us. And I don't know that I've got questions, but I would well, I'll let commissioners ask questions. I've got some comments. Looking around the room for commissioners with questions. I'm not seeing commissioners with questions, so I will move into comments and/or deliberations. I really appreciated slide 25, the avoid, minimize, and mitigate use of the hierarchy there, and just the general overall approach to, going what I would call sort of the best efforts in terms of trying to locate in the best location. Appreciated the informed consents, appreciated the work with the relevant local governments. We heard from Mr. Maxey, there was a lot of work there with the haul route, which is not something that we normally get involved with, but all of that is very much appreciated. I thought this was a thoughtful and well-constructed OGDP. Other commissioners with comments? Commissioner Messmer?
No, I agree with that, particularly the mitigation hierarchy piece, but I'll add on that, the plug and abandonment and retirement of 42 wells and associated facilities that's huge, and really appreciate that being a part of this application. And I think some of those obviously are done from an operational standpoint, but it's clear that not all of them are done from an operational standpoint. And that says a lot about the approach that this operator is taking, and I appreciate that.
Commissioner Cross?
Thank you, Mr. Chair. I'll just be brief and say I agree with both your comments and Commissioner Messner's comments. I appreciate the hard work on this, the efforts to co-locate with the solar development as well and avoid future development, which I think is an important aspect as well, especially as we look at a lot of what we did with our cumulative impacts rulemaking and the reasonably foreseeable future development. So I'll go ahead and move for approval of the application.
Second. Further discussion on the motion? Further deliberation? All those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you very much, and we thank staff as well for the good work that led to this approval.
Wonderful. Thank you, Chair. Thank you, Commissioners.
Hearings Manager Thomas, can you elevate? Or actually visualize?
Apologies, a little bit of a delay on my Zoom. Camera
Well, we can
should
hear
work
you.
soon.
That's good enough. I'm just trying to figure out next steps. It's 11:40. We did want to get back to the original Fund Air one, but I'm not sure if we're ready for that yet. Do you have you talked with Mr. Moret and or the applicant?
My understanding is they are prepared to go. Mr. Moret is here, and we're only promoting Mr. Moret, Ms. Wazelenki, and Ms. Smith from the Fund Air panel, so we can get them all up here now.
Okay, let's go ahead and get that done. Ms. Wazelenki, you're elevated first, and it's your burden, so I would recognize you first if you had anything preliminary to talk about.
Yes, thank you, Chair. We did have a conversation with Mr. Moret. I see him here on the panel. We are, I would say, on the same page. We do have some COA language. We literally were emailing seconds ago on that. And I had one question for staff, which I don't believe was answered. I don't think it's material, but it would just be a clarification in Mr. Moret's email. So our proposal was to perhaps share an email with you that has some proposed COA language, which in essence would require Fund Air to consult with CPW should operations extend beyond December 15th. And so that's our proposal and agreement, and happy to have Mr. Moret share his perspective, or we could simply share the email if that's more efficient.
Why don't you go ahead and do your piece, and then I'm going to ask Mr. Moret to comment on it.
Sure. Let's see. Sydney, would you be able to share your screen with that email? And I'm also happy to try that on my end.
Yep, absolutely. Let's see here. Can everybody see that?
Yes. And so maybe if you could start from the bottom. Yes. So the language we had proposed, and I'll read it into the record. If any operations on the Wild Horse 04 location, which is an existing location and has this reference location ID 426426, extend beyond December 15. I didn't put a year in that because we're assuming 2024. However, it would apply to any winter season. Fund Air will consult with CPW. So that was the proposed language. And then if we scroll up to Mr. Moret's response, I can let him speak to that. But he does agree with this language for the reasons that are bulleted in that email. My only clarification is in his last paragraph where he says, and I'm just trying to find the language. Thank you. Should CPW appreciates the COA, should an unexpected sundry be needed for a permitting delay? And I don't believe a sundry would be needed for any permitting delay, which was my only matter of clarification. So those would conclude Fundare's comments on this.
All right, if we could, I'm trying to find Mr. Moret. Hey, do you want to provide any input here to this? Did you get a chance to understand some of the questions from commissioners earlier? And we really appreciate you appearing earlier today to, or appearing now to help us get perspective on this.
For sure. Thank you, Chair Robbins. Can you hear me okay?
Yeah.
And for the record, my name is Brandon Moret. I'm a certified wildlife biologist with Colorado Parks and Wildlife. My apologies for missing the hearing earlier today. I had a previous commitment, but yes, I was able to turn on a dime and understand the conversation and the concerns that the commissioners had as far as when CPW starts every consultation, we initially start with just avoiding the entire winter season, but we also know that's not entirely realistic. This is a 1202D habitat. Fundaire could have said, we're not going to pay the higher amount. We're just going to pay the non-winter amount. That would have been a very different conversation, Chair Robbins and commissioners. But given that they are paying the higher amount, which is 1.75 times higher, and them doing everything they can do to expedite both the permits with BLM and ECMC, CPW is comfortable with this addition of this COA should things happen. But again, that's not Fundaire's expectation, as far as my understanding, with this proposal.
Questions, commissioners, to either the applicant or Mr. Moret? Commissioner Ackerman?
Thank you, and I really appreciate the work that you did behind the scenes to work on these questions. Thank you very much.
My pleasure.
So as I understand it, this is aimed at Mr. Moret. As I understand it, the COA at the bottom of this email string is simply consultation with CPW should operations run beyond that date. I think was the 16th. And clearly that would just require consultation if we were to adopt that language, and would not require, as per our regulations, any further action on the part of Fundaire. And so that consultation hurdle would be met if they simply chatted with you. And I just wanted to ensure that you're comfortable with that, and that any stipulations that would then be implemented would be voluntary at that stage under this language.
Yes, and I appreciate the clarification, Commissioner Ackerman. And when we have consultations with operators, I've had consultations where they're in the middle of nowhere, but this isn't that case. This is near an existing access road. It's between two existing locations. There can be a handful of different outcomes here. My expectation is that Fundaire will continue to not only reach out to me, should it happen, and again, it may not happen, but that this OGDP is protective, because they're going to be installing a sound wall and constructing it before December 1st. And they have all the infrastructure on there. They just need to expand this existing pad and drill and complete. And it sounds like it's only 2 out of 12 wells. Is that accurate?
That is correct.
Thank you. I just wanted to ensure that you understood that, if that's indeed the COA that we're looking at.
Other questions for the panel? All right, seeing no further questions, I too want to thank the applicant and Mr. Moret for the quick diligence here. Appreciate the fact that I think we've gotten to a better space. Would want to possibly recognize Commissioner Ackerman, since this is his piece, if he wanted to weigh in on deliberations now that we've had these clarifications.
Thank you. I appreciate that, Mr. Chair, and recognize that this was brought up largely because there was a statement in the CPW consultation. I think we can kill the presentation at this point if you don't mind.
Yeah, that's true. Thanks.
Largely because in the CPW consultation, there was a statement that specified the CPW's understanding was that this would last no longer than a couple of weeks, about 2 weeks, I think was the language, into the winter season. And therefore, the commission had to take at face value that CPW's consultation was based on that understanding. We didn't find that anywhere else in the materials, including the Wildlife Mitigation Plan, which is the wildlife driving document on OGDPs. And so it was definitely ripe for clarification. And as is often the case, I certainly defer to CPW's professional expertise on these matters, and I appreciate them clarifying, at least clearing this up with this additional COA. I do still have some trepidation that, in my opinion, that leaves essentially an open time frame for this operator to work all the way through the winter timing stipulation season as it's currently presented. I think that was made known to Mr. Moret. I think Mr. Moret told us there were some mitigating factors outside. Number one, a motivating factor of having to pay more in mitigation the longer that the company goes on into the timing stipulations, and then a number of mitigating circumstances that minimize CPW's concern of moving through the winter. I generally am uncomfortable with a stipulation that states consultation is needed. You know, I would prefer that we strengthen that statement into consultation and best efforts to implement CPW suggestions resultant from that consultation. That would make me certainly more comfortable with that COA. And I'd be interested in hearing the operator's response to that request.
Ms. Wazelinski?
Thank you, Chair, and thank you, Commissioner Ackerman. I think that's a very reasonable addition to the COA language.
Commissioner Ackerman?
Thank you. And I appreciate you being willing to consider that. And I would be comfortable, given the conversation that's taking place here and that addition to the COA, moving forward with approval of this OGDP.
Is that in the form of a motion, Commissioner Ackerman?
I'd be happy to make a motion. I definitely am interested to hear other commissioners' thoughts if they have.
Okay, we don't have a motion just yet, but we're looking for other deliberative thoughts, which, thank you, Commissioner Ackerman. That's actually the preferred course. Sometimes I get antsy. Commissioner Messner, you are recognized.
Appreciate Commissioner Ackerman's thoughts on this. Appreciate Mr. Moret for clarifying the consultation. For me, it was just, I didn't understand exactly what the expectation of the consultation was from a timing stipulation standpoint, and providing that clarity makes sense. I really appreciate Commissioner Ackerman's addition to the negotiated condition of approval. And so with those clarifications, I'm comfortable with the application.
Others with deliberative thoughts? I too am comfortable. I appreciate the work here by Commissioners Messner and Ackerman, as well as staff. Commissioner Ackerman?
Thank you, Mr. Chair. I certainly am willing to make a motion for approval of this OGDP. I think we probably might need AAG Davenport to ensure that we've properly included the COA in that motion.
AAG Davenport?
Thanks, Chair. Thanks, Commissioner Ackerman. I believe that the motion would be to approve the OGDP as presented and as recommended in the director's recommendation with the COA as discussed in the commission's deliberations today.
Thank you so much. Excuse me, I'm sorry.
I apologize. I'm not sure if we have a representative of staff present, but if staff unclear on the COA, then welcome staff to chime in. On the COA.
Yeah, I'm looking.
I'm not sure we have any.
Yeah, I'm not seeing staff either.
Thank you, Mr. Chair. So I believe my motion then would be to approve this OGDP as recommended in the director's recommendation with the additional condition of approval that if operations will extend past, was it December 16th? Is that right, Ms. Waselinki?
December 15th.
December 15th, then additional consultation with CPW is required, and this operator commits to best efforts to implement suggestions of CPW resultant from that consultation.
Second.
Motion and a second. Is there further discussion? All those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you, Ms. Waselinki. Appreciate the allowance of us to sort of work through issues as they come up. And again, I don't know if Mr. Moret's still with us, but appreciate his getting involved here this morning as well.
Thank you.
All right, commissioners, I would suggest we take a short break before we take up the last docket, which is going to take a while. It's 11:55, maybe return at 12:35, a little more than 30 minutes. Is that okay? All right, we'll see you at 12:35. All right, we are now going to take up two dockets at the same time, 2301-00033, an oil and gas development plan for extraction. As the applicant, it's called the Washington OGDP. And then at the same time, we're going to take up docket 2408-00202. It's a variance request for extraction relevant to the oil and gas development plan. I believe it appropriate that we take these matters up sort of at the same time, and we'll let extraction and their counsel, figure out how they want to present to us on that. Before we move into that, we do have some public comment. I had three folks that signed up. Ms. Paranos, you are one of them, and you are visualized. So if you'd like, go ahead and let us know who you're representing and provide us your public comment.
Great. Thank you so much, Chair Robbins. I'm Elizabeth Pranos. I'm here on behalf of the City and County of Broomfield today to provide public comment on the Washington pad. As a local government, Broomfield prioritizes the health and welfare of its residents. We routinely participate in state and federal rulemakings to protect air quality and respond to the climate crisis. We met with Thornton and Extraction on numerous occasions to recommend additional protections for the wash pad. We greatly appreciate Thornton's partnership and the commitments Extraction made to safer drilling practices, improved air monitoring, and the plugging and abandonment of existing older wells in Broomfield as a result of our comments and conversations. That being said, as a proximate local government, with residents living approximately 3,000 feet from the proposed location of the Washington pad, we are concerned with the potential for harmful emissions from the pad to adversely impact the health and well-being of residents living in proximity to the pad, to worsen regional air quality, and to contribute to the climate crisis. According to Colorado State Implementation Plan for Ozone, the oil and gas sector is the largest source of NOx and anthropogenic VOC emissions in the Denver Metro North Front Range non-attainment area, projected to emit approximately 68 tons per day of NOx and 90 tons per day of VOCs in 2026. This is 3 times the amount of emissions from mobile vehicles. The oil and gas sector is the largest source of methane emissions in the state, responsible for approximately 60% of the methane pollution in Colorado in 2019, according to CDPHE. According to Extraction, the Washington pad will emit approximately 31 tons of VOCs, 115 tons of NOx, 1,164 pounds of HAPs, including 372 pounds of benzene, and 6.7 tons of methane. That's in the first year of production and during pre-production activities. Despite being constructed and operated with state-of-the-art technology such as electric drill rigs and a tankless production facility, the Washington pad will still release harmful smog-forming, climate-altering, and toxic air pollutants. The North Front Range ozone non-attainment non-attainment area has failed to meet federal health-based standards for over a decade. Ozone poses a serious public health risk, in particular to children, the elderly, and those who spend time outdoors. In addition to contributing to ozone, NOx emissions are a precursor to PM 2.5, impair visibility in Class 1 areas such as Rocky Mountain National Park, and contribute to nitrogen deposition that harms biodiversity. Ozone also contributes to the climate crisis. In May 2022, Broomfield made available the results of a health study finding that people living near unconventional oil and gas facilities may be at risk of developing acute and non-acute adverse health symptoms. The results of the health study document an increase in the reported frequency of adverse health symptoms by persons living within 2 miles of the 6 existing multi-well sites operated by extraction in Broomfield. This finding is consistent with findings from other scientific studies that demonstrate an increased risk to public health for persons residing near oil and gas facilities. A recent peer-reviewed paper published in Atmospheric Environment, authored by researchers at CSU and Ajax Analytics, found that even oil and gas operations that include many best management practices still emit concentrated VOC plumes, at least for short periods. This finding was based on extensive air monitoring conducted in Broomfield between October 2018 and December 2022, when drilling and completions were occurring. Broomfield's experience with state-of-the-art oil and gas production facilities indicates that even such facilities can contribute to air pollution and resulting public health impacts. We strongly disagree with Extraction's cumulative impacts plan in that it indicates emissions from the Washington pad will have no negative impact on the surrounding community. This conclusion is based on a flawed study undertaken during select production activities at 2 of Extraction's well sites in Broomfield. We have pointed out numerous errors in the study's methodology and findings. Our air quality monitoring data, conducted at the same time, found very different results, and our residents' experiences do not support the conclusion that pre-production activities do not cause impacts to the surrounding residents. We object to the use of the CTEH study in Extraction's cumulative impacts plan and as support for any future cumulative impacts analysis in future OGDP or CAP applications. Thank you very much for providing us the opportunity to comment on this OGDP.
Thank you for the comments on behalf of the City and County of Broomfield. Next is Travis. And Travis, I do not know how to pronounce your last name, so I'm not even going to try, but you're recognized. You'll need to unmute.
It's all right. It is Bidelic. Most people usually cannot properly pronounce that. So no, I wanted to just comment from a private individual standpoint. So as a landowner, surface owner, and mineral owner in Adams County and Weld County, I think this development that Extraction Civitas is proposing, is, as mentioned, definitely state of the art. They've been cooperating with surface owners, with mineral owners. This development, they're taking the proper practices needed to develop it from an environmentally appropriate standpoint, from electric drilling rigs, Tier 4 frac fleets. It'll be tankless facilities. Everything will be piped in, piped out. It's going to produce very little traffic as far as once completions are commenced at the facility. I think they're definitely taking the right standpoint to be able to assure us as mineral owners that the minerals that we own are able to be effectively environmentally friendly and economically produced. I think, as Colorado continues to grow, we are a very high consumer of energy in the nation, and we definitely need responsibly sourced energy. And I think Colorado probably sets the bar on that. If you look at some of the other states where there's energy production, I definitely feel Colorado sets the bar on the standards we hold our operators to, etc. And I think this is a very, very feasible development. It's going to bring numerous economic benefits to the state from a tax perspective, revenue perspective, as well as producing clean energy. As we transition more power plants to natural gas, etc., there's only going to be more need for natural gas within the state. And I think as state government entities, this is definitely something we need to look at approving.
Thank you for the public comment. We appreciate you being with us this afternoon. There was one other person that signed up. That is Wells Fitzpatrick. Mr. Thomas, are you able to find Mr. Fitzpatrick? There he is.
Hey, how
Go
are
ahead.
you? Thank you, sir. Good afternoon. Obviously, I want to thank the commission and the commissioners for allowing me to speak today. Like the last speaker, I wanted to give a perspective as a mineral owner in the proposed Washington development. My firm is a small employee-owned investor in mineral rights. We have no outside money. We've been active in Colorado for well over a decade, and we're proud that all of our employees get to have an equity stake. So the Washington pad is our largest asset, and that flows directly through into that equity program. This isn't yacht money or Butler money. This is mortgage money, rent money, tuition money. So stranding these resources would have a real substantial negative impact on us and on dozens of other mineral owners. So I'd like to respectively voice my support for both the Washington pad and the associated variants. Thank you again for the time. I appreciate the ability to speak to the commission.
Thank you, Mr. Fitzpatrick, for taking time out of your day to present to us on this proposal. All right, with the public comment out of the way, procedurally, we would recognize Mr. Pershala and or his witnesses. Before we get to your witnesses, Mr. Pershala, either through my review of the record or through conversations that I've had with hearings manager Thomas, I just want to make sure that you are ready to present and you'll take the time you needed, but you're not going to take more time than is needed. I got a sense that you've got a lengthy presentation, in particular on the variants. It's all briefed. We're all aware of it. We've all done this a number of times. I'm not trying to undo any due process for you. I'm just giving you a healthy reminder that we'd love to hear your case and be able to get to it this afternoon. That's number one. Number two, we're going to need to take a break at 1:55 to 2:30 to accommodate another hearing that our Attorney General has to attend on behalf of ECMC. So if we get to that point and we're not done, just FYI, we'll be taking a 35-minute break to let Kyle go attend a different matter.
We will endeavor to get done in that time frame. I mean, we should be really close. Yeah, the variance component, we just have a lot of information that we think is relevant, and we really want to make sure we take our time and present that to you. This is a novel issue. We have not had this before, and so perhaps we're being overly cautious, but we feel like making sure you have more information is always better than less. So with that said, I'm looking at the panelists, and I see everyone except for Dr. Ramey.
Currently, we're unable to find Mr. Ramey in the attendee list. If he could raise his hand, and excuse me, Dr. Ramey, if he's able to raise his hand, we will elevate him as soon as we see him. I see someone raising their hand under the name Laura Brown, so we will raise them. I assume there was an issue there.
Yep. Thank you.
Then if we could get the witnesses to all visualize, we'll have AAG Davenport go ahead and swear in the witnesses.
Okay, as folks are coming up, I'll go ahead and get started. I'm going to ask each of the witnesses to raise their hand and state that they swear to tell the truth. I will start with Ms. Hubbard, please.
Lila Hubbard, I swear to tell the truth.
Thank you. Ms. Gutierrez?
Ana Gutierrez, I swear to tell the truth.
Thank you. Mr. Flanagan? Sorry, sir, you were on mute.
Apologize. Sean Flanagan, I swear to tell the truth.
Thank you. Mr. Annable?
Jeff Annable, I swear to tell the truth.
Thank you. Mr. King?
Clint King, I swear to tell the truth.
Thank you. Mr. Bennett?
Good afternoon, Nathan Bennett. I swear to tell the truth.
Thank you. Mr. Casper?
Good afternoon, Sean Casper. I swear to tell the truth.
Thank you. Ms. Stearman?
Good afternoon, Kathy Stearman. I swear to tell the truth.
Thank you. Sir, I apologize if I mispronounce your last name. Mr. Voito? And you are on mute, sir. Thanks.
You got it. Claude Boito. I swear to tell the truth.
Thank you. Thank you, sir. Dr. Ramey?
Dr. Rob Roy Ramey II. I swear to tell the truth.
Thank you. Have I missed anyone, Mr. Priscilla?
Don't believe so.
All right.
All right, then with that, Mr. Priscilla, as I mentioned in the outset, we're going to allow you and your team to present the case on both the OGDP as well as the variance. At some point, I need to recognize Brandon Moret from Colorado Parks and Wildlife on the variance piece. I would anticipate doing that after you're done with both of your cases in chief, if that sounds acceptable to you.
That's acceptable unless Mr. Moret would like to present first. We're happy to allow that to happen as well.
We don't. Number one, we don't have him up yet, and then number two, I think it would probably be helpful for you to set the stage with the OGDP presentation first, before we jump into this discrete issue relative to the variance. That's just my opinion.
Happy to proceed.
Okay, then the panel is yours.
All right, I'm going to share my screen, so bear with me here. And you all can see my screen, I hope, with a presentation.
Yes.
Excellent. Thank you. Great. Good afternoon, Chair Robbins, commissioners, and staff. My name is Joe Pershala with Wellborn, Sullivan, Meck, and Tooley, and I, together with my co-counsel, Ana Gutierrez, with Womble Bond Dickinson, represent Extraction Oil and Gas in this matter. Before you today are two applications, the Washington OGDP and docket number 2301-00033, and the associated variance application in 2408-00202. Before we begin, I'd like to extend a sincere thanks to ECMC staff for all of their significant work on this application. A thank you to the City of Thornton for its partnership and collaboration on the operator agreement, and a thank you in the work to Colorado Parks and Wildlife over the past year. Presenting for Extraction today will be Jeff Annable, Claude Voito, Lila Hubbard, and Dr. Rob Ramey. With Wildlife Science International, who's going to present expert testimony related to the variance application. There will also be Extraction representatives available to answer any questions that you may have. I'm going to try to move quickly, so I apologize if I'm talking quite fast. Normally I'd present a detailed overview of that OGDP. However, given the time constraints and the amount of material, I'm going to try to move quick and get through this. This is definitely a novel matter. It's not novel in the operational aspect, but due to evolving wildlife circumstances that are outside of Extraction's control. The Washington OGDP presents best-in-class development. As you will hear, Extraction has worked closely with the City of Thornton, surface owner, developers, all to accommodate the stakeholders' interests and concerns, much of which have been captured in the operator agreement with the city. You'll hear that Extraction performed a very thorough alternative location analysis to best avoid impacts to all receptors. And for the 3 RBUs that are within 2,000 feet, Extraction designed the location to have the wells and equipment more than 2,000 feet from those homes, and further continued consultations with those owners who ultimately provided informed consent. Accordingly, the Commission's review is under Rule 301A. Given the robust suite of operational commitments and best management practices, including electrified drilling rig and production facilities, Tier 4 better completions, 3-phase pipeline takeaway and tankless facility design, and more, this OGDP does avoid, minimize, mitigate impacts to public health, safety, and welfare of the environment and wildlife resources. Now, when this OGDP was planned and when it was submitted and passed completeness in October 2023, and at the time of the original scheduled hearing in this matter in December of 23, The location was entirely outside of all then existing mapped high priority habitat buffers, and as relevant, the bald eagle buffer. Importantly, though, Extraction voluntarily continued that hearing to evaluate this change in wildlife circumstances. The location should therefore be reviewed under the HPH buffers and rules existing in October of 23. The director and staff have reviewed and re-reviewed the Washington OGDP application. The December 1st, 2023 director's recommendation recommended that the commission approve the application with no conditions of approval, and the addendum that was issued October 11th, 2024 does not alter that recommendation. No petitions or interventions have been filed, and Extraction requests that the commission approve the OGDP. Now I'd like to turn briefly to the variance application. As alluded to, following completeness, a bald eagle's nest was discovered that is within a quarter mile of the Washington pad. While this development should not impact the commission standards of review for the OGDP, ECMC staff believe that this development and subsequent HPH mapping update in 24 resulted in the application of Rule 1202C to the operations on the Washington pad. As set forth in the variance application, Extraction disagrees with staff's position. Nevertheless, as you will hear, the Washington development is the culmination of years of planning and work with all stakeholders, which would be upset absent this variance. Accordingly, a variance should not be necessary because Rule 1202C and the HPH mapping layers in effect of October 23 should apply to the commission's evaluation and approval of the Washington pad OGDP, the associated 2A, and all related operations, including Form 2 APDs. Now, even if the commission determines that the 2024 bald eagle HPH was to apply to any part of the Washington pad operations, Extraction will demonstrate that a variance is appropriate under Rule 502C. Extraction will first show that through its extensive ALA evaluation, both pre and post nest discovery, as well as its good faith collaboration with CPW, it has made good faith efforts but cannot comply with Rule 1202C1G. As set forth in the application itself, a variance of this nature does not violate the basic intent of the Act. In fact, the mission change statement of basis and purpose expressly addresses this and suggests that variances are appropriate where circumstances show that the variance is equally protective of the wildlife resource. Thus, a variance does not violate the basic intent of the Act, and as will be shown today, Extraction's best management practices and seasonal avoidance commitment will provide protections equivalent to the Rule 1202C1G quarter-mile buffer. As to undue hardship, the statement of basis and purpose acknowledges that undue hardship involves many considerations, including financial, inability to access minerals, significant construction requirements, and other geographic considerations. As will be shown, moving the location to any potential alternative site will actually result in a greater number of human receptors within 2,000 feet of the pad, will result in stranding significant mineral resources to the detriment of mineral owners that you've heard from this morning, will impact the removal of legacy wells and infrastructure in surrounding community, will negatively impact the ability of other stakeholders, including the surface owner, to proceed with their planned development, and thus an undue hardship will not just befall Extraction, but all stakeholders and surrounding community members. With regard to no net adverse impact, Extraction will show that through fact and expert witness testimony that the BMPs and seasonal avoidance will provide protections equivalent to a quarter-mile buffer, and thereby avoid any net adverse impact to wildlife. And I'd also just point out that director recommendation has already determined that the pad operations will not have an adverse effect on public health, safety, welfare, environment, and wildlife resources. And finally, Extraction will show that its committed BMPs, nest monitoring, and seasonal avoidance will protect the wildlife resources such that no conditions of approval or other mitigation measures are necessary. With that, Extraction requests that the commission approve the variance application. I'm going to move through the first couple slides here and then turn this over to Mr. Annable. Just setting forth, this is the outline of the presentation. We'll cover the general location information and alternative location analysis, the procedural background and community coordination and outreach, the development plan timeline and BMPs, and then, of course, the director's recommendation and summary request for approval. This is a list of the presenters who have already named. And with that, I will turn it over to Mr. Annable.
Thank you, Joe, and good afternoon, commissioners. I appreciate your time and attention as we present our Washington OGDP I'm Jeff Annable, Manager of Well and Location Permitting at Civitas Resources, the parent company of Extraction Oil and Gas. Next, I'd like to provide some general information about the Washington OGDP and discuss alternative location analysis. The Washington OGDP consists of one new oil and gas location, the Washington Pad, which is located in the northwest southeast of Section 10, Township 1 South, Range 68 West, adjacent to I-25 and E-470. Relevant local government, City of Thornton, has approved the location via an operator agreement and local permit. This location is proximate to Adams County and the City and County of Broomfield, and the working pad surface is within 2,000 feet of 3 residential building units, with the closest being 1,820 feet away. All of the RBUs are greater than 2,000 feet from the proposed wells and facilities. 2 ALA triggers are triggered as a part of the location siting, which is an RBU is less than 2,000 feet from the working pad surface, and there are wetlands immediately down gradient of the location. The OGDP covers a total of 1,614 acres, 14.2 acres, which includes the surface location, a 640-acre modified drilling and spacing unit, and a 960-acre proposed drilling and spacing unit that will be developed by a total of 10 wells. The project received 4 public comments from local authorities and stakeholders, including Adams County, City and County of Broomfield, mineral owners, and the prospective surface owner. Next slide. Next, I would like to cover the cultural features adjacent to the proposed Washington Pad. While there are 3 RBUs within 2,000 feet of the working pad surface, all 3 of these RBUs have signed informed consents, and all of them are greater than 2,000 feet from the proposed wells and facilities, satisfying condition 604B1 and 604B3. There are no schools, child care centers, high occupancy building units, or designated outdoor activity areas within a half a mile, no public water systems, riparian corridors, or high priority habitats within 2,000 feet of the working pad surface at time of submittal. There was a disproportionately impacted community within 2,000 feet. The nearest RBU in that community was greater than half a mile. It is important to note that there are no DICs within 1 mile of the working pad surface per the May 2023 map update. Now I'd like to cover the alternative location analysis that was performed as a part of this development. We investigated a total of 6 alternative locations as shown on the map. Here is alternative location number 1. This is south of the proposed location and is within 2,000 feet of approximately 24 homes and 1 child care center. This alternative location was contained within a prior SUA, but after further investigation, the proposed Washington location was determined to be more compatible with the planned commercial development and nearby residential communities. Therefore, this SUA was vacated and this location was vacated as an alternative. Next is alternative location number 2, which is further south. As you can see in the map, this location is not compatible with the ongoing commercial development in this area. While this is evident now, when our ALA was performed, this was still an open field. Additionally, it is within 2,000 feet of 6 RBUs and 15 high occupancy building units. Next slide. Next is alternative location number 3. This location is northeast of the proposed location on the other side of E470. When the ALA was performed, this was within a half-mile buffer of a previously mapped eagle nest, but was ultimately eliminated as an alternative since the property is encumbered by a proposed development application. Next slide. Next is alternative location number 4. This location is east of the proposed location on the other side of Washington Street. Due to the proposed commercial development at the time of the ALA, this location was not available. Additionally, it would have had more receptors than the proposed pad with 5 RBUs and 1 child care center within 2,000 feet of the working pad surface. Next is alternative location number 5. This location is southeast of the proposed location on the other side of Washington Street. This alternative was eliminated as an alternative since it would be within an intermediate buffer of a type 3 aquifer and be less than 2,000 feet from 8 RBUs and less than 1,000 feet from a child care center. Alternative location number 6 is the last alternative that was investigated as a part of the OGDP AOA. This location is northeast of the proposed location on the other side of E470. This location would be sited in the quarter-mile buffer of a previously mapped bald eagle buffer, as well as within 2,000 feet of approximately 155 RBUs. This location was eliminated as an option because we would not be able to obtain an SUA for this location, and there are far greater receptors within 2,000 feet. Now I'd like to hand the presentation over to Claude Boiteau to discuss the procedural background and community coordination.
Thanks, Jeff. And good afternoon, commissioners. Thank you for your review of this OGDP. My name is Claude Boiteau. I'm a development engineer representing Extraction Oil and Gas and Civitas Resources. I'd like to speak for a few minutes on the procedural background of the Washington development. The proposed location was identified in conjunction with the surface owner, the City of Thornton. It was chosen to maximize distances from RBUs and schools, to benefit from proximal and existing oil and gas infrastructure, facilitate efficient traffic routing, and minimize conflict with existing high priority habitat. Additionally, the location is supported by the existence of a surface use agreement. The proposed location maximizes distances from receptors, minimizes cumulative impacts, and prioritizes infrastructure alignment. Next slide. Thank you. Extraction has been working collaboratively to pursue the Washington development for the better part of 10 years. In late December of 2020, the pre-application was submitted to the City of Thornton. Over the subsequent years, a multitude of meetings, negotiations, and stakeholder engagements resulted in a finalized and approved operator agreement in the fall of 2023. After additional engagement with ECMC, the OGDP was originally scheduled for an application hearing on December 14, 2023. I'd like to review the community outreach that occurred as an important component of the development of the operator agreement. At the request of the City of Thornton, the neighborhood meeting was conducted to introduce the proposed pad location to the community. Invitations were sent to 48 individuals, and an in-person meeting was held on November 11th, 2022. In addition to engagements completed at the community meeting, direct consultations were completed with representatives of the child care center located approximately 2,900 feet from the proposed working pad surface, and 3 RBUs located within 2,000 feet from the proposed working pad surface. No project concerns were expressed in either of these consultations. Further coordination was pursued with the City of Thornton, Adams County, and the City and County of Broomfield, resulting in the creation of and inclusion of a curated package of best management practices. These BMPs were included in the operator agreement and are reflective of the engagement of nearby communities and stakeholders. Additional engagement with the City of Thornton has been ongoing, and continued public questions and inquiries can be directed to the noted corporate. Oh, next slide, please. Next slide. There we go. We got a little out of order. That's okay. Additional engagement with the City of Thornton has been ongoing, and continued public questions and inquiries can be directed to the noted corporate informational services or emailed directly to Civitas staff at the listed contact. I'll note that the dedicated Washington email address has been operational since the public meeting in 2022 and has yet to receive any emailed inquiries. I'll now hand the presentation back to Mr. Annable to discuss the project schedule and cumulative impact mitigations.
Thank you, Claude. Next slide. Before you is a graphic that shows the anticipated operations along with the estimated duration of each operation. This work was originally anticipated to be kicked off June of 2024, but due to unforeseen delays, we are now planning to kick these operations starting in August of 2025, pending approval from the Commission. Next slide. Now I'd like to cover our proposed cumulative impact mitigation and best management practices. To start, I would like to cover the cumulative impact mitigation that is provided as a part of the siting. The Washington pad is adjacent to major transportation corridors, which minimizes impact to local transportation corridors. We also have access to 3-phase takeaway, which eliminates the need to truck products and waste from the production operations. We have sited and oriented the pad in a way that locates the wells and facilities greater than 2,000 feet from the nearest RBU, as well as keeping high occupancy building units, designated outdoor activity areas greater than a half a mile from the proposed working surface. Finally, the location is compatible with the future commercial warehouse development that is planned around the location. Next, I would like to go over the cumulative impact mitigation measures that will be implemented during operations. First, I'd like to start with construction. The permanent size of the location is minimized since this is a tankless location. We will be routing traffic outside of commuting and school hours. Additionally, we will use the best management practices listed to further reduce dust, potential impacts to wildlife, and topsoil preservation. Next slide. Prior to pre-production operations, we will implement ambient air monitoring that factored in early stakeholder input with local government. There will be 3 monitoring stations around the proximity of the pad, with 1 additional monitor on the west side of I-25, sited in collaboration with the City and County of Broomfield. All air monitors have the ability to take SUMA canister samples for laboratory speciation, as well as Civitas always remains open to enhancing monitoring as technologies improve. Now I'd like to go over drilling operations. Extraction is proud to be able to commit to utilizing a utility power drilling rig and Group 3 drilling mud, which minimizes emissions, noise, and odor from this pre-production operation. We will install 32-foot sound walls around the entirety of the pad for noise and light mitigation, and finally a polyethylene liner on location as an additional spill prevention measure. Next slide. Before we use a list of cumulative impact mitigation measures and site-specific equipment related to completions, I will go over some of the major highlights. A temporary lay-flat water line will be used to source water, minimizing truck traffic. A Tier 4 equivalent or better completion fleet will be utilized, lowering emissions. And again, a polyethylene liner will be used as an additional spill prevention measure. And finally, flowback will be routed through permanent production equipment, allowing gas to be controlled and sent down pipelines or combusted within 98% efficiency. Next, I would like to cover production operations. Extraction is proud to present a best-in-class facility design that is tankless, powered by utility power, serviced by 3-phase takeaway, and does not have permanent lighting. All measures aimed at minimizing potential impacts. Next slide. Finally, in addition to a best-in-class facility design, we will also be installing continuous leak detection system through the use of permanent optical gas imaging camera that performs a full inspection of the location every hour. Now I'd like to hand the presentation. As you can see in the screen, it shows how that imaging camera rotates around the pad. Now I'd like to hand the presentation back over to Claude to go over beneficial impacts.
Yeah, thanks, Jeff. Now I'd like to speak to the removal of legacy infrastructure. Approval of the Washington OGDP will enable the removal of 5 legacy wells and their associated infrastructure. This will include the retirement of roughly 4 miles of gas gathering pipeline. This legacy infrastructure currently exists near a school, childcare facility, and apartments. Removal of these legacy wells will eliminate 10 tanks, 5 separators, 5 meters, and roughly 8 tons of VOC emissions annually. 5 acres of surface land will be reclaimed as part of these abandonments. The elimination of this infrastructure is a key component of ongoing regional commercial development plans. Multiple surface owners and developers have submitted letters of support outlining the benefit this OGDP approval would have on their planned surface uses. I'll review the identified legacy locations now. Thank you. The Gonzales 1-2 is located within 2,000 feet of 13 homes in a mixed residential and commercial area. Next slide, thanks. The Bidelect 1-11 is located within 2,000 feet of 14 homes. The Shannon MD 14-5 is located within 2,000 feet of 4 homes, multiple commercial buildings, and a child care center. The Snyder 1-14 is located within 2,000 feet of 9 homes and Stargate School. And finally, the Schimpf 11-23 is located within 2,000 feet of 9 homes and Stargate School. And now I'd like to hand the presentation back to Mr. Pujala.
All right, thank you, Claude. Commissioner, just want to point out again, as I mentioned in my opening remarks, the director recommendation did recommend approval of the OGDP application, and that recommendation was not disturbed by the addendum issued in October of 2024. So we would just summarize here on this slide the efforts to avoid, minimize, and mitigate impacts associated with the Washington pad. The ALA avoids all receptors but for the 3 RBUs for which the equipment and wells have been located more than 2,000 feet away. There is informed consent from those owners. That is the primary tool that extraction is deployed to protect and minimize and mitigate impacts. And then, as you've heard, other efforts to minimize and mitigate impacts are set forth in the BMPs. And with that, we would request that the OGDP application be approved. And at this point, we're ready to move into the variance application. If the commission would like to take a break, we're happy to take a break, or if we should just go through, let me know.
I'm fine just continuing. Let's kind of hear it in all one fell swoop, and then we might take a break before we move into the Q&A piece.
Very good. Briefly, this is the overview of our presentation, introduction and background, discussion on the bald eagle nest, the Rule 502C 1 through 5 elements for the variance, director's recommendation, and summary. I'm going to keep my comments very short here. You heard me at the outset of this matter that the variance was submitted at the request of staff, that we disagree with whether the variance is even necessary under the way that the rules are drafted in the statement of basis and purpose. But nevertheless, we're applying for this to at the request of staff. This is the 502C overview, the 5 factors that extraction is required to show. First is a good faith effort to comply or is unable to comply with Rule 1202C1G, that the requested variance will not violate the basic intent of the act, that the variance is necessary to avoid an undue hardship, that granting the variance will not result in an net adverse impact to public health, safety, welfare of the environment, and specifically in this case, wildlife resources, and that the requested variance contains reasonable conditions of approval or other mitigation measures to avoid, minimize, and mitigate adverse impacts, again, specifically to wildlife resources in this case. And with that, I will turn the presentation over to Lila Hubbard.
Thank you, Mr. Pershala. Good afternoon, commissioners. I am the Natural Resource Specialist at Civitas, and my background is in wildlife biology. I will be discussing the new bald eagle nest that was discovered south of the proposed location just weeks before the original hearing date. This slide gives an overall visual of the proposed location, surrounding activities, bald eagle nest, and 3 buffer zones mapped around the nest, 660 feet or 1/8 mile, 1/4 mile, and 1/2 mile. Before we dive into the details of the bald eagle nest, here is a quick overview of natural resource considerations at this location. According to a review of the Codex database, this project location is outside any, quote, special areas, including PCAs and critical habitat. Looking at the swap layers provided in Codex, this location is in the lowest tier of habitat priority and species richness and outside key terrestrial habitats. This makes sense considering that this is an overall urbanized and industrial area. Civitas contracts third-party environmental consultants to survey for wildlife and other environmental receptors around all new proposed locations. During initial surveys conducted in January and June of 2022, no eagle nests were present within 1/2 mile of this location. Only 1 non-eagle raptor nest was identified, and there is a history of red-tailed hawk nesting in this area, but no eagle nests or activity were observed. There was an active bald eagle nest mapped approximately 1 mile northeast and included in the HPH dataset, and this nest was intentionally avoided during initial site planning. On July 10th, 2023, a new nest was documented south of the proposed location. No activity was observed at the nest at the time, and it appeared to be a non-eagle raptor nest based on its size. However, the consultant contacted CPW to determine if CPW staff had any insight on this nest. No data was provided by CPW at that time. On September 13th, 2023, 2 adult bald eagles were observed near the nest for the first time by our wildlife consultant. Extraction asked the consultant to begin weekly surveys. About 1 month later, on October 18th, the consultant observed bald eagles on the nest for the first time. As a result, wildlife agency consultations began in November 2023. Based on data collected by CPW and extractions consultants, we can confirm that this nest has not been successful in either of its 2 attempted nesting seasons. From September 2023 through August 2024, RPG Resources and SWCA Environmental Consultants conducted a total of 48 surveys. A nest survey form was created based on U.S. Fish and Wildlife Service guidelines to ensure thorough and consistent data collection. Potential incubation behavior was observed in March of 2024. However, the adult eagles were off the nest for long periods of time, which is atypical behavior if viable eggs are present. Outside the nesting season, after consulting with CPW and when no eagles were present, a drone was flown over the nest and biologists surveyed the area underneath the tree to look for any signs of egg remnants, but none were observed. In other words, there's no evidence that eggs have ever been laid in this nest. The intention of this slide is to provide an idea of the overall timeline of events. After several years of project planning, the OGDP was submitted in February of 2023. The OGDP passed completeness on October 10th, 2023, and the first observation of eagles at the nest was documented 8 days later. Consultations with wildlife agencies began in November 2023, and the director issued a recommendation for approval on December 1st. This hearing was voluntarily delayed 3 times while we continued discussions with agencies and continued developing additional wildlife BMPs. Per request by ECMC staff, this variance request was submitted on August 13th, 2024. Consultations and communications with agencies continued through September 2024. Before we discuss the details of our consultations, we'd like to provide some context. CPW's mission is to perpetuate the wildlife resources of the state, to provide a quality state park system, and to provide enjoyable and sustainable outdoor recreation opportunities. They define active nest as any nest that is frequented or occupied by a raptor during the breeding season, or which has been occupied in any of the 5 previous breeding seasons. CPW recommends an 1/8 mile to a 1/4 mile NSO and up to a 1/2 mile buffer area during the nesting season. U.S. Fish and Wildlife Service mission is working with others to conserve, protect, and enhance fish, wildlife, plants, and their habitats. Fish and Wildlife Service has the primary authority and responsibility for bald eagle management, protection, and conservation pursuant to the Bald and Golden Eagle Protection Act, which was established in 1940. Similarly, the Fish and Wildlife Service also has primary regulatory authority over the Migratory Bird Treaty Act. Bald eagles are protected under both these federal acts. Fish and Wildlife's definition of active nest is similar to CPW's definition. However, it is not based on a 5-year timeline and is flexible to each breeding season. The service recommends a 330-foot or 660-foot buffer zone, but not NSO, depending on activity, visibility, and presence or absence of similar activity. Fish and Wildlife monitors bald eagle populations and may authorize take permits where take is compatible with the preservation of eagles. We will discuss the permits more in later slides. Fish and Wildlife has also developed national bald eagle management guidelines to help avoid and minimize impacts to bald eagles. Extraction has conducted extensive consultations with both wildlife agencies, and this table gives an overview of all the main consultations and communications that occurred. We will go over some key points in upcoming slides, and more detailed information can be found in the file documents. First, we will focus on our consultation efforts with CPW. When the nest was first identified, we contacted CPW in July 2023 for any insight about the new unidentified raptor nest. No data was provided at the time. After bald eagles were identified at the nest site, we initiated consultations with CPW. During our December 7th and December 12th meetings, we discussed the project, nest, line of sight, BMPs current at the time, surrounding disturbances, and applicability of CPW's reduced 1/8 mile buffer zone for, quote, highly developed areas. CPW also mentioned that after further review of their internal data, this nest had been observed earlier in the year by a CPW volunteer, and an unsuccessful nesting attempt had been recorded for 2023. CPW urged Extraction to revisit the operational timeline and try to move all development phases outside the nesting season, and all parties agreed to reconvene the following day. The next day, on December 13th, the parties reconvened, and Extraction confirmed that operations could occur outside the season with 2 occupations. However, despite this commitment, CPW decided a 1/4 mile NSO should apply because the area did not meet their definition of highly developed area. CPW's hardline position came as a surprise to us at this stage in the discussions. The hearing was postponed and all parties agreed to continue data collection and discussions. On December 20th, CPW set up a meeting with Extraction to present CPW's current bald eagle study. During the call, CPW clarified that this was not an opportunity for the project to contribute data to the study, Rather, this was an opportunity for Extraction to contribute to the study, assisting getting CPW access to the property to trap and tag the eagles or support it by other means. Between March and August of 2024, Extraction reached out to CPW 3 times to continue discussions, but unfortunately, CPW declined or did not respond. On April 10th, Extraction presented information about the eagle nest and consultation efforts to ECMC staff to help bring them up to speed. CPW attended this virtual meeting. Following ECMC staff's request for Extraction to submit a variance request, ECMC staff notified Extraction and CPW that a formal consultation would be required. A site visit was conducted on August 20th, and a virtual meeting was conducted on September 10th. CPW filed their written summary later the same day. Due to concerns about inconsistencies and gaps in the record, Extraction filed a response letter on October 3rd. CPW's guidance notes that the recommended buffer zone around a bald eagle nest may be reduced to 660 feet or an eighth mile if occupancy within a quarter mile cannot be avoided and the nest is located in a, quote, highly developed area. CPW determined that the highly developed area definition did not apply because there were not 10 daily occupied facilities within a quarter mile. CPW also notes in their guidance document that the reason their buffer recommendations are more extensive than Fish and Wildlife's is because of the, quote, generally open habitat used by Colorado's nesting bald eagles. However, habitats and tolerance levels of bald eagles can vary significantly throughout Colorado, and this is an example of a very urban habitat. We acknowledge and respect CPW's efforts to be consistent with their recommendations and center their decisions around their written guidance and terminology. However, we also believe this location is a good example of unique site-specific conditions that are crucial to consider when making these decisions. When considering the level of disturbance in an area, it is important to consider more than just daily occupied facilities. For example, there are several other types of disturbance activities that occur within a quarter mile of this nest site, including commercial development, agricultural activity, traffic, and a power station, as shown in the photos here. There is also development, interstate traffic, and a Topgolf commercial facility within the nest line of sight. According to Thornton's zoning designations, the nest is located in an employment center zoning district and adjacent to business park, planned development, and community retail zoning districts. Additionally, it is important to acknowledge that daily occupied facilities are not all the same in terms of disturbance. ECMC's definition of building unit listed here provides a good example of how to account for different types of building units or facilities. This nest site is in a heavily developed and urban habitat, and that type of designation should be applied when determining appropriate wildlife buffer distances. This conclusion is supported by 3 analyses that were conducted to better understand sound, light, and traffic impacts in this area. We will briefly review each analysis. An 11-day sound study was conducted by ENRG, comparing sound levels at the nest site to sound levels at a similar nearby site that would meet CPW's definition of a highly developed area, as it is within a quarter mile of 10 plus daily occupied RBUs. ENRG found that the DBA and DBC levels were very similar between the 2 locations, and in fact, the sound levels near the nest site were routinely slightly higher, less uniform, and had more pronounced and frequent spikes. Based on these results, ENRG's opinion was that the area around the nest site should be considered a highly developed area. SWCA conducted a field assessment of local light impacts. They documented several significant permanent and temporary light sources in the area, including security lights and flood lights at the adjacent construction site, street lights, lights from traffic signals and vehicles, and lights from the Topgolf facility to the north. As previously discussed, Extraction plans to implement multiple BMPs to reduce light impacts, and there will be no permanent lighting at this location. These tables show traffic estimates for the Washington pad, separated by phase, and for the adjacent commercial development project east of Washington Street, which, per Google Maps, is designated to be a future target distribution center. As you can see, Extraction estimates less than 1 vehicle trip per day on average during the production phase, which is the only phase that would overlap active breeding at the nest site. Meanwhile, public documents for the adjacent development estimate over 3,000 vehicle trips per day year-round. To provide further perspective, the total estimated vehicle trips during Extraction's development phases, which will not occur while the eagles are nesting, is equivalent to approximately 2 days of traffic associated with the adjacent development. Due to the limited, less than 1 vehicle trip long-term traffic expected from our project, we do not foresee a cumulative impact on the eagle nest when considering the combined truck traffic from neighboring developments. During our consultation efforts with CPW and in the written summary provided by CPW, impacts were brought up as a concern. However, aside from moving the location entirely, which is not possible due to reasons that will be discussed later in this presentation, we feel that we have implemented every BMP that was suggested by CPW and that this project is sufficiently protective. Seasonal avoidance is the most preferred and effective method for avoiding and minimizing impacts. Extraction is committed to conducting construction, drilling, and completions when the nest is not in use. We believe this seasonal avoidance, as well as the other BMPs we are implementing, will be more than sufficient to protect this nest from noise, light, and traffic impacts. Now we'd like to discuss our consultation efforts with U.S. Fish and Wildlife Service. Excuse me. Extraction engaged Fish and Wildlife in November 2023 to discuss the proposed project and new bald eagle nest, as well as permit applicability. Fish and Wildlife staff also attended our December 12th meeting with CPW. On December 23rd, Fish and Wildlife provided an initial recommendation via email, and they followed up on March 5th, 2024 to confirm their determination that a permit was not necessary for this project. Fish and Wildlife assessed this project and nest location based on current species data, project-specific details and BMPs, geographical location, and surrounding activities. In their initial recommendation provided to us on December 23rd, they cited several specific reasons for their decision to not recommend application for a permit, including the proposed BMPs and high tolerance of bald eagles in this area. On March 5th, Fish and Wildlife concluded that a disturbance take permit is not necessary for this project due to the reasons cited in their previous email. The photo included here shows the nest tree and agricultural field that is located immediately adjacent to the tree and extends north through the proposed project area. The road around the agricultural field passes underneath the nest tree. Our consultant identified a nearby development project that we believe is worth sharing as a local case comparison. A little over 3 miles to the east, there is an ongoing 72-acre residential development that includes 41 parcels and 3 local roads within 660 feet of a bald eagle nest. The nest is approximately 145 feet away from the edge of development. Fish and Wildlife Service conducted an environmental assessment as part of their permit process and then issued an incidental take permit based on their findings. One of the main BMPs implemented was avoiding construction within 660 feet of the nest during the breeding season. According to CPW provided the same recommendation for this project. They recommended a quarter-mile NSO. However, the project moved forward. According to public documents, the nest has been successful multiple years despite the ongoing construction associated with this project. This project is significantly closer to a bald eagle nest and more disturbing than the proposed development here. We highlight this project because it provides evidence of the tolerance of bald eagles in this area, as Fish and Wildlife noted in their review of the Washington project. A permit was required by Fish and Wildlife for this project, whereas they determined that a permit is not even necessary in the case of the Washington Bad. Overall, these data points further support the conclusion that the Washington Bad project is not likely to impact this nest. As mentioned earlier, Fish and Wildlife recently updated their permit program to include a general permit option for activities that, quote, have relatively consistent and low risk to eagles. This new general permit process went into effect in July 2024. Extraction proactively and by choice applied for a general permit. Part of the reason for this decision was due to the fact that this eagle nest has been consistently unsuccessful. So there is a chance this nest could continue to be unsuccessful for reasons unrelated to this project. So this permit provides some legal protection for any misinterpretation of such event in the future. Extraction obtained this permit on August 9th, 2024, and the permit was provided to the Commission in our filings. We have discussed several BMPs associated with this project, including many wildlife-specific BMPs. The Fish and Wildlife permit also includes 60 conditions, which are essentially BMPs. This slide just serves to highlight some of the primary BMPs, many of which are associated with the general permit. A more extensive list of BMPs has been provided to the Commission in our filings. To conclude my portion of this presentation, we would like to assure the Commission that if we believed this project was going to harm this nest or nesting pair, we would not be here in front of you today. Extraction has a robust wildlife compliance program and strives to always avoid and minimize impacts to wildlife. We have put a significant amount of additional time and effort into this matter over the last year and are committing to implementing BMPs that will allow this project to proceed while avoiding, minimizing, and mitigating potential impacts to this wildlife resource. We respect the expertise and opinions of CPW and Fish and Wildlife staff, and we appreciate their time reviewing this project. I will be available for questions after the presentation, and we also have Clint King from SWCA available for any questions about the nest monitoring efforts or general permit application. Thank you for your time. I will now turn the presentation over to Mr. Boito.
Thanks, Ms. Hubbard. In addition to the many minimization and avoidance BMPs associated with the Washington development. And because collaborative mitigation efforts with CPW were unproductive, Civitas has been pursuing multiple voluntary mitigation opportunities. We're excited to announce that we have been able to finalize the planned $25,000 donation to the Birds of Prey Foundation. The foundation, located near Broomfield, is the largest raptor rescue and rehabilitation facility in the state. In 2023, the Birds of Prey accepted nearly 800 raptors into their facility and is on pace to meet or beat that number in 2024. We are also in early stages of a collaborative nest and habitat augmentation program with a nearby stakeholder. Next slide. Thanks. Following the identification of the new nest and the confirmation that the previous HPH was no longer present, Extraction reassessed the previously completed alternative location analysis. The 6 alternative locations discussed during the OGDP presentation were reviewed for any new surface occupancy opportunities. Additionally, 9 more locations were reviewed for surface occupancy opportunities. All alternative locations were determined to be incompatible because of nearby RVUs, childcare centers, schools, an absence of an available SUA, the existence of planned future commercial and industrial development, and the anticipated stranding of large quantity of minerals. Next slide, please. A total of 6 alternative locations were examined as part of the development plan. These locations were previously discussed by Mr. Annable and were shown to be incompatible with development. Following the identification of the new nest, back one, please. Thank you. Following the identification of the new nest, 2 of these 6 locations, which were previously located in bald eagle habitat, were re-examined for renewed suitability. These locations are identified as Alt 3 and Alt 6 and are located north of E470 on the adjoining exhibit. Thank you. Alternative location number 3 is north and east of the proposed location. This location is encumbered by a proposed development application and within 2,000 feet of 2 RVUs. Alternative location number 6 is within 2,000 feet of 155 RVUs. Following the identification of the new nest, 5 additional proximal locations were identified and examined for suitability. These are identified here as locations 7 through 11. Alternative location number 7 is north of the proposed location and is within 2,000 feet of multiple RBUs and HOBUs. This location is within an active bald eagle HPH. Alternative location number 8 is south and west of the proposed location and is within 2,000 feet of many RBUs and HOBUs. Alternative location number 9 is located south of the proposed location and near a location that was examined as part of the original ALA. This location is no longer viable due to recent commercial development. Thank you. Alternative location 10 is located south and west of the proposed location. This location is within 2,000 feet of multiple RBUs and a child care center. Alternative location 11 is south and east of the proposed location. The location is within 2,000 feet of 3 RBUs and a high school. Thanks. After exhausting all proximal alternative locations, 4 additional surface locations were examined further afield. These locations are identified as Alt 12 through Alt 15 on the adjoining exhibit. Alternative location number 12 is located roughly 2.5 miles north of the proposed location within the city and county of Broomfield. It is constrained by multiple RBUs, HOBUs, and existing bald eagle high priority habitat. Additionally, extraction is precluded from pursuing new developments in the county by a standing operator agreement with the city and county of Broomfield. Alternative location number 13 is located roughly 3 miles north and east of the proposed location. This location was determined or was eliminated from consideration as no surface use agreement exists, and the location is expected to strand roughly 960 net mineral acres. Alternative location number 14 is located roughly 2.5 miles north and east of the proposed location. This location was eliminated from consideration as no surface use agreement exists, and the location is expected to strand roughly 960 net mineral acres. Alternative location number 15 is located 2 3/4 miles east of the proposed location. This location was eliminated from consideration as no surface use agreement exists, and the location is expected to strand roughly 960 net mineral acres. As this alternative location analysis is demonstrated, commercial development near the proposed location is ongoing and extensive. To help eliminate the development that has occurred during the advancement of the Washington OGDP, we have created this time lapse. The time lapse begins in, hold on a second, Joe, if you don't mind. Thanks. Back that baby up. Thank you. The time lapse begins in 2017 after the approval of the Washington North and South DSUs in their original format. Please now play the time lapse. Thank you. You'll note that the proposed Washington location in the center of mostly agricultural land uses. Starting in 2019, the land uses begin to change. The build out of distribution-based facilities near the proposed pad location has been steady through the intervening years. Commercial developments planned to the south, to the north of the proposed location will completely transform this area from agricultural to industrial and commercial. Let's play that time lapse once more, Joe, if you don't mind, as it did go kind of fast. Thank you. Thank you. Next slide, please. While nearby commercial development has been ongoing throughout the advancement of the Washington OGDP, commercial development proximal to the proposed Washington development location is planned. A component of the Washington development is the plugging and abandonment of the previously discussed legacy locations. The removal of pipeline infrastructure associated with these locations will unburden the highlighted commercial developments. Without the variance, the wells will not be abandoned and the associated infrastructure will not be removed, disrupting the planned development to the detriment of both the developers and the surface owners. I'd now like to hand the presentation back over to Mr. Pujala.
Chair Robbins, at this point, we've probably got about another 15 or so minutes of presentation. I think we're going to run into your stop for AAG Davenport.
Mr. Pashala, let's go ahead and do it. I believe that AAG Davenport will be able to wing into his Zoom meeting. So let's just keep moving and see if we can get through this, and then we'll take the break and come back for questions.
Sounds good. Thank you. Okay, with that, I'd like to introduce Dr. Ramey to the commission. Dr. Ramey, you are elevated and you have your camera on. Please introduce yourself to the commission.
Yes, I'm Dr. Rob Roy Ramey, with Wildlife Science International. A little bit about my education and experience for you. I received my bachelor's degree in biology and natural history at the University of California, Santa Cruz. I went on to Yale University and earned my master's degree in wildlife ecology there. I worked on California condors at the time, including research and publication on nest site biology of condors. I went on to receive my doctorate at Cornell University in ecology and evolutionary biology. And I also did 2 postdocs after that to continue my education. The first was at the University of Colorado in Boulder, where I studied parasites and pathogens on wildlife. And then I moved on to the San Diego Zoo Center for Reproduction of Endangered Species, where I completed my second postdoc with their genetics laboratory there. A bit about experience now. that may not be in my CV, which I'm sure you have all read. We work a lot on endangered species scientific issues, Bald and Golden Eagle Protection Act issues, and as well as Migratory Bird Treaty Act issues. A lot of our work involves consulting on and conducting original research on human disturbance of wildlife and potential effects and mitigation measures. I've also lots of experience in the field with raptors, beginning in 1980, working with the highly endangered peregrine falcons at the time. Recall that about in 1975 or so, they were down to 345 birds in North America, nesting pairs in North America. And so we were in a rush program to access nests, to retrieve eggs, bring them back to captivity to establish a captive breeding population, and then return chicks into the wild to bolster the wild population. I overlapped that with work on California condor recovery, where again, I was climbing into nests to retrieve eggs from these wild nests to establish the captive breeding population at the San Diego and then LA zoos. It was a desperate time. We were down to 22 birds. And now, fortunately, today we're up at 560. Peregrine falcons today, by the way, great success story. Like bald eagles, they were affected with DDT. We're now over 93,000 in the lower 48 bald eagles. Now we're over 300,000. Also, I've continued my work. I have for the last 24 years, volunteered with the United States Forest Service in Boulder, Colorado, in the Ranger District, monitoring golden eagle nests. So monitoring the nests for activity, obtaining data on nesting timing, egg laying dates, hatching dates, fledging dates, causes of potential disturbance, helping to coordinate on seasonal closures in those areas, as well as determining causes of nest failure. And I've recently extended that work in 2022 to Rocky Mountain National Park, working with, again, a wide variety of raptors, including eagles and falcons, for the National Park Service. And again, locating nests, climbing into them, documenting those for them. Regarding bald eagles, I've also consulted on a number of projects on wind energy, oil and gas effects, and also recreational uses surrounding them. And also, you know, I have very familiar with contemporary oil and gas operations and mitigation measures. Since 2009, I've been working on greater sage-grouse conservation issues in Colorado and Wyoming. And so I'm highly familiar with that. I published 2 peer-reviewed scientific papers on that, one on mitigation measures, including oil and gas mitigation for greater sage-grouse, and also another paper on effects of oil and gas operations in Wyoming on greater sage-grouse population trends. So very familiar with these sort of topics, and available here today to consult on this particular issue.
Thank you, Mr. Ramey. With that, Chair Robbins, I'd like to move to have Mr. Ramey admitted as an expert on the topic of bald eagles, no surface occupancy buffers, and eagle tolerance to human activities, including oil and gas activities.
So admitted.
Thank you. Mr. Ramey, have you visited the nest in the location that we're talking about?
Yes, visited the site on August 12th. In fact, I visited the site previously to that by going on Google Earth to get an idea of what's going on in that area, as well as downloading the CPW overlays for HPH for bald eagles to understand where the nest sites were relative to development. So yes, I went to the site, and a few of my takeaways from that site is that, you know, it's arguably in a highly developed area because of all the commercial development in the area, and that's also slated to occur there. There's a lot of unmitigated development around there, including the Topgolf lighting, which you drive by at night on the way to the airport, and you can go like, oh my God, what is that? Large Target and Amazon distribution centers, you know, kitty corner to the project site. And there's this encroaching warehouse development and a lot of 24/7 both activity, noise, and lighting going on in that area. And then, you know, after reading all the documents surrounding this is listed in Appendix A, I was struck by how arbitrary the quarter-mile NSO buffer is, and specifically why that is so. And so I do hope that all of the commissioners have had an opportunity to read my report, October 18th report, Joe, about these issues, and I'd like to go in and explain some of the reasons why.
Please do.
Okay, let's go straight ahead. So the Gadir et al. Report, I wanted to bring to your attention as the best available science on this subject. This is a paper that was produced by four of the five authors are U.S. Fish and Wildlife Service bald eagle experts, all well published in the field. The U.S. Fish and Wildlife Service that we've heard before is arguably the expert agency having regulated activities and worked on protection of bald eagles since 1940, and especially under the Endangered Species Act from 67 to 2007. So broad experience. Now, this data set that was used to produce this paper came from bald eagle take permits issued by the U.S. Fish and Wildlife Service for potentially disturbing activities that would result in take and potential loss of nesting success. And so, as you've read, the data which are available that download in the back of the paper show that there was no significant difference between the nesting success, whether a chick was produced or not, and those quote areas that received the take permit and those areas that were unaffected by any regulated disturbance. Also, there was no statistically significant difference, so not biologically significant either, relative to the nest productivity, nest success between rural disturbances and urban disturbances. Very interesting results. And so the question is, why is that so? Well, first, bald and golden eagle act take permits are not free-for-alls that you can go and do whatever you want to within the affected area. No, these actually come with very specific targeted restrictions that must be complied with. So those typically, and just like in the Civitas extraction situation with their bald eagle permit, is to minimize, avoid, and mitigate noise, excessive traffic, human activity in the area, and lighting. And those combined to reflect the current conditions around that nest site. So the big take home here is that bald eagles are the current contemporary science and a lot of previous research that I can bring up today. I cited a few of those in my report, the Goulet and the Gwynn et al. Article. Bald eagles are a lot less sensitive to, quote, human disturbance than had been previously realized. Now, you have to realize that in the past, when bald eagles were highly endangered, agencies were more likely to be more precautionary. And so that's how you ended up with buffers and greater restrictions. But as the science has matured, it's been realized that these birds are actually more tolerant, that we can actually address any specific threats to them, and that there's a much more of a coexistence that is possible. Additionally, bald eagles, as per the latest U.S. Fish and Wildlife Service 2024 guidance document and supporting scientific document, the final environmental assessment on the 2024 Eagle Take Permit Program, discusses the dramatic increase in the number of bald eagles nationwide, including in our Central Flyway in Colorado and extending north to the Canadian border. And so as these populations have expanded, bald eagles have moved into areas that were traditionally habitat. And they've successfully reproduced there, as shown by data not just here in Colorado, but elsewhere. And so bald eagles are moving into these areas. And the reason why they're so successful, it is hypothesized, and in a published paper and seconded by the Gadir et al. And then also in the U.S. Fish and Wildlife Service 2024 guidance, that the mechanism here operating is that bald eagles that are raised near urbanized areas or within an urbanized area imprint. They become used to that area that they've fledged in, and they understand how to avoid hazards, and that they are used to it. They feel safe, and so they're more likely to nest there. They nest in trees for a reason, because it's a safe place from predators. Not many humans are scampering up these trees to harm them. And so they have done quite well, not only here, but all across the United States, as well as Canada. Numerous citations to that recently. Let me go on here. How are you doing on time, Joe?
If
Okay,
we
we're just
can
gonna
try to move through it here, get to your summary of your opinions and conclusions. I think that would be beneficial to the commissioners.
Yeah,
Great.
Mr. Pashala, don't rush. We'll just get through it.
thank
AG
you.
Davenport has moved on to his other status conference, but that's fine. So the commissioners are all here.
Thank you,
Appreciate it.
Commissioner. Thank you so much. So what also sets this study apart is that it is based on actual data on reproductive success of bald eagles. Previous research, which is used to develop some guidelines, for example, CPW's guidelines, was based upon research that was looking at whether the eagles reacted to the disturbing activity. So did they turn their head and look in that? Did they stop feeding? Did they flush from the nest? But not actually whether the nest succeeded or failed. And so that is an important distinguishing factor here. I mean, I was surprised to see this paper. Found it so welcome, because I've only seen a handful of others like it, where basically a system was driven to potential reproductive failure, and they found that it didn't. And the reason that they didn't is a combination of habituation by the eagles and human habituation to the eagle's needs. Specifically, what are the threats that could potentially lead to reproductive failure? So that's what sets that apart as best available science, as opposed to correlative studies, subjective interpretation of observations, and review articles where basically the authors compile and regurgitate somebody's opinions on what should be a recommended closure distance or such and that. Important here too, and one of my reasons for disagreement with the Mr. Moret's CPW report is that, I don't see these as unreconcilable conflicts. Obviously the U.S. Fish and Wildlife Service, the expert agency, does not see that because of their issuance of that permit. They didn't even think a permit was needed in the first place, but now you have it. And then also that there were no specifics as to what those potential threats were. And so when I dug a little deeper into CPW's guidelines, they referenced the 2007 U.S. Fish and Wildlife Service bald and golden eagle protection guidelines. And CPW says in their guidance that that their guidelines mirror those of the U.S. Fish and Wildlife Service, and they're consistent with the U.S. Fish and Wildlife Service guidelines, except that they're not, and they're not because there's a misreading or misinterpretation of those 2007 guidelines and all the guidelines produced by the Fish and Wildlife Service since. There are no NSOs in that 2007 Fish and Wildlife Service guideline, nor fast forwarding through 2016 revision and 2020. So I have no idea how it got in there, but for obvious reasons, it is not needed because you can mitigate those specific factors that could cause a problem for the eagles. So for that reason, and my education and experience and delving deeply into the scientific literature, much more than the citations listed here, I find that this is a reasonable variance application. I don't see this having a deleterious effect on reproduction in these birds. And not only that, the birds haven't even been shown, there's no evidence that the birds have even actually laid an egg there. There are no eggshell fragments. There's no prolonged incubation. So we don't even know those are the same birds between 2 years, 2 different seasons. So for all of these reasons, I support the application. I think it's very reasonable on biological grounds and certainly consistent with expert agency U.S. Fish and Wildlife Service guidance. So thank you so much, and I'm available for any questions you have.
Dr. Ramey, I've got a question for you.
Sure.
Given that I understand you've reviewed not just the location, the nest, you've reviewed extraction's best management practices, the seasonal avoidance. Do you have an opinion whether those best management practices and seasonal avoidance would provide equivalent protections to the to the no surface occupancy buffer that CPW is maintaining?
At least equivalent. Yeah. I mean, because this quarter-mile buffer thing is just an arbitrary thing. You know, I can envision things where, you know, there could be a disturbance beyond that could be mitigated through these guidelines, Fish and Wildlife Service guidelines that are not in this just NSO. I mean, the NSO is just a blanket, thou shalt not, one size fits all prescription. But as we've heard today, there are numerous and very detailed avoidance, minimization, mitigation measures to deal with any potential threats to the birds. So I don't find it, I think it's equivalent at least.
And a follow-up question to that. What is your opinion if the operations go forward with the proposed BMPs and seasonal avoidance? Do you have an opinion on whether those would create a net adverse impact to wildlife?
That would only be the prairie dogs that might, no, actually no prairie dogs on the site. Actually, they're not, because I visited that site. I remember looking around there. So no, I don't see anything there. This is a highly developed area. Sure, it's industrially developed with high amounts of lighting and all sorts of other activity. And this is just a small corner of that. And it's no, you know, contribution to any, you know, adverse effect that I can determine. You know, there's nothing specifically that's been pointed out in CPW's opinion, Mr. Moret's opinion, that identifies what any particular threat would be and how that couldn't be mitigated at all. So there it is.
One final question for you. You're familiar with the understanding that there'll be drilling and completion operations, and then when the wells go into production phase, that's an entirely different operation than what is associated with drilling and production. Do you have an opinion on whether that ongoing production phase long-term would have a negative impact on this nest?
Well, I'm sure the commission understands how these things operate. The drilling phase is short, it's intense. There's timing stipulations here that this will not occur during the bald eagle nesting season, effectively removes that as any kind of threat to the birds. And after drilling and completion, this essentially becomes a benign object in the environment. There's minimal human visits to the site because of telemetry, the fact that they have pipelines removing the products and from the site. I believe there's only like, you know, one vehicle a day going there, you know, potentially. So this is actually far less activity than the surrounding development in the area. It's basically a lump in the landscape. And, you know, the bald eagles, let's not forget that bald eagles primarily feed on fish. And so they're going farther away in order to go obtain fish, but they also eat prairie dogs. And so they'll make some larger distance forays. So, you know, they do have wings, they can fly, they go long distances in order to obtain food. So I don't see a problem here.
Great. Well, thank you. I don't have any further questions for you, Dr. Ramey. Thank you very much for your time and testimony here today.
Thank you. I'm glad to answer any question, commissioners, that you may have. Feel free.
Okay, thank you for the presentation. Why don't we put a hold to it now? Let's return at 2:30 as I indicated. That'll give our AAG a chance to get back to the hearing. So it's 2:04. We'll take a 25-minute break and we'll be back at 2:30.
Thank you.
All right, we're back on the record in 2301-00033 and 2408-00202. Mr. Pashala, I believe we are to hear from you kind of a summary, and then we will figure out next steps. Does that sound fair?
That sounds fair. Yes, I have some closing remarks that I'd like to make for the record, and then we will be done with our presentation. And I understand that y'all want to hear from Mr. Moret from CPW, and then questions and deliberations. So with that, I will jump right in. Starting with the OGDP, applying the HPH mapping layers in effect at the time of the completeness, the Washington OGDPs unquestionably satisfies Rule 301A as confirmed by the director recommendation. The location prioritizes avoidance of all Rule 304 B2B receptors, and for those RBUs that could not be avoided, extraction is located at the wells and equipment on the pad more than 2,000 feet from those homes, and also obtained informed consent. And the suite of enhanced best management practices, including the line-powered rig, electrified production facility, tankless facility design, full pipeline takeaway, demonstrate effective minimization and mitigation of adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Turning to the variance, extraction has demonstrated that a variance under Rule 502C is appropriate here. First, whether extraction has made a good faith effort to, but cannot comply with the quarter-mile buffer under Rule 1202C1G, has been demonstrated through the extensive ALA analysis conducted both pre and post-nest discovery. Extraction has determined that there are no other viable locations further from the nest that would not increase impacts to other human receptors, including homes and schools. That would not leave significant minerals undeveloped, or would limit the timely removal of legacy infrastructure that would otherwise benefit for nearby communities and allow for the commercial development to move forward as planned. In addition, extraction has worked for over a year with CPW, well, excuse me, not over a year, close to a year with CPW, exploring best management practices and other alternatives to resolve CPW's concerns, but to no avail. Second, whether the variance will violate the basic intent of the Act, as I covered at the outset. The basic intent of the Act is applicable here is to regulate oil and gas in a manner to protect wildlife resources. As to bald eagles, the starting point is the application of the Rule 1202C1G buffer. However, as the Commission recognized in the Statement of Basis and Purpose, the buffer in certain circumstances may not be appropriate, and it's not the only way to achieve the Act's goals. Therefore, variance may be appropriate if it's equally protective of wildlife resources. Thus, variance is not violative of the basic intent of the Act, and as was shown today, extractions, BMPs, and seasonal avoidance commitment will provide protections equivalent to the Rule 1202C1G quarter-mile buffer. Third, many parties other than extraction will suffer an undue hardship if this variance is not granted. As you heard, moving the location to any of the potential alternative sites will result in a greater number of human receptors within 2,000 feet of the pad, including schools, and then the stranding of mineral resources to the detriment of mineral owners that you heard from this morning. It will impact the removal of the legacy wells and infrastructure in the surrounding community, some of which are close to homes and schools, and will negatively impact the ability of the surface owner to proceed with its development of its lands. Further, without the variance, years of planning and expectations in cooperation with the City of Thornton would be highly upset. Fourth, there will be no net adverse impact. As shown through extractions, fact, and expert witness testimony, the BMPs in seasonal avoidance will provide equivalent protection as that of the quarter-mile buffer, and thereby avoid any net adverse impact to wildlife. The evidence shows that the commitment to not operate during the breeding season while the nest is in use will avoid any impacts that could disturb the nesting viability of these eagles and the breeding success. That avoidance is followed by other best management practices that minimize and mitigate other impacts through the use of the line-powered rig, sound walls, lighting protection, and others. Of course, once production is established, there will be minimal human activity at this location due to the tankless facility design with the three-phase pipeline takeaway. And further, as shown by Dr. Ramey's testimony, eagle populations along the urban Front Range, along the I-25 corridor, are thriving. This species is adapted to human activity in urban areas such as the Washington location. And the latest scientific research shows that eagles are tolerant of more intensive activities and at distances closer than what is proposed at Washington. In his professional opinion, studying the distance, best management practices, and the seasonal avoidance commitment, Dr. Ramey concludes that those measures will provide protections equivalent to the quarter-mile buffer and will not result in a net adverse impact to these bald eagles. In addition, as to the other considerations of public health, safety, and welfare in the environment, the director has already determined that the pad and the operations will not have an adverse impact thereon. Finally, fifth, no conditions of approval or mitigation measures are necessary, as the testimony and evidence shows that extractions committed BMPs, nest monitoring, and seasonal avoidance will protect the wildlife resource. The commission is looking at a balance here, a proposed location that is optimally located in regard to human and environmental receptors. It's tucked into the interchange of two major highways, bordered by a power station, bordered by existing and future industrial warehouse development operations, and is supported by the city of Thornton, the surface owner, and the developers that have plans to develop the lands immediately surrounding the Washington pad near this nest. Those considerations need to be balanced against the potential impacts to the viability of the nest for breeding. Extraction acknowledges that the Rule 1202C buffer is a starting point. It's designed to protect the nesting viability. However, as demonstrated by the fact and the expert testimony, the viability of the nest remains protected with the Washington pad siting and the operations with the best management practices and seasonal avoidance. CPW's main concern appears to be that the long-term Washington operations would cause the eagles to abandon the nest. But as we've heard today, the facts demonstrate otherwise. The commercial developments in the vicinity have been under construction and moving ever closer to this nest, even before this eagle pair was ever observed. And even since the pair moved in, they have returned each year, despite the increasing level of human activity. Of course, despite all of the significant development around this nest, which extraction believes should meet the highly developed area definition and the application of a reduced buffer, which is commensurate with fish and wildlife, CPW has remained steadfast in the application of its quarter-mile buffer, no surface occupancy buffer. I also point out that fish and wildlife, in reviewing the nest, the surrounding development, the Washington operation, including best management practices and seasonal avoidance, determined that the agency did not expect extractions operations to constitute a take, meaning that the operations would not disturb the eagles and pose no risk to the viability of the nest. Extraction pursued that general take permit only for legal protection in the event there was a disturbance that the Fish and Wildlife Service did not anticipate even occurring. Contrary to CPW's contention, the permit is not evidence of a net adverse impact. Rather, it demonstrates that the primary agency tasked with protecting bald eagles does not believe there will be an adverse impact, much less a net adverse impact. Of course, the take permit has conditions of approval, which include the BMPs that Extraction is proposing as part of its Washington OGDP. As you've heard from Dr. Ramey, the best available science and his expert opinion, the Washington pad operations with the BMPs and seasonal avoidance will provide protection equivalent to the Rule 1202C 1G buffer. And therefore, it weighs in favor of granting the variance. I think one of the main takeaways from the research is that Fish and Wildlife Service has undertaken the necessary research that can guide this commission. By approving the variance, you are not treading new ground. Rather, you would be following the lead of Fish and Wildlife, which has already established that bald eagles are tolerant and adaptive to human activities at levels higher than and at distances closer than the Washington pad to the subject nest. We respectfully request that based on all the facts, the testimony, the best available science, that you approve this variance. Thank you very much.
Please take down the screen share. Commissioners, I'm inclined to hear from Mr. Moret next, and then come back and open up the panel for questions, and then open up Mr. Moret for questions so that we can kind of see both sides of the story. So with that, if we could have Mr. Moret visualize himself. Good afternoon, Mr. Moret.
Good afternoon, Chair Robbins, and good afternoon, Commissioners. It's good to see you for the second time today. I appreciate this opportunity to discuss this very unique situation with you all. For the record, my name is Brandon Moret. I'm a certified wildlife biologist and CPW's Northeast Region Energy Liaison. Chair Robbins, I have the following 6 points that I wanted to briefly go through after listening to that testimony. First one, CPW continues to appreciate the ongoing collaboration with extraction with this unique situation, but CPW has unresolvable wildlife concerns regarding extraction's 1202C1G variance request. Number 2, I'm not here today to debate the nest buffer distance that existed well before SB 181 and was extensively discussed during the 1200 series mission change rulemaking. I'm here to apply the quarter-mile distance that was codified on page 297 of ECMC's rules. Number 3, my assessment is based on current ground conditions, not 2025, not 30 years from now. Today, this buffer has less than 10 daily occupied structures that CPW considered within a quarter mile. It wasn't just my determination, but it was 2 other CPW biologists. Furthermore, at least 1 bald eagle has been viewed at this nest by myself and coworkers within the last week, including yesterday, which means this will be the 3rd consecutive season that nesting is likely to occur. And this nesting pair has attempted to nest in this territory for at least the last decade. I wanted to make a few clarification points from Civitas's testimony. First one, there are prairie dogs, which can be prey for eagles within the quarter-mile buffer, and eagles are dietary generalists, and they aren't focused entirely on fish in the Front Range of Colorado. For CPW, the presence of eagle eggs or lack thereof aren't required to constitute a nest. Conversely, the lack of breeding success further exemplifies the need for protecting them with that buffer. It's common for new nests to fail during the first year or 2 of a new nest. And the structure was built when the previous one north of E470 was destroyed. But as I mentioned, eagles have occupied this territory in North Thornton since at least 2006, and previous attempts have been successful. Regarding the Gadir paper from 2023 that was entered into testimony, it should be noted that the nests that they analyzed are not in Colorado, nor any of our surrounding states. The states that were analyzed are mainly from coastal states and north central Midwest that have deciduous or evergreen forests that provide a natural visual buffer, which, as you've seen from Civitas's photos, does not exist at this location. I'd also like to push back on the comment that there's no scientific basis for CPW's buffer and seasonal timing limitations because they're based on literature discussed during the 2020 rulemaking and are currently cited in the back of CPW's 2020 Raptor Buffer document that I'm happy to share with commissioners if they have not seen it yet. Point number 5, I appreciate one of the commissioners' questions ahead of time regarding the difference between Fish and Wildlife's and CPW's bald eagle recommendations, which Civitas described. But to summarize, the main difference is that Fish and Wildlife's eagles buffers are more to prevent the obvious human impacts from violating the Bald and Golden Eagle Protection Act and the Migratory Bird Treaty Act, such as destroying the nest tree or shooting an eagle. Is Civitas doing that? No, they are not. However, CPW's bald eagle buffers are focused on protecting the nesting and rearing part of its phenology. Furthermore, even though there's different approaches between the federal and state bald eagle conservation recommendations, one should note that this is not a case of CPW preempting or superseding federal recommendations. On the contrary, since Fish and Wildlife's eagle buffers are not codified in the 1200 series rules, and the state buffers can be more protective than state law. Also, CPW has ongoing bald eagle research that involves nest monitoring and telemetry. 2021 was the first year of our significant data collection for our projects, and we're coming up on year 4, and we'll continue data collection in 2025. Publications will be forthcoming in 2025 through 2027, but Chair and Commissioners, for this variance request, the buffers aren't on trial, and they don't meet CPW's definition of a highly developed area. And I'll close with 2 last points, Chair. Page 183 of the 1200 series statement of basis and purpose, 1202 C1 habitats are, quote, the most sensitive wildlife resources in the state, and avoidance of these areas are the single most protective strategy that's supported by robust data in the administrative record during rulemaking, which included evidence provided by CPW. CPW is concerned with the precedents that approving this variance would set for other operators to pay $25,000 or whatever to impact a newly identified 1202 C1 habitat. And with that, I'm available to take any commissioners' questions or listen if the commissioners have questions for Civitas.
All right. Thank you very much, Mr. Moret, for the presentation. I believe the way we're going to try to do this is go have commissioner questions to Civitas and then have you listen in, because we may have similar questions for you. And then after commissioner questions to Civitas, the first question I'm going to ask you is, do you have anything you want to add following that Q&A with Civitas? So if you could just stick around and listen in, we relish your experience and being with us. Okay, with that, commissioners, we have the Civitas panel up for questions. Commissioner Ackerman?
Thank you. And I appreciate everyone's work and presentations today. Dr. Ramey, especially thank you for being here. My questions are directed at Dr. Ramey, I believe, although certainly anyone from the Civitas team is welcome to answer them. And I certainly had a lot of thought as to why the Gadir article, oh, did I say it right? Yeah, the Gadir article was selected as kind of the key piece of evidence here. As I see it, that article focuses on population level predictions associated with anthropomorphic disturbance that impact overall population fecundity. And like Mr. Moret pointed out, it's based largely on evaluation of nest sites that are in states and areas that are characteristic of, much thicker and predominantly deciduous forests, and notably absent of essentially any site in the entire Rocky Mountain region, with the exception of it looked like one in southeast Idaho. And the article, it recognized that a lot of historic research has demonstrated that eagles are sensitive to human proximity and disturbance, and that those studies are useful for developing management recommendations regarding breeding pairs. But it really focused on the concept that human proximity or disturbance may not adversely affect reproductive rates at that population level. So to me, the key takeaway was that the Gadir article posits that human activity may not affect overall reproductive success at a nationwide population level, but certainly does recognize that individual behavior of animals can be affected by anthropomorphic disturbance. So all that to get to my question, which is, can you address why a population level reproductive success evaluation article, on a relatively new front of research, you mentioned there are only a handful of similar papers, should be given, deference in this discussion about potential disturbance of this individual breeding pair, over those previous studies that clearly substantiate breeding pairs' susceptibility to human proximity and disturbance?
Certainly. Thank you for the question, Commissioner Ackerman. Well, as an initial matter, this is based on individual nest success data. It talks about implications for population level, but the paper, the data analysis, the Bayesian analysis of the factors that are important for nest success or failure come from individual nests. So unfortunately, you're wrong on that. And not only that, the eagles in Colorado are not a unique subspecies. They're not a unique ecotype relative to other eagles. This is the same species across North America that the Fish and Wildlife Service has studied since 1940. And that unfortunately, you may have not looked at the data in the back of the paper, but they specifically state minimum distances, which go all the way down to 0, which are right under the nest. And in fact, 51 out of the 66 nest sites are within 200 meters of the disturbance. And they also discuss whether there was the visibility was visible or not visible or partially visible. So Mr. Moret is in fact wrong on that point, that these are sites that are both visible and partially visible and obscured in some situations. So, that's an incorrect reading of it. So, the bottom line is that the Fish and Wildlife Service has been conducting this kind of research and management since 1940. And, they've published numerous articles on this subject, including their top experts in this paper, including Millsap, who just retired. And that is why it's best available science, in addition to the fact that the data is in fact available here. So national experts, national agency, data is available. It looks at multiple different situations, different scenarios of whether there was habitat alteration, there was the distance involved, the visibility with the environment was rural, industrial, or suburban. So, this compares to the mostly opinion-based interpretations of past research and correlative studies that assumed that if a bird reacted to some disturbance, that it would somehow result in nest failure, or potentially nest failure. Well, this is a refutation of that. And the cleanest form of science is hypothesis testing and refutation. So, thank you for the opportunity to comment on it. Strongly urge you to go back and look at that. I also have other papers. I mentioned the Goulet et al. Article on what's been going on in rural areas of British Columbia. There's also the Gadir article, Gwynn article 2013 as to the mechanism of this. And, there's also, here's an interesting paper, the influence of weapons testing on bald eagle reproduction and nest success. And, this is Aberdeen Proving Grounds. So yes, it's on the East Coast, but they're doing weapons testing and it's an open environment where, obviously a lot louder, and they don't find a difference in the nesting success of the eagles there adjacent to the proving grounds and those in rural or nearby areas. So, together all these things refute the narrative that it is a narrative that there's this human disturbance issue. And as I explained in my testimony, Commissioner, that human disturbance at nest sites doesn't even rank as a major concern. I mean, if CPW truly cared about preserving these birds, and those in particularly, they'd ban bullet fragments, they'd ban use of lead bullets, because bald eagles are scavengers. They'll pick up carcasses. They ingest lead. They die of lead poisoning. 47% of the bald eagles sampled in the United States had elevated chronic levels of lead contamination from both bullet fragments and carcasses and lead in fishing tackle. So, these are the kinds of things that are affecting populations. And relative to individual nest disturbance, this paper sits there as best available science and data. And I'm sure we'll see additional ones. Thank you.
Ackerman, if I may just sort of also respond to that question, and I'll keep it brief, but I think part of the reason for bringing Gadir to the table and this research and analysis is because we're sort of level setting why we're here and what posture we're in, right? We recognize that the NSO half-mile buffer is not on trial, as what may have been alleged, right? That's not what we're necessarily arguing here. But what we do have is that was established, right, in 1202C, and the initial starting point is no surface occupancy. There is, however, in your rules and ECMC's rules, the ability for a variance if there's no net adverse impacts. So what we're saying is we need to look at the big picture, right? The bigger picture is both the impact to the population, and then if you're looking closer, right, there are avoidance measures being put in place, mitigation and minimization that sort of lend towards that that variance, if you will. And I would just point you to the ECMC's definition of mitigate adverse impacts, which does speak to landscape level, population level protection of these species, not necessarily the individual creature. So I think for this particular application, you see both protection of the populations. It's a thriving set of bald and golden eagles. And then you're also seeing individual protections for these species.
Thank you. I appreciate that additional testimony on both of your parts. One follow-up question for Dr. Ramey. I'm trying to extract then from your testimony whether you believe that buffers are appropriate, or I guess what level of buffer is appropriate for the protection of bald eagles. And I would also state that CPW does very much care about the protection of bald eagles in this state, and I think we should be careful with that kind of language. Can you talk about what types of buffers, in your professional opinion, are appropriate for the protection of bald eagle breeding pair nests?
Yeah, thank you for this opportunity to clarify. I very much care about bald eagles, golden eagles, condors, peregrines, having hung on a rope as a rock climbing biologist, risking my life many, many times over and over again. So just to get that on the table. But in terms of buffers are a starting point of discussion. And as I explained on the last page of my testimony, written testimony, that buffers sometimes come out as initial precautionary measures before much is known about specific causal factors that may threaten a species. And I saw it on greater sage grouse. I've seen it on peregrine falcons and California condors. You know, they used to have us do condor nesting observations from a mile away. And then once we realized this is really not a problem, we're down at 90 meters. Setting up our observation points. So, you know, the same sort of thing time and time again, that these are initial precautionary measures. Sometimes they include NSOs, and then they, over time, are not, they're relaxed in terms of they're not strict on that, thou shalt not, but they are starting points of discussion for figuring out what are the specific causal factors that might influence reproductive success at that nest, and how can those be mitigated? And so that is where buffers come in. They're starting points of discussion from, you know, whether that's, you know, collaborative or it's regulatory, but that is the starting point. And, you know, I go with what I've seen as a very rational approach by the Fish and Wildlife Service on this. That let's try and figure out what the potential problems are, the specific site conditions, and then let's just move forward. So we are adapting our management to the bird's needs and not to, you know, some, I mean, sort of some sort of an archaic thought that this human disturbance is going to just immediately cause them to fail for some unspecified reason, as per Mr. Moret's testimony. So that's the nature of it. We can mitigate, we can avoid in virtually all cases, not all, but we can, and that's where buffers come in.
Thank you. I appreciate that. And so what I'm extracting from that lengthy response is that in your professional opinion, there's not necessarily a need for standing no surface occupancy buffers on eagles' nests, but rather a site-by-site analysis. Am I interpreting that correctly?
Yeah, a site-by-site analysis utilizing those buffers as starting points of consultation and discussion amongst agencies. I think that it would be great if CPW and Fish and Wildlife Service got together on that more formally.
Thank you. Nothing further at this point, Mr. Chair.
Commissioner Cross.
Thank you, Mr. Chair, and thank you for these presentations. I think there's a few things that I want to try and go into a little bit here. One one of the things I think for you, Dr. Remy, to begin with is Mr. Moret brought up the line of sight. And I know you were talking about that the Goodyear article also talked about line of sight. And I was curious your thoughts on the interplay of the other variables that we have present here. I know you brought up specifically the Topgolf and other things. Where does that line of sight distance kind of come into play? Because the Topgolf is obviously further away than some of the buffers that have been talked about. But there's also the different warehouses. How does the line of sight come into play there? And also, I'm curious as to how the sound walls that are going to be put up, how that would play into the line of sight as well.
Yeah, thank you for that question. I'm a lot less concerned over the years with line of sight, and I've seen buffer zones and line of sight analyses used for a wide variety of species of raptors. Is there visibility of a human potentially on a trail from this nest site? What about where the eagles, in this particular situation, what are they potentially seeing? That tree is a standalone object in the environment. We walked out to that tree and all around it to see it. So what the question here is really what would disturb the eagles in terms of lighting? And so there's research on this relative to wind energy impacts, because bald or golden eagles that are flying and in storms or even at dawn, dusk, or night, and can collide with the wind turbines. There's research on noise and lighting that might discourage them from crashing into those. I haven't found anything that is effective to discourage them from the lighting aspect. Flashing lights were tried. Dazzlers are used at airports to discourage the birds, but I just don't see very much. But what we do have is a little bit on noise, and so there's some research on evoked auditory potential, and this is a research. I've worked on elephants too, so I know a lot about infrasound and acoustics. So they take the eagle, captive eagle, they restrain it. It's not drugged. They hook up an electrode to the brainstem, and they play different sound pressure levels and frequencies to figure out what is disturbing of them. And so at what decibel levels. And so it turns out it's sort of a high mid pitch, 2000 kilohertz is kind of the peak. They're sensitive to that. And so that's the only thing I could find on the sound that could really be disturbing to the birds, but we have no evidence of that from the project. And similarly, relative to noise, we have Aberdeen Proving Grounds study on impulsive noises. But I think most importantly, in terms of this particular project, none of the lighting, none of the noise, none of the activity that is even approaching that at the surrounding area is going to occur during the nesting season. And they're going to drill and they're going to be out of there pretty quickly. Now, relative to Topgolf, the eagles have habituated to be in this environment. So perhaps they're avoiding it. We just don't know.
So as you talked about with Commissioner Ackerman, kind of looking at the site-by-site kind of applications, starting from the buffer areas rather than kind of relying on them as an NSO. Do you think then if they've kind of adjusted to this light, do you think that, or I guess let's put it differently, what do you think are the important mitigation and protective BMPs that are helping prevent the harm here? Because if they're already kind of used to the light, is the wall really what's helping with some of the protections here, or is the wall unnecessary? Are you looking at other mitigation measures? What protections are you relying on to say this is protective?
Yeah, that's a great question. Avoidance is the first one. Avoidance of your primary development phase. And so, and this is something that sets this oil and gas operation, many others, apart from other developments. So for example, like the warehouses across the street or like Topgolf. When those are developed, they just keep going. There's truck traffic, there's people, there's automobiles, there's lights, there's securities, there's sirens. Topgolf, it's, running its lights all the time. In this particular situation, you have avoidance relative to they're not doing all the drilling intensive activities during the nesting season. Second of all, they've got that sound wall, which also protects, so it disrupts sound transmission significantly. And then it also contains the lighting, which they have downcast lighting. And then once this has drilling and completion phase is passed, that this becomes basically a benign object in the environment. There's no permanent lighting. There's very infrequent visitation. That's because all of the products are taken off by pipeline. There's telemetry to monitor it. And you need very, very little visits as compared to everything else around the area. So.
Ms. Gutierrez, do you want to add in?
Yeah, Commissioner Cross, if I may be responsive to that question as well. I think kind of what you're getting at is what is the appropriate mitigation, right, to be protective of these species, these particular set of birds, and make sure there's no net adverse impacts. And in this particular case, I think we've addressed that by, primarily, and it's so important to say it time and again, but temporal avoidance, right? We are avoiding the most important season for this species to ensure that they have that opportunity for nesting again and again each year. Obviously, the sound walls will be in place and there's no permanent lighting in addition to everything else you've heard today. I think where you're kind of chasing is what more would be needed. And we heard from CPW just earlier that there's unavoidable wildlife concerns. And I think what we're struggling with on our end is we went through discussions with CPW at a point at which, there was a decision made from their side and lack of further engagement. We have not heard specific additional concerns, right? What specifically are we trying to mitigate beyond what we already have? And so that is precisely, frankly, where we are. I'm not sure that there is more to be done because all net adverse impacts have been avoided.
And adverse impacts avoided and codified in a permit with the expert federal agency.
Thank you. And I think some of my additional questions are probably going to go more towards the operator. And so maybe, Ms. Hubbard, it might be best directed towards you on some of these. And perhaps to get things on the record, perhaps Ms. Gutierrez or Mr. Pishala, it might be helpful for some of yours on this as well. One of the things that was discussed was the upcoming, I believe it was called the Mile High development. There were some additional warehouses coming in. And I know there was some slides shown about that. And I was wondering if you could, for one, bring up the slides again and talk about what information you have on that Mile High development, timing of it, exact location of it, and also maybe why this is not suffering from some of the same CPW issues as the concerns we're facing here.
Good afternoon, Commissioner Cross. Appreciate the question. I'm going to attempt to answer it, and then we'll defer to my colleagues for additional information should that be needed. And so I'm going to rely on a newly codified definition of reasonably foreseeable development that it was part of the most recent cumulative impacts rulemaking. And this Mile High proposal does fit that definition to a T. Specifically, the developer for this area has filed a permit with the city of Thornton for not only a change in land use, but also a large warehousing proposal. That information is available via the city of Thornton's website in their land use or development webpage. To that end, I'd be remiss if I said I knew exactly what the developer had in mind, as their plans have changed alongside ours in some respects, given the presence of this nest. To that end, the biggest difference between our application and what we're discussing here today, in my opinion, is the fact that the 1200 series rules require a consultation with CPW in this instance and require us to consult with that agency as we have, as you've heard today, and more importantly, bring that consultation before you for a decision. It's my understanding that other industries are not subjected to the same sort of regulatory requirement that we are. And so in a very simplistic manner, and again, this is where I'll defer to my colleagues, perhaps Ms. Gutierrez, in a very simplistic manner, if Mile High or any developer, for example, is able to get the concurrence of the agency which with statutory authority over a species that may trigger a coordination, then for all intents and purposes, barring any local requirements and local land use code, they're free to go about their business subject to whatever federal permit may be issued. With that, I'll turn it over to my colleagues to either fill in the gaps or potentially add to something I may have said.
No, Nate, I think that's right. My expectation is that CPW likely would offer its feedback and recommendation as to the development, but it is up to that authority to do with that what it will.
And kind of looking at the map here, just so I make sure I understand, and so the record's clear, what is part of the Mile High development filing versus what have you created? So I think on the map we're seeing on the left here, it says site. Is that the site of the nest? Is that the Civitas proposed site? Is that the site of the Mile High development? I'm just want to make sure that we have this clear for the record too.
Yeah, Commissioner Cross, sorry, I neglected to answer that in your initial question. I appreciate another opportunity to address that. So in essence, the entirety of the property that's contemplated or surrounds our proposed Washington oil and gas location, as well as the parcel immediately to the south and adjacent to this northern parcel, are part of their future development based on the materials that are available through the City of Thornton's website. Although I don't remember the specific number of warehouses, both properties are intended to be encumbered by warehouses similar to what you see up and down this corridor from a commercial standpoint. The exact number, as I mentioned, escapes me, but it's somewhere north of 6 individual warehouses slated for these properties. To that end, as our materials show, our well site will be just over 3 acres once the wells are in the ground and producing, and we've performed interim reclamation. That small footprint will be immediately offset to the south by the northern extent of their warehouse development.
Yeah, and if I may jump in as well, Exhibit D to our variance application is a copy of the LPC. I think that's right. As a copy of the LPC Mile High 1 development plan, and that contemplates looks about 7 warehouses in the space, all surrounding the Washington oil and gas location.
So a potential approval of this OGDP and variance would not affect what they're proposing as part of their development. Theirs would be directly to the south, which is where the nest is.
Correct. So the between the nest and the Washington pad will be a number of warehouses.
Okay.
Now, and I would also note, just associated with the development plans, that some of the development, and I think it may be further south of that, is also contingent upon the removal of the legacy well and pipeline infrastructure, right? So as the Washington pad, the Washington plan is approved, that legacy infrastructure comes out, which then enables developers further south to actually, move forward with their plans. But with respect to the
if this was not to pass, then the legacy equipment would not be removed, and that equipment or in that development would potentially not occur.
That's correct. I believe that's further to the south. The LPC development, though, as I understand it, is already approved. They have a Fish and Wildlife general take permit for their northern, so closest to the Washington pad. Those warehouses can already proceed, as far as I understand.
And that northern part is where the nest is.
Further north from where the nest is.
Further north.
So they have 2 phases of development. Their first phase, let's call it, is most adjacent to the Washington pad, and that, as I understand it, can proceed. And perhaps Nate can or Sean Casper can provide more color on that, but that is, as I understand it, is the current status.
Joe, I'll chime in real quick and anyone
Thank
can
you.
follow up, but just to clarify, it's actually the opposite. So their southern development has an associated general permit with U.S. Fish and Wildlife. The northern section I can't speak to, but I believe that there's something in process there. So.
And then Commissioner Cross, I might just add that, I think it's important to keep in mind as you're thinking through this, that we heard from Mr. Moret just a minute ago that his assessment was based on current ground conditions, but this commission has deemed that it's appropriate for itself to look at all reasonably foreseeable activity, this being one obvious and critical one.
And I think kind of continuing on at some of the potentials here and what would happen, there was some additional discussion of additional alternatives that were evaluated based off of this nest being identified. And so I was hoping that we could go into a little bit more detail. I know that we were kind of trying to get through things. And so I was hoping to go into a little bit more detail. And one of them that stuck out was, I believe it was alternative 12. And I think alternative 12 also talked about some, we'll call them non-operational limitations on it being able to occur. And I think if you were talking about it being with respect to contractual obligations, the developer agreement. And so I was hoping to get some more information on that.
Commissioner Cross, can you see the screen? Is that alternative 12 that you're?
It is.
Okay, great.
Thank you for the question, Commissioner. In regards to this alternative location, Alt 12, and any location near to it, it resides within the city and county of Broomfield. As you may recall in recent commission hearings in the last number of years, Extraction's Broomfield development was approved, and the operator agreement that is in place between the city and county of Broomfield and Extraction precludes any new wells, as it states in the agreement, to be pursued anywhere anywhere other than the well sites and the exact number of wells that are considered within that operator agreement. So while this location is a little further from our planned location and within distance that drilling operations could likely reach a portion of the planned DSU, we are not allowed to operate here.
Okay, so this one, it's not that Broomfield would be the proximate local government; they would be the
That's
relevant.
correct.
Okay. That's helpful to understand as well. And I know in some of your other alternatives, I believe 13 and 14, you both talked about the 960 not being able to be in reach. Maybe it was 14 and 15. 13. And I presume that's the 960 at the southern part of the DSU. Is that correct?
That's correct. Yeah.
And is there any alternative site that would be able to? Obviously, there's further development south as well, but a lot of the pictures we were looking at were further north, a little bit east, and trying to come across. Are there any potential locations to the south that would be able to develop that 960 acres?
Not that we were able to identify. As you move further south, you move into a more residential and built out area. So it becomes more difficult the further you move south.
Okay, so essentially it's, if we can't do your proposed location, you're either cutting off some of the 960. And I know in 13, 14, 15, you said no existing SUA. Was it possible to get an SUA in some of these locations, or because of, like, for example, 14 is up and it says you couldn't get the three-phase gathering, or did you not even attempt because of those kind of limitations on that?
We had yet to attempt based on the net mineral acreage loss.
Okay.
But anticipate that an SUA would be difficult in these areas as well as it is in most areas around this development.
Okay. And then and I'm not sure who's best to try and talk about this, but in trying to think of alternatives and ways we can get around this. And obviously there's different things. This will probably come up with Mr. Moret as well. But as we talk about, I believe under the CPW rules, it talks about 5 years without use of the nest. And that's obviously unless the nest is gone, like the tree is gone. But I'm curious if there are other ways for this to occur, given that there's apparently development that may be coming up and the nest may be subject to issues as well. I'm curious Civitas's position with respect to delaying this development until such time as the nest may be impacted from other resources as well. I guess not other resources, from other impacts such as development as well.
Commissioner Cross, I'm sorry, Claude, go ahead.
No, you got it, Nathan. Please lead the way.
I'll attempt to answer your question. And so as was demonstrated in the project timeline that was shared as part of the case in chief, there are a lot of moving pieces in this general area, but specifically with the subject properties on which our location is proposed. And to that end, I think we spoke we provided a lot of detail as it related to our negotiations and coordination with not only City of Thornton, Adams County, Seating County, Broomfield, but also the surface owners. And ultimately, the surface use agreement that governs our occupancy at this location is structured in such a way that it conforms with the conceptual development program that the developer has for these two properties combined. And so that's a long way of me saying that the way that the Mile High development is intended to proceed, as Ms. Hubbard said, is from the south to the north. They have performance metrics tied to their financing. I think they have commitments with would-be lessees for the spaces that they intend to build. And so our window of opportunity to occupy the surface that we've talked about at today's hearing is extremely limited. And so we are unable to wait for the warehouses to get built and then come in, if I'm understanding your question correctly, and develop this location, for the mineral resources that lie underneath. I say we're unable to do that because as part of our coordination with the surface owner and the Mile High development, we're sharing infrastructure such as roads. We're relying on the City of Thornton's, we're relying on the developer to help us meet the City of Thornton's fire code requirements to have fire suppression at certain distances from our would-be location in the unlikely event that is needed. And so on. And so it's very much a choreographed development for these two properties together, which has us, quote, going first as Mile High begins in the south and starts to head north.
That is helpful. And then I think one of the other things that I think would be important to look at, make sure we get clarified for the record as well, is Mr. Priscilla, perhaps if you can go to slide 60. This is talking about the number of trips, vehicle trips. So the commercial development east of Washington Street that's on the long-term post-construction, that's the existing development that's already there, not the proposed development. Is that correct?
That's correct.
And is the 3,158 trips, is that along the Washington Street directly where that is occurring?
That's correct.
Okay, and part of the reason I want to try and understand this is, and I think in the map you were just looking at, not to go back and forth, but I think it was slide 46. It showed the buffers, and so that the 3,158 trips are going within the quarter-mile buffer, regardless with what's existing, correct?
That's correct, Commissioner Cross. And I'll add one point to that if you look closely at that quarter-mile buffer, you'll note that all three entrances to that facility are within the quarter-mile buffer.
Okay. And then to get more clarity here, obviously this is a conceptual development, but can you indicate where the access road would be for the Washington pad here?
Mr. Pajala has his mouse on it.
Yeah, it's this black line right here. If you can see that where my cursor's moving.
Mm-hmm.
And is it so? And just as I'm looking at this again and understanding that's kind of where the oil and gas location outline comes from there, was there any alternatives looked at to have that access road or capabilities to have that access road not within the was it the 8th mile buffer there? So it would be kind of similar impacts to what that development on Washington is showing?
There were, thank you for the question, Commissioner. There were, we are unfortunately somewhat constrained for the same reasons that were mentioned by Mr. Bennett. It's worth noting that access road that Mr. Pajala noted is the temporary access road during pre-production operations. The permanent access road during post-production operations is commingled with LPC Mile High's development, as Mr. Bennett noted. As we move forward, we share the space. There really was only one other option to consider, and that was entrance and exits to the north off of E470, and that was not allowed. We additionally, it's worth noting that we are constrained by the existence of the Bull Canal irrigation ditch that Mile High will be rerouting as part of their planned development. We have an approved temporary access over that Bull Canal, but it's only temporary for the pre-production operations.
So in terms of the site itself, you really are limited to where you are because of the canal, because of what Thornton will allow, because of what the surface owner will allow, et cetera.
And also, if I may add, the existence of I-25 to the west and E470 to the north.
Okay. And again, I guess one point of clarification: the 3,158 trips, that's exclusive to the Washington development. That's not the Mile High that'll also have an access road that you would be using as well.
Those noted trips noted in slide 60, and Ms. Hubbard, speak up if you feel the need to. The 3,000 plus trips that were noted are connected to the existing development on the east side of Washington Street, not connected to LPC's development. So to the point of your question, yes, any trips associated with LPC would be additional to that.
And it would fall in the same line of what you currently have as less than one today, because it would be the same access road.
That's correct.
But that may happen regardless, depending on the development and how it occurs with the Mile.
Yep, that's correct. For the southern portion of their first noted portion of development, that has a clear line of construction, and I don't want to stray too far into matters that I may not have full understanding of, but for the portion closer to the nest, I think they're still working on how they modify or move that development forward, in part with the service.
If I may, I'd like to just add 2 quick points. The first being, just to clarify, this estimate for what it's going to be a target distribution center across Washington Street is from public documentation through City of Thornton. So we can't speak to the details of that traffic, but that's a public estimate that we found. And then the second point, we didn't bring this up earlier, but just want to point out, because of the agricultural activity that's already happening on this parcel, there is an access road that goes underneath the nest tree currently, and we will not be using that access road, but there is traffic that uses that access road directly under the tree at times currently.
And do you know will that access road be removed if your application was approved?
I don't know the answer to that question. I will defer to others if they do.
But that's a surface owner used road as is.
As far
Surface
as I'm aware. Yep.
Surface owner used and tenant farmer. In the near term, that access would remain, but as part of the planned development, that access will be removed.
And Claude, I think it's also an access for power utility companies, because I think we observed
That is correct.
power utility truck driving on that road right beneath the nest when we were our field site visit.
Yep, that's
And
correct.
were those trips being the observed trips, were those observed during the nesting season, or were those observed outside of the nesting season?
Our site visit, when we observed the trucks underneath the tree, that was outside. Well,
I believe it was outside the season. I can say for sure it was when the nest was no longer in use because we did confirm that before visiting the site.
And then I think that was already touched on. I think those are my only questions for now. I may have additional questions after I ask Mr. Moret some questions as well. Thank you.
Other commissioners with questions? Commissioner Messmer?
Thank you. Just a couple of questions. So the term reasonably foreseeable development was brought up in the testimony here. And I wonder, in evaluating, in developing your cumulative impacts plan as part of 304C19 rule requirement, and seeing how in some ways this oil and gas development is tied to a known commercial development, whether or not the cumulative impacts associated with that reasonably foreseeable development was evaluated and addressed in your cumulative impacts plan as it is associated to impacts to wildlife.
Thank you for the.
Yeah, go ahead, Nate.
Go ahead, Anna.
No, I was just going to offer, thank you, Commissioner Messner. The way you described the connectivity of the two projects, I think, is a little bit generous. Yes, they are choreographed, but Extraction does not have control over that project for purposes of doing anything.
And that's understood. Choreographed is probably a better term, but understanding that there are some things that seem to be dependent on one another.
Commissioner Misner, appreciate your question, and I do recognize I incorporated a newly adopted term that did not exist when we prepared this application, but I thought it was germane to some of the conversation that was occurring this afternoon. To that end, at the time that we prepared our permit application materials, had initial consultations with not only ECMC, but also relevant and proximate local governments. The development proposal, which is referenced in our ALA for this project with a hot link to the materials that are now available via public website. The project in and of itself was still going through the City of Thornton review process. And so, again, without the existence of reasonable foreseeable development at that time, we did not expressly contemplate the warehouse development on this parcel and the parcel to the south as part of our cumulative impacts plan.
Thank you, Mr. Bennett. I will note that in the statement of basis and purpose for Rule 304C19, it does contemplate the evaluation of reasonably foreseeable development and the addressing of that as part of the cumulative impacts plan in the current rules.
Thank you.
And sorry, Commissioner Messner, if I may respond to that, and we of course will take that back. But again, I think the proposed avoidance minimization mitigation on the table is unlikely to change given the development, right? It was considered in the larger ALA analysis, but in terms of the mitigation and impacts to receptors, I think you have before you what would be the same.
Understood. I'm just walking through required submittals as part of an OGDP and 304C19 and the associated analysis to address cumulative impacts is part of an OGDP submittal requirement. And as it's been brought up and talked about here significantly, both from the fact that that reasonably foreseeable development could potentially impact wildlife habitats, and then how this OGDP application ties into that from a cumulative impact standpoint, I think ends up being an important question as well, since it's part and parcel to this whole conversation. So that's why I bring it up. And then I wonder if we could talk a little bit about, I think, which is one of your root arguments, is this temporal avoidance. And if you could point to me the BMPs that specifically commit to certain temporal avoidances, dates, and how that avoids the potential impacts. I see the certain BMPs that are tied to it, but I don't see a lot of, and I could be missing it. It's a big application. I've done a lot of reading over the last couple of weeks, but specific dates that are associated with that temporal avoidance that would be an enforceable BMP.
Lila, I think this might be best for you.
Yeah, sure.
Real quick, Lila, let me jump in real quick.
Oh, go ahead.
It was the list of the BMPs with those dates, Commissioner Mesner, were submitted as part of the pre-hearing statement, but Lila can obviously speak to them here now.
Sure. Thank you for the question, Commissioner Mesner. One of the previous slides in the OGDP presentation did show sort of a timeline that Mr. Annable presented. And so in there, I know he did mention that the anticipated start would now be August 2025. That's a hopeful start. And so that's following the eagle nesting season. And then I can say that it would essentially be 2 occupations for 2 consecutive years, only in the months outside the nesting season, unless it is confirmed that the nest is no longer in use, as in if enough months have passed and the eagles are not using the nest, or if the nest has failed, as long as CPW confirms through consultation that that is the case, that would be an instance in which we may start during the season, but only if something like that were to happen and CPW agrees. But otherwise, the current schedule, the current timeline is to operate outside that nesting season, which is listed as December through July per CPW. We'd only be operating outside that season for 2 separate occupations. Does that answer your question?
It does. Thank you. That's specific enough for me. I think those are the questions I have right now.
Commissioner Oath.
Thank you, Mr. Chair. Just a couple of questions for Dr. Ramey. So it was noted a couple of times that this pair has occupied the nest for 2 seasons, but no eggs or evidence of offspring has been identified. Is that typical? Is that unusual? Could you put that in some context for me?
There we go. Sorry about that. Yes, be glad to. The birds, we don't know if these are the same pair of birds in 2022 versus 2023. And Brandon mentioned that he went out yesterday and saw a bald eagle and say, we have no idea if that's the same bird as previously or a different one. So for a few reasons, birds may not attempt to lay an egg. One of them is infertility. And we do see that in a variety of species. And it could be incompatibility. It could be age related. It could be due to some toxicity that can contribute to that incompatibility of the pair. It's no different than other animals. And also, it's not necessarily the same birds coming together. As bald eagle populations expand, there are a lot of floaters out in the population, so birds that don't have territories. And in fact, there's several papers about how sometimes the bald eagles are their own worst enemies because they're competing and trying to get to new sites and to find a place. So we don't know why they didn't. We don't know why they didn't lay an egg, or there's zero evidence of egg being laid. We don't know if they're the same birds, and we don't know why. So, all of those things out there are open questions. So, this gets referred to as a nest, and sometimes it's assumed it's the same pair. It's not necessarily the case. It's assumed that this is a critical site to the birds. There are a lot of trees out there, even in the urban environment, especially cottonwoods, and they do build their own nests, and they do take over nests of other birds. So we don't even know if they successfully nested somewhere else. So, unknowns out there. But, this does have bearing on it because we sometimes assume things that don't have a basis in fact. And so let's step back and be, a little bit wary of what is assumed as to what is a pair, what is evidence of, whether they had nested or not. I mean, there's no evidence out there that they ever had laid an egg. I've seen this before.
Yeah, I'm not sure that that's really getting at my question. So if we
Go ahead.
assume that, let's assume that they're the same birds, would it be typical for them to have for there to not be successful eggs for, a couple of seasons? Is that common? Is that not
It's
common?
possible. Is it common? If it's a mated pair, but you're assuming that it's a mated pair that are, tend to be together for the long term, and we don't have any proof of that. We have
Dr.
no.
Ramey, if I may jump in too, Commissioner
Go ahead.
Oath. Yeah, and I want to point out, Brandon mentioned that in the first couple of years, it is common for adult eagles to not be successful at a new nest site. We're definitely not arguing that. In fact, I would agree with Brandon's point there. That definitely can happen. The point of sharing that information, one, was to give sort of a nice overview of what's happening at this nest site that we were going to be talking about, especially because it's a new nest. Eagles will stay at the same nest site sometimes for decades. And so one of the points here is that we're not talking about a nest that's really well established and has produced successfully multiple years in a row. We're not talking about a well-established successful nest. We're talking about a new nest that seems to be having some trouble getting started. And regardless of all of that, the BMPs we're suggesting, especially avoiding the nesting season, should not interfere with that. They might continue to try to nest there. They might be successful next year. And the point of our BMPs is that we're not going to interfere with that. Our project could coexist with a successful nest site if that's where it leads. But the point of sharing that data was sort of to give you a better idea of the nest site that we were talking about and the history of it. I hope that helps.
That is helpful.
Thank you for that. That was very helpful. No, I completely agree.
Yep, thank you. That's all I have, Mr. Chair.
Following up on that question, kind of looking at the big picture, what is a pair? I don't want this to sound bad, but I don't know the answer to this. But if you had an eagles, and let's say this was a nest, and then something happens and they no longer use that nest, what do the eagles do? Do they no longer breed? Do they no longer try to find a different nest? I mean, what happens? Do they die?
They will typically try to find a new nest location, but that's going to be your short answer. But of course, it's all case by case, and it will depend on the situation, right? Of why maybe that nest fails or if there's something going on with that pair. But I would say the most common scenario in that case would be for them to look for a new location if there was something that, was not working about that location. Honestly, Brandon Moret might have something to add to that to give you
I'm going to ask him next.
Yeah, but more biology context there, but that's kind of the short answer.
Mr. Moret, are you still hanging with us?
Yes, I am, and I'm still following along.
Do you mind I might have another question or two for the applicant, but I'd love you to have a chance to weigh in on the question I just asked.
Yes, I appreciate that, Chair. And if I understood the question right, what happens if a nest falls down? And that was the first, let me say, that was if this situation were opposite, if this were a 1202C habitat and that nest tree fell down, that would be one where we would waive the situation. We can move on. But as Civitas mentioned earlier, there was an eagle nest north of E470, and that nest unfortunately fell down. So as Dr. Ramey identified, yes, we don't know if this is the same pair or not. We actually did attempt to contact the landowner and had initial conversations to actually put a transmitter on these to figure out, is this their primary nest? Do they have a secondary nest? Is it the same pair? But those efforts were unsuccessful. And so, yeah, if eagles will try to find the next best available tree in their nesting territory. And that's why they took over this red-tailed hawk nest that's been known to CPW since 2010 or so. So this nest has been on our radar, but obviously red-tailed hawks aren't an HPH species. Does that answer your question?
Yeah, no, I appreciate it. So before we turn to Mr. Moret, give him a chance to weigh in, do other commissioners have other questions of the applicant panel? Trying to keep this moving. All right, well, then I think the segue, Mr. Moret, is to give you a chance to sort of respond to anything that you heard, to provide some perspective back to commissioners. So
Great.
We'll start with that open-ended question.
Okay, sounds good. And I appreciate Civitas's continued conversation on this. And, you know, one of the things that I keep hearing for this, let me move my screens over here, is, you know, why aren't these measures protective for wildlife? And you know, the main concerns are, you know, when you impact a quarter-mile buffer, and can we also take down that slide?
Yeah, that's a great idea. Let's take down the slide, please.
And so the main concerns of impacting an unmitigatable quarter-mile buffer, it's all of it, direct, indirect, cumulative, light, traffic, noise, changes in landscape, food sources. Also, extraction can't control the timing of future unexpected leaks or spills that could occur during future breeding seasons. And that would require an increase in human activity and equipment. I've worked with reclamation staff for other spills that are in the nesting season. And it's a headache, if I could be quite frank, to deal with those restoration activities, but also being protective of the nesting season. And so, you know, we had these same recommendations that we sent to the city of Thornton regarding the warehouse development too. But, you know, I asked the commissioners, you know, why should we try to find COAs or tiptoe towards the line of nest failure? Like, how close is too close? Is it a quarter mile? Is it an eighth mile? Is it, you know, outside the nesting season? Regarding the further explanation of highly developed area, let me share my screen with you all, if that is allowed, Chair.
It is absolutely allowed.
Can you see my screen?
No.
Okay.
Or not yet.
Maybe now?
Yeah, now we can see it.
Okay. So in the middle, obviously the red X is the eagle nest, and you can see the proposed development within the quarter mile. So again, this is per ECMC's rules that this is the NSO. And so when you look at this, you know, the first thing you can look at is, yeah, you got E470, you don't have I-25, you don't have the on-ramp, you have Washington. But based on my biological expertise, that's kind of background noise to these eagles nests. And I do appreciate extraction doing the noise and light study. But for this, when you look within that, there is a couple sheds to the southeast. There's and I believe that's a well that's been P&A to the southeast as well. But for the most part, besides the substation, you know, this is relatively undeveloped and has minimal human activity associated with it compared to other ones that we've seen. I'll stop sharing. But, you know, eagles, you know, can be like people. You know, there are some that like to be in the middle of the action. I've during a previous consulting gig, I saw a hawk nest literally on the edge of a sand and gravel mine. So some raptor species can be in the middle of development. Some need big buffers and they wouldn't tolerate this. But for this eagle pair, whether or not it's the same one as last year as this year, they chose this site given the background noise of the highways and the utility station, and there's food sources there. So I wanted to just talk about that a little bit. And also, we did discuss and Extraction brought up a good point when we were in the field, with the target development to the east. We did consider those, but those are temporary, work sheds that were on the east side of Washington, on the other side of the traffic, not on the west side. And also, regarding Topgolf, I know that's come up a little bit, and I can't speculate on a possible future warehouse development. As some of you may or may not know, Topgolf was originally had a sign and installed utilities southeast of I-25 and 144th. It wasn't at this location. And so I thought there was going to be a Topgolf down at 144th, and that's likely foreseeable development, right? However, the homeowners had major concerns, and that's why this development got pushed north of 152nd. And also associated with that, the likely reason that there aren't any advocates that chimed in during public comment is because this is a relatively new nest, and so no neighbors to regularly view this nest. And also with Topgolf, those lights are primarily focused shining to the north. If you've ever driven south on I-25 at night, you may have just seen that blinding light. Per Commissioner Cross's comment about Extraction's Alternative 12, for the record, I would note that bald eagle nest has been destroyed. So if that was an option that Extraction wanted to explore further, we could discuss that. But, commissioners, at the end of the day, we've made it known what CPW's position is, and this is an unmitigatable 1202C habitat. There isn't a dollar amount to impact a 1202C habitat to replace it somewhere else, because these are the most sensitive resources in the state. Civitas is asking for a rule change, but we're asking for the buffer to be applied. So I can answer any other questions. Chair.
Yeah, I'd like to ask you a question that segues off that last piece. So in your opinion, Mr. Moret, if a proposed location ticks an NSO, is the operation just not allowed? And I ask that because we do have within our SBP that while we created the NSOs, we did recognize in a number of different instances that the variance process could be utilized provided it established that additional or different avoid, minimize, and mitigate protections happened. But I'm not sure I'm getting that nuance from you and from CPW, which that may be your case. You may be, look, if it ticks one of these, then nope, we can't support it. So I'm trying to figure out what the position of the sister agency is.
No, and I appreciate that question, Chair Robbins. And it is case by case. I mean, there are definitely cases where, like I know there's a bald eagle nest off Smith Road in Aurora. That's a highly developed area in my mind. But it is case by case. That's why there's on ramps, off ramps. But for this particular case at this time, for the hearing, based on current ground conditions, all those factors considered, that's where we stand with this case. But obviously the commission can make other, approve, deny. They can, make other conditions of approval for this one, but that's where CPW stands.
Okay. Well, no, I appreciate that clarification. Because if CPW didn't recognize that, the case by case variance, I would have a concern about that, because I think we have these NSOs, we utilize them, but based upon the circumstances, there may be alternatives for the commission to make different findings. And I just wanted to make sure I wasn't wrong about my assumption of where the sister agency stood. So thank you for that clarification.
For sure.
Other questions for Mr. Moret? Commissioner Messner.
Thank you. And thank you, Mr. Moret, for being here. And, really appreciate your expertise and your opinion. I know it's hard sometimes here to sit up here and have people criticize your opinion. But I do know that I admire and respect CPW and the opinions that they provide the state of Colorado. So based on some of the written testimony that you provided in your consultations, I mean, what I understand, and then tell me if I'm wrong, I guess, is that you are concerned about this potential warehouse development from the city of Thornton because you provided comments to the city of Thornton indicating that you're concerned about the potential impacts of that associated with this bald eagle's nest. And you've also provided similar comments to this OGDP process at the state level, indicating that you have unresolved concerns associated with the potential direct impacts associated with this proposed development to the bald eagle's nest. Those two things are correct, right?
One slight clarification. They're not unresolved, they're unresolvable.
Resolvable. Sorry, better. That's the term you used. And so can I assume that from a cumulative impact standpoint, if you look at both of these developments together, combined, that would also create unresolvable cumulative impacts associated with the potential impacts to this bald eagle's nest? Is that fair to say?
That's fair to say.
Okay, thank you for that. I wonder if you would share your thoughts on temporal avoidance.
Temporal avoidance is a great.
I think I made it sound like tempura, temporal.
Yeah, temporal avoidance is a great tool. And it is one you did hear during Extraction's testimony that there were times that CPW didn't get back right away. That is very uncommon for me, but that is where we had further internal conversations amongst coworkers and our SMEs as far as, is this appropriate? Is that an appropriate path forward? But we were concerned about the precedents that would set, that let's show other operators about if they just pay $25,000 and work outside the season, they can impact 1202C habitats. And so we were concerned about the danger in that precedent setting.
Thank you for that. I appreciate that.
If I may interrupt briefly,
Mr. Pashala, just let Mr. Commissioner Messner, I'll get you back to you.
Thank you. And if I have any other questions for Mr. Moret. I think I don't have any more questions for you, Mr. Moret. I think you made your position very clear in your written testimony as well as your statements today. So thank you.
And Mr. Moret, let me ask just one follow-up. So you've mentioned this precedence piece a couple of times in your testimony. So I just want, in line with my questioning earlier of we've got NSOs, they're applicable, but in certain circumstances, based upon the case-by-case basis, a variance could be arrived at because it creates additional avoid, minimize, and mitigate. So in my mind, I don't look at that as if we grant a variance in one particular case, that creates a precedent for future cases. That's just me talking, but I just want you to be aware of at least how one commissioner looks at the decision tree.
Thank you, Chair Robbins.
Now, I think, Mr. Pashala, let me see if anybody else has questions of Mr. Moret, and then I'll recognize you. Commissioners, any other questions of Mr. Moret? Commissioner Cross?
Thank you, Mr. Chair. And thank you, Mr. Moret, for being with us here today. I do want to try and make sure that I understand a couple points. You talked about it being on a case-by-case basis where a variance may work. And you mentioned an example of a nest in Aurora, and I didn't catch the name of the street, but you said that's a highly impacted area, correct?
Yeah, Smith Road, which parallels the train tracks over in Aurora, like I-70 and Havana-ish.
Okay. And so when you say that is a highly impacted area, is that highly impacted under the definition you talked about? Because I know you said there aren't 10, let me make sure I get the language right, 10 daily structures today at this proposed location. Is it a highly developed under that definition on Smith Road?
Correct.
Okay. And I think one of the things that I want to make sure I understand, you said other than the power station that's within the quarter mile. Yeah, there's a little bit of Washington Street, a little bit of 470, but it avoids I-25, it avoids the on-ramp, it avoids some of the other stuff. I'm curious about the power station and your thoughts on the power station. What impact, if any, would the power station have on the Eagles?
And that's where, and I appreciate the question, Commissioner Cross. That's where, the substation, that's been there for decades, but it's not expanding further west, further south, closer to the nest. And so there is regular work that is occurring there. Is it going to be the same number of vehicles every day? No. Is it going to be the same number of humans? But like with several species of wildlife, they have a flush distance, right? And so, given where that location is, they are comfortable with that activity that regularly occurs there. Just like it's a wheat field underneath the nest and near the nest that the landowner plows and harvests once a year. That's a regular activity that this eagle chose to be acceptable with. Just like you and I choose to live in certain neighborhoods or certain cities because they have certain amenities that we desire.
Okay, and so I'm curious then, if they do avoid the nesting season and it's a tankless operation, and so under what they've proposed, they're being and setting aside, and I think it's a good point you make about the potential spills, and obviously that would throw a wrinkle in everything because you can't control when spills happen, if they happen, et cetera. So I think that's a very good point. But if setting aside a potential spill, if they were to have a production site, but everything occurring, construction, drilling, completions occurring outside of the nesting season, do you think that would change what they're used to, given that maybe there's a truck a week going to the substation, if there's a truck a week going to check on anything that can't be done with the remote checks at the production facility? Do you think that is enough of a change to kind of throw off what they're used to there, especially if they do have the traffic? And I guess that kind of leads to my second question is the traffic really the concern here, or is it other things associated with the site?
Thank you for the question, Commissioner Cross. And yeah, I mean, just like I can't foresee the warehouse coming in, I can't foresee if there's going to be a spill or blowout or whatever associated with that. But why eliminate more habitats within the quarter mile? Why eliminate their food source, which is prairie dogs? Why tiptoe as close as we can to the nest and see when is the straw that breaks the camel's back? If this were a 1202D habitat and it's outside the nesting season for big game, for instance, yeah, I mean, this would be a no-brainer. But, given how CPW's mission is to protect these species for current and future generations, this is just one where I can't get my head past that it's going to be an impact within a quarter mile.
Okay.
But so I did consider it. We considered it over several months. We had several conversations with Civitas. It was just, we could not get to that place where, at least from CPW's standpoint, that is protective of wildlife resources.
Completely understand that. And to make sure I clarify the record too, it's not necessarily the traffic, because there is a traffic on Washington Ave. You're saying it's also eliminating some of the potential food source with the prairie dogs, etc.
Exactly. And it's also the timeline of, this well being there 30 or 40 years, because on the back end, which you guys don't really see, is all the consultations I have with P&As during the nesting season. We need to get it done now. Oh, Brandon, we need to do an MIT, during the nesting season. And so there's just all these cumulative activities that need to occur after it goes in. Sure, in and of itself, it can be very benign, but it's all the unexpected that we don't want to have in the 1202C buffer.
And were any of those issues, such as doing the P&As, et cetera, Was there any discussion of making sure that P&As and other issues occurred outside the nesting season as well?
That is usually our goal, but sometimes there are new developments that are outside the buffer that cause P&As within the buffer.
Okay. And then I think let me just double check my notes here. I think my last question is going back to what Ms. Gutierrez said, and that was when we're looking at the no net adverse impacts within a variance request. When we're talking about the mitigation to kind of offset impacts that do occur to get to that no net. I know one of the things that you've talked about is the impact to this pair, this eagle pair, and as you said, I think it's hard to get around the impact to that pair. But as Ms. Gutierrez said, under the rules, we also talk about mitigation of adverse impacts being with respect to the population. And I just wanted to make sure you had an opportunity to respond to that as well.
Yeah, and again, that's another point that we considered, but at the same time, I don't want to have a minimum standard for impacting a 1202C. I mean, I appreciate their creativity to try to find a path forward. And I thought long and hard, again, this has been over, just about a year that we have been consulting on this, but in my mind, it just reached an impasse when it came to this eagle nest. So, but yeah, I mean, yeah, we are where we are, and the commission can decide to side with that or go a different way or condition it. So,
but as it stands now, it would be your focus is on the impact to this pair, and really something you can't get past this pair, not necessarily population impacts, but
correct.
This pair you can't get.
Correct.
Okay.
Thanks for that clarification.
I think that's my only questions. Thank you.
Other final questions of Mr. Moret? All right, seeing no further final questions, Mr. Pershala, you're recognized.
Thank you, Chair Robbins. Yeah, I just wanted to, there's been this implication that Extraction has been offering to pay $25,000 to essentially buy its way into a variance. And I don't know where that's come from. And I object to that characterization of the application before the commission here today. I would say that what's interesting is that in the regular course of oil and gas development plans, operators are continuously working with CPW to contribute mitigation fees for direct and indirect impacts. So the characters and what's significant is that CPW will not even entertain any sort of compensatory mitigation associated with this project. So the implication that somehow Extraction is trying to buy its way into a variance, I strenuously object to that characterization. And what's more is the $25,000 payment that was referenced, that was a voluntary mitigation effort undertaken by Extraction, given that CPW was not even willing to negotiate or participate in any sort of mitigation, as you've heard. There's apparently from CPW standpoint, there's simply no mitigation that would satisfy Mr. Moret and his colleagues. So in that work with Birds of Prey, that was just very recently. That was something that's been worked on. We've been communicating with them, and that just came into play in advance of this hearing that we finally reached an ability to help them, and they were very appreciative of that contribution. And in addition, about compensatory mitigation, even if this was to be characterized as compensatory mitigation, which it's not, the best management practices and the seasonal avoidance alone are protective of this nest and this breeding pair, assuming it is the same breeding pair. So I just wanted to point that out, that this is not, there's no payment that Extraction is offered to make to CPW or any other party to buy its way into this variance. We are proceeding under the rules as they're prepared. This is a fact and scientific analysis that we've engaged in order to support our request. And I believe my colleague Ana Gutierrez has some comments that she would like to make as well.
Ms. Gutierrez.
Thank you, Chair Robbins. Just one other piece that I thought it was important to respond to, or at least offer a touch of a different perspective, and that is with respect to how Fish and Wildlife Services program was characterized as compared to CPW's. So I don't disagree that Fish and Wildlife's program under BAGIPA started on the basis of avoiding or stopping or mitigating shooting and trapping. And that is not what we're dealing with here, right? Extraction is not in that business. But as society has evolved, that program in and of itself has evolved. And now you see in the Code of Federal Regulation, Fish and Wildlife Service, quote, works to manage and conserve both bald and golden eagle populations. Quote, we provide guidance on living and working near eagles. And take, for example, the U.S. Fish and Wildlife Service land-based wind energy guidelines. That's clearly something that's focused on the conservation of the species and populations and not focused on trapping, shooting, and taking of the pieces and parts of a bird for sale on the market, which again is how this all originated, but not where we're here now. So I do want to be clear that Fish and Wildlife Service is equally as focused on conservation of these species. They do have an important opinion here, and it is something that I would encourage this commission to consider as you deliberate.
Thank you both very much. Anything further before we move to deliberations from either of the lawyers for the applicants?
Nothing more for myself.
Nothing further, Chair. Thank you.
Okay. I need a couple of minutes to gather my thoughts. Let's return at 4:14. That's 4 minutes out, and then we'll go into deliberations. All right, commissioners, we're back on the record in the aforementioned dockets, and we have now had testimony and evidence. We've had questions and answers, and we now move to deliberations. Who would like to provide some initial input on deliberations? Commissioner Ackerman?
Thank you, Mr. Chair. And again, thank you to all of the parties. This has been an extensive process and a difficult one on all sides. We certainly recognize that. And I, for one, don't take those efforts lightly. These are impactful decisions and impactful discussions on a number of fronts. We talk often about the mission of ECMC, and it certainly is set forth in statute. And we often cite that it's our direction to regulate the development and production of oil and gas in a manner that protects public health, safety, welfare, and the environment and wildlife resources. And that clear intent really is to protect wildlife, is what I'm focused on in this discussion, is really threaded throughout the Act. And then ECMC rules are the vehicle that we use to implement the intent of that statute. Specifically with regard to the protection of wildlife, our mission change statement of basis and purpose on page 172 states, the Commission recognizes that even with annual rulemaking, wildlife or habitat may change as they are dynamic elements and maps will necessarily remain static. The Commission also understands the importance of employing the mitigation hierarchy to address different wildlife habitats that are currently not mapped as part of high priority habitat. So to me, I wanted to talk about some of the ECMC rules that I think are pertinent to this discussion. And the first one would be 309E1, and that's the rule that addresses CPW consultation. And it reads, the purpose of consultation with CPW is to provide the director the information necessary to determine whether an application protects wildlife resources and whether conditions of approval are necessary to avoid, minimize, or mitigate adverse impacts to wildlife resources associated with high priority habitats and protect against adverse impacts to wildlife resources resulting from oil and gas operations. The statement of basis and purpose on page 171 furthers that thought by stating the Commission developed a definition for high priority habitat, which focuses on ensuring healthy wildlife populations by deferring to the expertise of CPW in identifying the species and habitats for which avoiding, minimizing, and mitigating impacts is critical based on the best available science. The next regulation that I think is applicable is in 309 in that same regulation, E2D. And this is the consultation on-ramp. And that requires consultation where CPW requests consultation or because consultation is necessary to otherwise avoid, minimize, or mitigate reasonably foreseeable direct, indirect, or cumulative adverse impacts to wildlife resources from a Form 2A, OGDP, CAP, or other matter. Again, the statement of basis and purpose clarifies the intent of that regulation and states that that the rules provide on-ramps and off-ramps to consultation with CPW in order to ensure related protections for wildlife resources in the 1200 series rules can be appropriately applied. And so I would say the mid-process discovery of a sensitive species or habitat and a resultant consultation in order to appropriately address impacts to that species is a good example of the need for this on-ramp rule. And so in this case, the appropriate 1200 series rule to be applied, as has been mentioned a number of times today, is 1202C1, appropriately titled No Surface Occupancy Habitats. And it states that operators will not conduct any new ground disturbance and well work, including access road and pad construction, drilling and completion activities and flow line utility corridor clearing, and installation activities in the high priority habitats listed in Rule 1202C1. Bald eagle, of course, as we've talked about, within a quarter mile of an active nest is listed in those no surface occupancy habitats. And the mission change rulemaking basis and purpose statement again states the specific habitats and management areas listed in that rule are the most sensitive wildlife resources in the state, and avoidance of these areas as the single most protective strategy is supported by robust data in the administrative record, including evidence provided by CPW. It further states in Rule 1202C, the Commission modified its prior restricted surface occupancy rules to align the restrictions to the high priority habitat system and to conform to CPW's current no surface occupancy recommendations for habitat and species protection. So those that had been developed independently and prior to their introduction to this agency in the mission change rulemaking. The basis and purpose statement then further addresses 1202C, and it states that this rule 1202C provides the best example of how the Commission has updated its rules to reflect the mitigation hierarchy contemplated by Senate Bill 19181. And the Commission reiterates that the obligation to mitigate unavoidable adverse impacts occurs only after operators seek first to avoid and then minimize impacts from oil and gas operations. And finally, the basis and purpose statement on page 183 states the Commission acknowledges that based on the recommendations provided by CPW, avoidance is the single most effective protection strategy for the listed high priority habitats in Rule 1202C1, because impacts to these habitats are difficult or impossible to minimize or mitigate. So to me, the key summary points from our rules are that these rules that I've talked about highlight the importance of CPW's consultative role in identifying species and habitats for protection, and specifically do so under the mitigation hierarchy. And they do address the contemplated scenario in which a sensitive species or habitat may be discovered and addressed during an OGDP process by providing an on-ramp. And I think the key point is that 1202C doesn't allow any new ground disturbance and well work in these habitats, including access road and pad construction, drilling and completion activities, and flow line and utility corridor clearing and installation activities, which then, of course, necessitate the variance. So during mission change, we held up this specific rule, 1202C, as the primary example of how we intend to properly employ the mitigation hierarchy. And we also clearly recognize that this specific habitat, bald eagle nest, was difficult or impossible to properly address other than through avoidance. Now we bolster a lot of applications through BMPs, and what's commonly included in those applications as a BMP is surveying for migratory bird nests during the nesting season, and then protecting active nests with buffers. And that's not just the BMP, but it is also set forth in Regulation 1202A8. And while that regulation is more inclusively written for migratory birds in general, and migratory birds is a term that also includes bald eagles, the intent is to protect active nests, largely through the establishment of appropriate work zone buffers around active nests if they are discovered at any point in the development. And so to the variance, the variance process, as we're very familiar with, has 5 points to it. And the first point is a good faith effort to comply. I find in my study of the materials and in listening to the hearing here today that point has been complied with. There has been a very good faith effort to comply with the regulations. On point two, it will not violate the basic intent of the act, and I'm speaking specifically to protect wildlife. I do not find that it complies with the basic intent of the act under our interpretation of what is necessary to protect no surface occupancy habitats. Number three, necessary to avoid an undue hardship. I believe that that standard has been met and that this will be a hardship upon this agent or upon this operator if not granted. And then the next will result in no net adverse impacts to, among other things, wildlife. And CPW's conclusion, as we've heard, is that oil and gas operations or other types of developments at this location will likely cause this eagle pair to abandon this nest, causing an adverse impact. And there, I would say that this does not comply with that stipulation of the variance. And finally, contains reasonable conditions of approval or other mitigation measures to avoid, minimize, or mitigate adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Again, NSO habitats are those habitats in which avoidance is generally the only viable protection alternative. And so I do not find that it complies with this stipulation either. The statement of basis and purpose language actually addresses variances specifically in the context of 1202C1, the no surface occupancy habitats. And it states, as with all of the commission's rules, if circumstances in an individual case require a variance from the commission's rules, and the variance is equally or more protective of public health, safety, welfare, the environment, and wildlife resources, an operator may seek a variance pursuant to Rule 502, in which case I think those points would have to be met. My finding is that based on CPW's professional work on this OGDP, the suggested mitigative efforts aren't equally or more protective of wildlife than compliance with the rule would be. So, I think that really my key thinking here is that the intent of wildlife protection statutes and rules is dynamic and fluid, and they recognize that wildlife are not static. And this case begs the question, because this nest, which has been successfully used by bald eagles for the past couple of years, was discovered mid-process, does that then negate its eligibility for protection under the rules? And I don't believe it's the intent of our rules that the most sensitive habitats in the state should be frozen in time and are simply out of luck if they evaded detection long enough or didn't construct their nests within the appropriate schedule of our habitat map updates. Again, the intent of the statute and the regulations is to protect wildlife, and a significant component of that protection is consultation with state wildlife experts at CPW. In the mission change rules, we worked diligently to make the HPH process usable and predictable in most cases, but while also incorporating provisions to appropriately protect wildlife in regular and special circumstances. The 1202C this application falls under the HPH maps at the time of filing for consideration, but not for new disturbance, as I've noted, and that variance would be then necessitated. So importantly for this discussion, as I mentioned, our rules intentionally added an on-ramp to address special wildlife circumstances, which was used in this situation. And this situation does qualify for consideration under that provision at 309E2D, in my opinion, as bald eagle nests are, as has been mentioned a number of times, amongst the most sensitive habitats in the state. And it's been made excessively clear that they should be afforded a high level of protection. So then if the habitat qualifies for consideration of protective measures, I think the question asked, and I apologize if it was you, Chair, I think it was Commissioner Cross, asked, are the protective measures proposed by the operator sufficient then? And to me, it's been clearly established by CPW and within ECMC's mission change statement of basis and purpose that avoidance is the most effective and sometimes the only way to protect no surface occupancy habitats listed in 1202C. That's what is found in our regulations. Unsurprisingly then, CPW's professional judgment is that avoidance is necessary to protect this particular habitat. And also, unsurprisingly, CPW's professional judgment differs from the professional judgment of the operator's witness who was hired to promote its occupation at this site, who, as we heard, is of the opinion that really no level of no surface occupancy for bald eagle nests is appropriate, which is a concept that, right or wrong, significantly deviates from our historic protective measures here in Colorado. as has been stated, we can't predict the future. That's a tough situation, and we won't know precisely what will cause the abandonment of this nest if it is ultimately abandoned. And so we have to rely upon the best available science and the informed position of Colorado's wildlife experts, who is CPW. I'm not swayed by an argument that future, although I'm sensitive and compassionate, I'm not swayed by an argument that future development of other types will cause abandonment of the nest. We don't regulate that development. And as such, to me, we're obligated to evaluate the impacts of the development that we actually oversee. And I'm also not swayed by a request for a reliance on the 1/8 mile buffer for developed areas. But even if I were, as I understand it, all access points to the site would also violate that buffer. And so a variance would be needed even if the buffer were reduced. And finally, I just do not see a no surface occupancy habitat as a starting point for discussions of how they can be mitigated, but rather exactly that they are no surface occupancy habitats. That's what they were intended to be at the time of the mission change rulemaking. Now, the great majority of the time, we're able to find solutions to work around wildlife. And I think that's been evidenced by the history of permitting since mission change. We're often lambasted by certain groups by the number of permits that we approve going forward, or that we've approved going forward since the rulemaking. And we've had high quality of applications and have approved many applications. CPW has often been flexible in seeking those solutions. That's been their history since mission change, and sometimes being even more flexible than I might be. And our rules clearly set forth that some habitats in this state, including bald eagle nests, are identified as the most sensitive habitats. Extensive discussion during the mission change rulemaking hearings, as well as the basis and purpose language that I've talked about, clearly demonstrate that bald eagle nest zone buffers of 1/4 mile are generally only properly addressed through avoidance. And as such, the situation this operator finds themselves in this OGDP, while very difficult and unfortunate, shouldn't be surprising. In cases like this one, if the operator continues forward with an OGDP contrary to the vehement counsel of an expert consulting agency, and then ultimately reaches an impasse with that agency, in my opinion, it should also not be surprising if that situation remains at that impasse after review by this commission, as the commission and CPW both share a statutory charge to properly protect wildlife in the state. So those are my initial deliberative thoughts, Mr. Chair and members of the commission. I think it's pretty clear that I am not in favor of approving this application and this variance.
Thanks for leading off, Commissioner Ackerman. Does anyone want to go second? Commissioner Messer.
Thank you, Mr. Chair. Thank you, Commissioner Ackerman. I don't really have a ton to add, and I think that you hit all the points that I had intended to hit and more, and cited the same rules and areas in the statement of basis and purpose. I think we have 2 decision points here. We've got a decision point on the OGDP. In my opinion, because of the rule not adherence to Rule 1202C, the OGDP is not approvable. In addition, I think that as particularly identified in testimony here today and in the application submittals, properly evaluating and addressing the cumulative impacts associated with this development as it pertains to wildlife in an area where there is reasonably known foreseeable development. In fact, this development in some ways is I can't remember the term that Ms. Gutierrez used, but there's a level of coordination or support between the 2 developments, this OGDP application, which we do regulate, and another development in which we don't. But it's clearly been indicated by testimony by Mr. Moret that the cumulative impacts associated with both of those developments that CPW has provided consultation on is problematic as well, with unresolvable issues. I think this agency during the mission change rulemaking determined that this level of protection is reasonable and necessary for species in 1202C1, and the record is clearly documented from that rulemaking through expert testimony and evidence. The state standards are more stringent than the federal standards in this instance, as they are in many different segments of our rules. Our rules in the Act require us to protect wildlife by proper application of the mitigation hierarchy, which clearly indicates that avoidance must come first. In fact, the applicant's witness testimony from Dr. Ramey indicated, and I quote, "Avoidance is the first strategy." Our rules also clearly lay out that a variance process is appropriate in instances when non-adherence to the NSOs within our rules are contemplated. And I think Commissioner Ackerman has indicated in the statement of basis of purpose in the rules where that is contemplated. In that situation, the applicant does bear the burden of proof and not CPW. And so I believe in this particular situation that the applicant has not met their burden of proof in the variance application for the reasons indicated by Commissioner Ackerman. And so therefore, because of non-adherence to Rule 1202 C1, no surface occupancies, I also think that the OGDP is not approvable, as well as some missing information for how they're evaluating and addressing cumulative impacts associated with wildlife in their 304 C19 cumulative impacts analysis. So those are my comments, Mr. Chair.
Thank you, Commissioner Messner. Others with comments? Deliberative thoughts? Commissioner Oath?
Sure, Mr. Chair, thank you. And thank you both, Commissioner Ackerman and Messner, for your sharing your deliberative thoughts. I can be brief because I am in agreement. I do believe that given the structure of the rules and this situation that a variance would be required. And I, despite very good faith efforts by this operator, and appreciate all of those efforts, I agree that a number of the criteria for the granting of a variance have not been met in my mind either, for the reasons articulated previously by Commissioner Ackerman in particular. And so I also am unable to support this application.
Commissioner Cross?
Thank you, Mr. Chair. Given how it looks like it's coming out, I'll try and be brief as well here. I'll start off saying that I do think that this is an approvable OGDP. I think this is an interesting circumstance given that the variance, which has been previously stated, would be required under 1202C, kind of goes hand in hand with the OGDP. And so it's admittedly a bit of a unique situation here. I do think that they need to be viewed separately. So in looking at it, I think the OGDP itself is approvable. And so then we have to go to the variance itself. I think that I'll just start off saying I think I want to address a couple points because I think this is a unique situation. First, I agree with what Commissioner Ackerman stated about the citations to both our rules and the statement of basis and purpose. It was also brought up by Mr. Moret as well. The 1202C habitats are the most sensitive habitats. And as was stated, avoidance is the most effective protection for those habitats. I do think it's important to note that it doesn't say avoidance is the only protection, but it's the most effective. And I agree with that point. I think it's important to highlight a couple of the unique aspects that have come up with this. For one, during our cumulative impacts rulemaking, there was a lot of discussion about no net adverse impacts and how they should be, whether they should be utilized, how they should be utilized, et cetera. And I think that this is one of the areas where it's important to highlight the difficulties with no net adverse impacts. Under our variance rules, a variance can only be granted if there is no net adverse impacts to the resource. And I think one of the important things here is when you look at the overall plan, it's a very different way to look at overall impacts and the net adverse impacts versus looking at the specific resource. And by that, I mean, when you look at the amount of surface disturbance that's being removed from the P&A and of wells, the amount of older legacy wells that are being removed, the VOCs removed, et cetera, we're actually having a lot of benefit from the proposals provided by the operator here. But that's very different than the net adverse impacts to the specific resource. And so I think that's an important thing to highlight, is that you do have to make sure that we're very clear on how we look at these. I'll say I've been having a very tough time with the variance itself. And I think it's because I understand where both sides are coming from. I do understand Mr. Moret's point that if you look at the fact that we're within the buffer, and I agree, we're not here to just discuss whether the buffer is appropriate. I'm glad that CPW is going to be continuing to do more research and provide more studies in the future as to whether buffers may need to change when it comes to some of these things. So I'm glad that that additional research is being done, because based on some of the things we heard from Dr. Ramey, it sounds like maybe those buffers are already being changed when looked at by other agencies like Fish and Wildlife Service. So I think it'll be important to look at that. But that's not what's really being looked at here. The fact of the matter is we have to look at 1202C. Because 1202C applies, we have to look at it as a variance. And so one of the things that stuck out to me is I think there are a lot of impacts currently to this nest. Based off of the publicly available information, there's already 3,158 truck trips a day within this quarter-mile buffer that's being talked about. And so once you take into account not doing any of the pre-production operations during the nesting season, we're maybe only talking about one truck trip or less a day that is being added to that. And so when you look at it from that sense, I don't know that there's that much more of an impact from the operations being planned. But as Mr. Moret said, it's beyond just the truck impacts. It's beyond just the light impacts. It's beyond just the noise as well, because part of what's also being done here is there's some impacts to the prairie dog habitat and potential food sources as well. And so I think that that's important to look at as well. I think one of the difficult things is trying to assess what may happen, what may not happen. And as Commissioner Ackerman noted, it's very likely that this nest may not be here in just a couple of years because of ongoing development aside from the oil and gas development that's proposed here. We can't really look at it in that way, though. We have to look at what we have today, because we don't know that additional development will occur that may take down this nest or anything of that sort. And that's why I wanted to try and make sure that we looked at additional alternatives, looked at the potential for maybe delaying the construction of this to see if in a couple of years maybe the nest isn't there anymore, is not successfully being used anymore, and maybe that would change CPW's position on this. Overall, I really find this to be a very difficult variance to look at, because I think that not trying to utilize one definition of highly developed area versus another, I think there is a lot of development in this area. And so I'll be honest, not having the scientific background of being able to say, the minimal additional truck trips is going to have an impact or is not going to have an impact. I have a hard time looking at that. And I do think that it's important to, at that point in time, to look to our sister agencies and for their views on that. I do find it important, Mr. Chair, as you recognize, trying to say there does need to be situations where a variance can occur. And looking at what was mentioned by Mr. Moret, the issues like the Smith Road example that he provided, there are times where a variance may be applicable. And he indicated that they couldn't really find that here. I will say one of the things that was difficult for me as well was the aspect of trying to go back to where I started with the no net adverse impacts. When we look at, as Ms. Gutierrez explained, when we look at mitigating adverse impacts by rule, we're not looking at the pair. We're looking at what impact it's going to have on the population. And so I think that that's another thing that we may need to look at in the future as well, because when we don't have the connection of no net adverse impacts here, presumably no net adverse impacts would mean you're talking about mitigation strategies. And if we are talking about mitigation strategies, I don't think we can base this on the specific pair, but we have to look at the populations as what's talked about in our rules. But it's not overly clear if we are supposed to look at mitigation versus some other form of looking at no net adverse impacts here. So I think that's a long-winded way of saying I think the OGDP itself is approvable. It already looks like my fellow commissioners are against the variance here, and so I think I also will look to CPW in this situation and say that I don't think that the variance is approvable at this time. And that's why I wanted to make sure that we looked at, potentially delaying future construction to see what may happen with this nest in the future, because I think in the future, this may be a very good spot to have this development. And I think that it's also a very good application overall, given the three-phase takeaway, given the electrification, given the tankless, et cetera. And so I'll leave it there.
Great. Thank you, Commissioner Cross. I can be brief as well. I tend to agree with you, Commissioner Cross, that absent the 1202C and the NSO, that this is an approvable location. And I will defer to the explanations from Commissioner Ackerman in particular, who is our wildlife expert, on how this does not meet 1202C and doesn't meet the variance criteria. Having said that, and as I said in the hearing, I do believe that if the NSO setbacks are the only method for doing the avoid part, that we've lost sight of avoid, minimize, and mitigate. And I believe that we are charged with doing that. And that's just a long way of saying I think variances are allowable to be asked for. And then we need to make a determination of whether it's met. And I think I heard from CPW Officer Moret agree with that. So I just would end there. I guess the other piece I would point out is I do believe that the OGDP was to be adjudicated based upon the HPH maps that were in place at the time, but that this whole dialogue was important and necessary because the NSO maps and the setbacks contained therein are for any new construction. And so even if we'd gotten to an approved OGDP, we would need to figure out a variance for the Form 2s that would be associated with the OGDP, because those Form 2s would trigger NSO consideration. So that's just me pointing that out for the world in terms of how at least one commissioner applies HPH maps at the time of the permit versus the NSOs for any new construction. AG Davenport, can you please visualize? Mr. Pichardo, are you visualizing just so you can hear us, or did you feel like you needed to say something?
Commissioner Chair Robbins, thank you. I wanted to, you're raising an interesting point here, and I think from what we've heard on the deliberations, there seems to be, at least from certain commissioners, support for the OGDP itself. And then I think it's been clear with respect to the variance. To the extent that the commissioners are inclined to approve the OGDP but deny the variance application, my client would agree to that outcome. And with the understanding that with the approved OGDP, approved Form 2A, there still wouldn't be approval to conduct surface operations because Rule 1202 would still apply. But that would at least enable us to kind of regroup, continue to work with CPW, relevant stakeholders, and see about coming back for the variance at a later point in time. So if the commission was to consider approving the OGDP and denying the variance, and so to speak, a split decision, we would welcome that outcome.
Okay, well, I appreciate that. Happy to recognize you. I'd like now to recognize my Attorney General, AG Davenport. AG Davenport, it seems to me that we ought to have two motions, one on the OGDP, and I don't have any real understanding of where that outcome is, and then also one on the variance. Do you, having listened to us deliberate, does that sound like a good plan?
I think that's a fine plan. Given that there are two separate docket numbers, two separate applications, that seems reasonable to me. And given the discussion that's been had, perhaps it makes sense to record the votes for each separate application.
And can I ask a second question? Then John or Commissioner Messner, I'll recognize you. Can we take the variance up first? I mean, is there any reason not to? Because that might help us with different perspectives on the OGDP.
I think it's entirely your pleasure as to which you'd like to take up first. There's no legal obligation to take one or the other up first.
I personally would like to take up the variance first. Commissioner Messner, you wanted to weigh in?
Well, hey, I think I want to ask a legal question, and this is associated with the decision on the OGDP, because as I read our rules, in particular Rule 307B, which indicates that we can approve an oil and gas development plan that complies with all the requirements of the commission rules and protects and minimizes public health, welfare, the environment, wildlife resources. If 1202C is not adhered to, then I'm not sure we can approve the OGDP. I mean, I understand where the other commissioners are at. They like all the other elements of the OGDP. I appreciate that. But if we don't approve the variance, therefore 1202C setback requirements are not adhered to, therefore it doesn't apply to Rule 3, then it doesn't adhere to Rule 307B. See what I'm saying?
Yeah, AG Davenport.
I do see what you're saying. Yes, thank you, Chair. Frankly, I'm wondering if this is better answered in executive session or offline discussions, but I'm happy to go ahead and answer the question if that's what the commission would like me to do.
Let me ask something in a different way. And again, I'm a vote in to deny the variance because I don't think 1202C has been met or whatever the 5 criteria. I also, at least I'm one commissioner, and I think that believes that a lot of work has gone into this. I don't necessarily need to approve the OGDP today, but if we deny the OGDP, then all of that work goes down the hatch and, just nothing else happens. Can we just not act on the OGDP? That's a question for you, Mr. Davenport. It might be a question for Mr. Pershala, and it's probably a question for my fellow commissioners as well. Because what that would mean is a denied variance, a non-approved OGDP, you get a sense of where the commission is, and you can chat with CPW, you can collect your marbles, you can do whatever it is you might want to do, but you don't have anything you can act upon to go start doing drilling, etc. So I throw that out as a proposal to the entire commission. Commissioner Messner?
Sorry, go ahead. Please go ahead.
I'm not trying to put you on the spot as much,
AG Davenport as I am my commissioners, because I know if you'd probably need to go into executive session, and we've got a hard stop in 8 minutes. So, Commissioner Messner, you're
No,
recognized.
I mean, I hear what you're trying to do, and I appreciate it. I think that's a realistic path forward. I think another potential path forward, and I just throw it out there, is, a condition of approval that would require adherence to Rule 1202C. So they would either have to adhere with 1202C, so the setbacks, or there would have to be CPW confirmation that the nest has been abandoned, or whatever the appropriate term for that is, right? Which I think would create that same flexibility. But I think either way works. You can stay it indefinite. Right?
Yeah. Commissioner Cross? I thought you were raising your hand.
Yeah, I'm just curious if 1202C really applies to the OGDP itself, because there you're talking about operating requirements, not OGDP, what's required to pass an OGDP in the 300 rules there. And so I think I view the two as very distinct requirements. What goes into the OGDP itself, what's required to get the Form 2A. However, once you're talking about the Form 2 and actually going in and doing the disturbance, doing the actual operations, that goes under the actual operating requirements, which would be separate from the OGDP itself. And that's the Form 2 versus the Form 2A. And that's the way I was looking at it.
Commissioner Acton?
Thanks, Mr. Chair. And I failed to mention, and should have mentioned, that there are a lot of, and other commissioners did, this is a high quality application in a lot of different ways. And so I do think that there's a pathway here, absent the Eagle issue, for some good work to be done. I find it difficult to approve the OGDP based on the fact that the pad and any possible pad would be within the buffer distance for this bald eagle nest at this time. And so it feels to me a little, I'd hate to use the word disingenuous, but to approve the OGDP knowing that there's not a possible pad location within that OGP proposal that's usable. And so I'm more reluctant to approve the OGDP, but I do think there are a lot of merits to continuing to talk about how this development may be able to take place over time.
Yeah, and Commissioner Ackerman, I segue up on that point. I'm not comfortable approving it just based upon the NSO today. I am comfortable in indefinitely continuing it. And then if it comes back to us, we'll adjudicate it on the merits that may be at the time. I mean, it might be a year from now or 2 years from now. But I would only do that if the applicant's attorneys are comfortable with that, the indefinite continuance. Otherwise, we'll just go down the path of denial.
Thank you, Chair Robbins. I tend to agree with. Let me, before I answer your ultimate question there, my interpretation, and it agrees more closely with Commissioner Cross. I think that you could approve the Form 2A. That Rule 1202 really does apply to the actual movement of dirt operations. So I think they are separate. That being said, I think you could also approve the Form 2A and add a condition of approval to it that does say that there's no ground disturbing activities allowed pursuant to this 2A until the 1202C matter is resolved. So I think you do have that option as well. If the commissioners do not see that as a viable option, I think our other preference would be to have you exercise your authority under Rule 307 B3 to stay the matter pending resolution of the 1202C issue. But our preference would be for approval of the 2A with the condition.
I understand your preference. All right, to cut to the chase, I move the variance is denied. Do we have a second?
Second.
Motion and a second. Is there further discussion on the motion? All those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? Okay, motion carries. I now move under Rule 307 that we continue indefinitely the application on the OGDP.
Second.
Motion and a second. Is there further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? That motion carries as well. Thank you. Not easy, as folks can see. And we appreciate the work on behalf of CPW, on behalf of the applicant, on behalf of staff, and I appreciate the work of my fellow commissioners on what was not an easy docket. With that, I move to adjourn the meeting.
Second.
Motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? We're adjourned. Thank you.
Thank you, commissioners, and we do really appreciate the time that you've devoted to this today. Like you said, Chair Robbins, it has been a long process, a lot of complicated issues, and we do appreciate everyone's attention to it. And hopefully we'll be back and we can discuss these matters further.
Very good. Thank you very much.
Thank you very much.